The Committee on Juvenile Justice and Family Issues will come to order. Clerk will call the roll.
Chair Dutton.
Here.
Representative Lujan.
Here.
Representative Cook.
Here.
Representative Leo Wilson. Representative Lopez.
Here.
Representative Martinez Fisher. Representative Smithy.
Here.
Representative Talarico. Representative Wu. Quorum is present.
Quorum is present, members. Thank you all for being here. I know it's that part of the time of the session where everybody's got to be in 3 or 4 or 5 different places all at the same time. So that always causes a little bit of a delay, because I think we've got 3 or 4 members on this committee who all have committees meeting at the same time. In addition to that, they've probably got their bills being heard by different committees, so they got to deal with that. So I thank you all for your patience. With that, unless there's anything else, we'll go ahead and get started. Chair at this time lays out House Bill 1734 and recognizes its author, Chairman Leach. There is a committee substitute. The chair, without objection, lays out the committee substitute and asks Chairman Leach to explain it.
All right. Thank you, Chairman Dutton, and members, good afternoon. Appreciate you allowing me the opportunity to lay out House Bill 1734. Members, this bill seeks to remedy what I believe is a longstanding injustice in our current legal system here in Texas. Currently, under Texas law, there is no legal mechanism for obtaining prenatal support before the child is born. And even after the child is born, a court is not required under Texas law to order the payment of prenatal and postnatal support. And this is even when a mother has requested this type of support and has provided evidence of those expenses. I believe that this is a glaring disparity between mothers and fathers that cannot and should not be ignored. And that's why I filed House Bill 1734. Currently, under Texas law, an argument can be made, and the reality often is that the mother is solely responsible for maternity costs and for any health care related expenses stemming from the delivery of a child. All of the prenatal expenses, prenatal support, this would include all the expenses that we're all aware of. It's expensive to have a baby, and in most cases, and under Texas law, the mother in many cases is required to bear 100% of those costs. The father is not legally obligated to contribute to these costs. With rising health care costs associated with childbirth, this disparity becomes even more pronounced. The purpose of this bill is to address this issue and to make retroactive child support to the earliest possible date of the child's conception, as determined by a physician, mandatory once paternity has been established or by the execution of a valid acknowledgement of paternity from the father. The substitute also establishes the presumption that doing so is in the best interest of the child. The substitute further makes clear for a court to order the father to pay an equitable portion of the prenatal and postnatal health care expenses of the mother and the child. The bill seeks to ensure that both parents share in the responsibility of bringing a child into this world, something that we welcome and encourage here in the state of Texas, and that mothers are not left to bear 100% of the financial burden alone. We must recognize in this state the significant financial costs associated with childbirth, as I've discussed, and provide support for Texas mothers in every way that we possibly can. I believe this bill can help us come together and support Texas mothers in word and in deed as they start their families or grow their families, as we require mothers and fathers to share in the financial responsibility of childbirth. I'm happy to answer any questions and would respectfully request the right to close, Mr. Chairman.
Thank you. Show Representative Wu present. Are there any questions of Chairman Leach? I'm not sure. Okay. This doesn't grant any rights, either directly or indirectly, to the health care provider, does it?
What do you mean?
I mean, the health care provider who provided the benefits for the delivery, would they have any rights established through this?
No, I don't believe so. They would, in many cases, if the mother is coming in, let's say, OBGYN appointments, or if there's more extensive prenatal support that's needed
Right.
at either a hospital. Most of the time, if the mother comes in, and a witness, our expert witness can correct me if I'm wrong, the mother is billed directly for those costs. Maybe her insurance company is as well.
Right.
What this would allow to happen is for the mother, who is right now is 100% responsible for those costs, to request via court order the father to share in those costs.
Right. And if she has insurance, for example, the insurance carrier would pay for part of those benefits, but this wouldn't grant any rights to the insurance company
Any out
to
of
go out against
it
the
would
father.
grant rights to the mother to seek half of out-of-pocket costs.
And that right only extends to the mother.
That is correct. Yes.
Okay, all right. And the other thing I guess I wondered is, does it pretend that all births will have a confirmation of the father, of who the biological father is? Because in order to attach that person
Sure.
for the cost of medical care, you got to confirm that that's the father.
Correct.
And we don't require that, except the court makes a finding of that sometimes in absentia.
Well, this would all be at the election of the mother. The mother could choose not to pursue this, but if she did want to pursue this, I'm thinking about, Chairman, the situation where there's a mother who has a child, father's not in the picture, and let's say worst case scenario, she incurs, well, not worst case, but definitely a very very practical scenario that happens all the time is that, let's say there's severe there's challenges, there's issues with the baby. She incurs, let's say, hundreds of thousands of dollars of medical bills.
Right.
Right now, under Texas law, there is no provision whereby even after the baby's born, she could go seek retroactive child support, knowing who the father is. Paternity is proved; it's either acknowledged or proved. There's no mechanism right now under Texas law for her to go and seek any form of child support from that father, either currently or retroactively.
Right, exactly. But I guess the only thing I was wondering, and maybe I'm just thinking this through my head, but the mother would trigger this. The mother would have to
Yes,
trigger
the
it.
mother
Okay.
has the sole right to elect
All
whether
right.
to pursue this or not.
All right, okay, I think I got it. All right, any further questions of Chairman Leach, members? Not hearing any, thank you. We'll give you the right to close. Chair calls at this time. Before I do this, let me admonish everybody to go and register at the link outside. If you plan to if you plan to testify at all, you have to do that before you testify. And when you come up to testify, please state your name, who you represent, and your position on the bill, and then you may proceed. Okay? So, having said that, we'll start the public testimony on House Bill 1734. Chair calls Robert Garza.
Good afternoon. My name is Robert Garza. I am here to testify on HB 1734.
And you're representing yourself or?
Myself,
Okay,
yes.
thank you.
For the following reasons. While this bill specifically references adjudication and voluntary acknowledgement prior to becoming valid, there should be language inserted into the bill that is mandatory and requires a DNA test confirming the father's parentage. By ensuring that the correct biological father is listed on the birth certificate, the child can also be informed of any medical issues that the child would need to prepare, including high blood pressure, heart problems, cancer, as well as ensuring that the correct person will be supporting the child. This will fix most paternity fraud cases that will exist in the future, which will in return lessen the cases in the family court as well as the criminal court. Section 1B, in ordering retroactive child support under this section, the could shall apply the child support guidelines, parental, postnatal. The assumption is that the mother already has health insurance through at least Medicaid. Receiving 20% of the father's income from conception to birth does not make sense to me. The current bill ambiguous language could easily be interpreted to cover limitless pre- and postnatal items, also equitable, and having meaning ranging from 0 to 100 should certainly not be lifted up to a court's discretion. This would also cause another hearing and expenses for both parents. Section 1C, interest section, while appreciative of the 6% delay, please think about the damage to our youth faced with life's challenges. An 18-year-old presumed father will not only have a lump sum judgment child support debt levied on him and his credit report for the next 18 years, he will also have ongoing 20% plus percent of his income taken from him while trying to support himself and his family. At very least, the lump sum debt should not have accrued interest and not appear on his credit report. Other notable issues with the bill: the order of the man language in the bill. What if a man gets custody? This bill prevents prima facie an ability of a man with custody to receive child support. What if it's a same-sex marriage? This bill does not address this. Given the ambiguous language of the prenatal lost wages, this will greatly incentivize women to quit their jobs pre-post pregnancy, which causes much larger issues. Indiana already passed this bill a few years ago. Even the lawyers admit that the law was bad and should be repealed. If you really want to fix things, in my opinion, both parents maybe could pay child support upon conception. 20% both parents pay to each other through the OAG's office. This will truly equalize the income in both homes. This is what is in the child's best interest. Maybe we put the money in a trust or till paternity is established. Maybe a 50-mile radius restriction should be added to the bill to ensure that the best interest of the child to have contact with both parents equally, just like a 50-mile radius for the expanded standard bill last session. This will incentivize to keep the nuclear family intact or at least together. You cannot have a strong nation without having strong families. Let's look at a scenario. If Texas throws a teen in jail for back child support, then we're putting his future at risk for being a high school dropout, among other things. This will be very hard for that teen to get a job with a rap sheet now. Then if he spirals, he will end up in jail or in prison and have the state of Texas paying to take care of him the rest of his life in the penal system.
Okay, thank you. Can you wrap it up for us, please?
Yeah, just one more sentence. The affected child ends up with no child support and now fatherlessness. We all know the statistics of fatherlessness and are seeing those effects with our youth today. Thank you for your time.
Thank you, Mr. Garza. Let me see if there are any questions. Many questions of Mr. Garza? Appears there's not. Thank you for being here. Chair calls Ashley Leonards. Did I say that right?
Close.
Close, okay.
Pull this up. Thank you, Chairman Dutton and members of the committee. And my name is Ashley Leonards, and I serve as a legislative associate for Texas Right to Life. And I'm here to testify in favor of House Bill 1734 by Representative Leach. This is the first session since Roe has been overturned. The legislature has a unique opportunity to show that our state is not just anti-abortion, but truly pro-life. And House Bill 1734 is a great example of this. The mother's financial responsibilities begin immediately upon finding out she is pregnant, but the fathers currently do not until the child is born. This includes healthcare expenses, of course, but it also includes other expenses that begin to be incurred upon pregnancy and preparation for the baby's arrival. Texas Right to Life supports the goal of this bill to extend retroactive child support to the earliest possible date of the child's conception as determined by a physician. We support this bill that would also order the father to pay an equitable portion of the prenatal and postnatal care expenses, both for the mother and the preborn child. This bill would also allow proceedings to begin before the birth of the child if the pregnant mother commences them, and the bill would also allow the ordering of in utero genetic testing to confirm the parenthood of the father if the pregnant mother makes this request and a physician determines that there is no danger in these requests being made to both the mother and the unborn child. This legislation highlights the preborn of the human child and is an important role, and it shows the important role of fathers in their children's lives. It also recognizes the important time frame of pregnancy for children both in the healthcare and financial responsibilities that fathers have and mothers have to their child. These common sense measures these common sense measures would continue to allow our state to build a pro-life Texas, but also provide that mothers and children are both welcome in our state and able to succeed here. We look forward to a favorable consideration of House Bill 1734, and I'm happy to answer any questions.
All right, thank you, Ms. Leonard.
Thank you.
Are there any questions, members? Not hearing any. Thank you for your testimony. Chair calls Arnold Yan.
Mr. Chairman, I'm Arnold Yang. I represent myself. I'm here to object to this bill because I believe this bill actually harms mother's right. And after the conception, before the born, its mother has exclusive right to make medical determination for the best health interest of the child. When you bring in another responsibility, financial responsibility from some other male, and we don't even know if this male is father or not, when this male owns the responsibility, actually he also supposedly owns the medical determination, the decision on this child, which will have potential conflict to determine what's the best things to do with the mother. Because sometimes during the medical treatment, mother and the child has conflict of interest when you do the medical decision. And also, according to the Texas family law, father's role was determined. Definition was not even determined after conception. Now everybody try to come here and say, hey, protect father get involved, parents get involved. They were not even defined as a father after conception by Texas family law. They just jump to the conclusion right now. Okay, they are the conception, they are the father. Let's talk about the financial responsibility. At that times, they are not even establishment of father-child relationship according to the Texas family law. Unless Texas family law changes the definition and define the establishment of the father-child relation after conception, then we can talk about the financial responsibility. At this moment, this ground is not established. I think this idea is premature, and it will eventually hurt mom's interest in the future.
All right, Mr. Yan, thank you for your testimony. Let's see if there are any questions. Not seeing any. Thank you for your testimony. Thank you for being here. Chair calls Cody Taylor.
Afternoon. Cody Taylor. I represent myself, and I object this bill. I position strongly to this for the reasons is that you're creating another statistic from the right beginning. I'm just looking at you, not because of your personal beliefs to this or anything else, but this is created solely as a business decision for mothers. This incentivizes for mothers to make a sole decision to stay single, not to bring into a father that wants to have a decision to life. There's nothing to this that gives a father at point of conception that gives the father a right to make any decisions as far as medical.
Let me say something here. We have this bill now. He doesn't have it.
I know. I'm just looking at him. He proposed it.
So you probably ought to talk to us rather than him.
I'm talking to anybody who's listening, including the ones online.
Okay, well,
So
talk
at the end of the day, though, it gives the right to the mother strictly for the enforcement to do anything. It gives her sole discretion to anything. You're talking about possibility of, and in this day and age, specifically to youth who have not remained abstinent, to use a condom, who use safe sex practices possibility, and then all of a sudden we have a youth that's having a child. Now we're starting to automatically hemorrhage what his life is going to be like for the next possible 18, 19 years with the 9 months involved into that. So to further put this into it is fathers would not have a basis at this point in this bill to be even have an opportunity to go back for retroactive child support if they were after birth and the mother doesn't decide that she wants to have the baby. Now can the father go after that? Can he go and get child support retroactive into this bill? If we had some language into that met an opportunity for it, then I could see where we would have a better opportunity for everybody.
All right, thank you. Is that the testimony? Okay, let's see if there are any questions, members.
No.
I don't think there are any questions. Thank you. Thank you for being here, Ms. Taylor. The chair calls Jeffrey Morgan.
Thank you, Chair Dutton. My name is Jeffrey Morgan. I am from Dallas, Texas. I'm representing myself. I am against this bill. I have a handout. How do I get this out?
Give it to her.
Okay. And with regard to this handout, there's a QR code. What I've been doing I've been fighting for stronger families, for the protection of families for over 2 decades, both in the United States and overseas. I've worked in missions and ministry among Iraqi refugees. Family is the essential unit of our society. And the reason I'm against this bill, there's multiple reasons I'm actually against this bill. First off, this bill benefits a single class of people, and it would be single women who are engaged in premarital sex. That's who it's actually benefiting. And I don't think that that's really what we want to be doing, is incentivizing that type of behavior. As we know, what we incentivize, we get more of. Second thing, Chairman Dutton, as you mentioned, you asked about the genetics. How do we make sure the father is the real father? I've been in courts and I've witnessed paternity fraud take place in the state of Texas. It's a very real concern. And the person who was involved with that, everybody knew he was not the father, but it was the attorney for the Office of the Attorney General who was trying to make him the father because they withdrew some money from his paycheck years back. This bill creates obligations for the father, but no rights. Basically, the father is looked at as a paycheck, as a source of income, but not as an influence to the child. And I think that if we're talking about building strong families in the state of Texas, we have to be talking about what incentivizes families. I saw nothing in there about the idea, perhaps even of suggesting marriage. That is one of the best anti-poverty prevention programs that we have, but it's not even mentioned in there. Perhaps these people should be saying, hey, we will help you if you're going to look at this. And then after that, maybe consider some of these other things. The best interest of the child, Representative Leach mentioned, nobody has ever defined that. That is a very nebulous term. My definition of the best interest of the child is the child should be reared in an intact home with his or her natural mother and father, period. We hope surrounded by strong extended family. We hope surrounded by a society that supports and values the institution of marriage. To invoke the best interest of the child for everything, I think it's very wrong. The lady in front of me testified about this is a pro-life bill. You cannot be truly pro-life if you're not pro-family. And if you look at the statistics for abortions, I believe the abortion rate or the unplanned pregnancies, you have a 7 times higher factor of that taking place where there is no family intact. So basically at the end here, like I said, I would rather see something that would incentivize marriage, incentivize strong families, not reward promiscuous behavior by either person. And, I also want to say as well that I know we sent Representative Leach's office a FOIA request to find out some information regarding his thought process. He was informing him about that. To the best of my knowledge, that was never responded to. It went to the Office of the Attorney General for his opinion on that. Finally, I want to just point out one final thing here, is that the representative, or the person who represents the Texas Family Law Foundation, the female, often calls fathers who cannot pay terrorists, as you can see by these tweets. I would hate to be seeing a very young child being called a terrorist or a deadbeat because he could not pay. So anyway, I am firmly opposed to this bill. I think that there are much better options than what we have before us right now.
All right, thank you for your testimony, Mr. Morgan. Chair recognizes Chairman Leach.
Do you mind if I just ask a couple questions?
No, go right ahead.
Thank you, Jeff, for your testimony. In response to your question about my intent for this bill, my intent for this bill is very simply to support Texas mothers, period. We have passed laws in this state over the past several years, and of course, as a result of the Dobbs decision, more and more women are going to be carrying their kids to term. That's a good thing. That is a welcome change in the state of Texas. It's something that we've worked very hard for, and I'm grateful for that. But at the end of the day, it's one thing to encourage motherhood with our laws. It's another thing to elevate motherhood with our laws. And hang on, I'm going to ask you a question.
Sure, absolutely.
So what do you say about the situation where a guy gets woman pregnant, neither of them want to get married? In fact, a situation where woman may be afraid of afraid of the man. There may be good reason for her to keep her distance from him after she got him pregnant. You can imagine all the scenarios why. Is your position that she should be responsible for 100% of the costs relating to the delivery of that child that he created?
I'm saying my position differs from yours where that you
Yes or no? Yes or no? Is she
I
responsible?
cannot answer that yes or no, as you know, Representative Leach. I am telling you this, that, there are other sources of income, and really when you look at child...
The question is very simple because I want to understand what your testimony is, because it sounds to me like your position is most definitely yes.
My testimony is...
Let me
if
finish
you're
my
going to-
question. Let me
Okay.
finish my question. Is that your testimony is most definitely yes, that woman should be legally, under the law, 100% responsible for those costs? That she has no recourse whatsoever to seek compensation from a reimbursement from the man who created that child?
My testimony is this. When this happened with my daughter, who bore the costs? I did. I bore the costs. So you have family already around. What you're trying to do...
You're making my point for me. You absolutely just made my point
No, I did
for me.
not, because you're putting something in place where there are obligations but no responsibilities. You want a paycheck instead of a parent. And I think that you should be looking at saying, okay, what about shared parenting, even from the get-go? That should be an option. You should not say, hey, I'm going to punish you, and I'm looking at this thing that, we're going to be making financial demands upon you, and I'm sorry.
I'm very grateful. You just made my point for me, Mr. Chairman. I couldn't have said it better than you just did. Thank God that your daughter had a dad who was willing to support her and cover those costs for her. I think about all the Texas women that were not as fortunate as she was and don't have fathers or friends and no resources of their own to cover the costs. And except there's this guy sitting over there that does, and right now under Texas law, she cannot ask him to pay a single cent.
And many of those cases come from already broken families or never formed families, as you know.
Mr. Chairman,
So you're going to be perpetuating a problem,
All right,
and
thank
I'm
you.
trying to say, how do we solve the problem?
All right, thank you, Mr. Morgan. Thank you for
Thank you so much. I appreciate it.
Thank you for your testimony. Chair calls take that back. Chair calls Taryn Champagne.
Good afternoon. My name is Taryn Champagne, and I represent myself and my son Finley, who's back there, and I'm opposed to this bill. This bill, as written, does nothing to ensure that the paternity of the child belongs to the man as identified by adjudication. While there are provisions made for genetic testing in the bill, they are only at the discretion of the mother. Nothing in the bill prevents some hoochie mama from naming some random person, such as Elon Musk or Representative Leach, as the father. If someone is requesting child support from a parent, DNA testing should be mandatory. The bill also is in conflict with Section 160.202 of the Family Code in that it forces an unmarried man into an obligation that married fathers do not have. While parents have a duty to support their children, married parents are given the discretion on how much they choose to spend on their child in support of them. Money spent in support is a protected form of speech, and when the state limits the father's ability to spend that money in support of speech, the state censors and diminishes his speech while enhancing the mother's discretionary speech. Child support, as calculated by the state of Texas, is not, in fact, based on the actual needs of the child, as the child's needs do not simply increase commensurately with the parent's income. Child support guidelines often exceed the minimum amount necessary to support the child's basic needs. An unskilled laborer's child has the same basic needs as a politician's child. Additional money that is spent is discretionary and a form of speech. Nowhere in this bill is outlined guidelines for prenatal and postnatal health care expenses of the mother and the child. This bill leaves that solely with the discretion of the mother. In married families, parents may have to agree on what sort of care the child and mother may actually receive. In fact, it conflicts with the public policy of the state, which is 153.001, by not encouraging the parents to share in the rights of duties of raising their child. The mother who instigates this lawsuit comes to the state without clean hands. They have chosen not to involve the father in the process of raising the child from conception. If the child support is for absent parents, which based on the OAG stats, the public policy of the state mandates absent fathers, then a request in many cases had to be made to remove or prevent that parent from being involved. That would reward such bad behavior. Before enacting this legislation, I would encourage the committee to conduct an interim study on how families in Texas are formed, determine how many children have fathers who have not been present from the outset of conception, based on the decision of either the father or the mother and their unilateral decision. The best support a parent can give is by being there for the child in all aspects, not just financially. The best thing for children and their parents is not to have the government involved in their personal affairs, whether they are married or not. I can think of no greater overreach of the government than interfering with an individual's personal lives when no crime has been committed. My son's mother and I enjoy a healthy co-parenting relationship, and that only occurred when we had kicked the state of Texas out of our lives. I welcome and encourage any questions at this point.
All right, thank you. Mr. Champagne, let me see if there are any questions. I think Representative Cook has a question.
Are you suggesting that Mr. Leach's bill orders child support without determining parentage?
Based on my understanding, it said it can be either by adjudication or a DNA test at the mother's discretion, but it's not mandatory. So you can name somebody, but there's not a requirement.
Do you have the copy of the bill in front of you?
I do not, sir.
I would encourage you just to look at simply at the title. On line 7, 154.0091 says retroactive child support on adjudication or acknowledgement of paternity. So that means that you're not going to have child support ordered until there's been
Excuse me.
no problem. Until there's been a decision on paternity. And once you have paternity, then you're going to have rights and duties, and you're going to have periods of possession, you're going to have conservatorship, and you have rights and duties. And so I think the speaker before you said there's no rights set forth in the bill, but of course there are lots of rights set forth in the Texas Family Code that would be applicable. So just because they're not stated in this bill, I just want to make sure that it's not your understanding that this bill attempts to order someone to pay child support without giving them any rights or responsibilities.
So my actual concern, right, so you brought up the adjudication part. So I've seen cases of paternity fraud, and that's where my concern is, right, where even there's DNA tests to prove that a man is not the father of the child, where the state will continue to pursue that individual for child support cases. I encourage you to look into the Gabriel Cornejo case, which was quite a prominent case a couple years back, where an individual, there was DNA testing available, but by adjudication they determined he was the father of the child. So that's my concern right there.
Okay, well, that's not what you said. That's not what you testified to. But I just want to make sure that the public's understanding is that Mr. Leach is not trying to establish retroactive child support without establishing parentage, which goes along with rights and duties and periods of possession. So, thank you.
All right. Any further questions of Mr. Champagne, members? Not hearing any. Thank you, Mr. Champagne, for your
Thank you very much, sir.
Chair calls Carlos Damon.
Just click right there. I bookmarked it.
Good afternoon. So I'm just going to talk to you like a man today. I say I'm not in favor of this bill because I call bullcrap.
You have to give us your name.
Oh, my, sorry.
Who you represent.
Carlos the man, yeah. I'm just here presenting myself.
Okay. And your name is?
Carlos.
Okay. And you're for or against the bill?
I'm against the bill.
Okay.
Period.
Please proceed.
Yeah, because I like I said, I call bullcrap. This gentleman, whoever introduced the bill said that the women were responsible for 100% of the costs, and that's show me the data, right? I would want to see the data on that. It's like me just claiming something without bringing you evidence of it. Doesn't make sense. And because I know there's Medicaid, there's TANF, there's all kinds of resources available for the women. I've seen it happen, lots of times. So, but I mean, I'm just going to talk to you like normal people. We've all struggled in life, right? Mr. Dutton, if your parents had any kind of help from the government, would it make you a stronger man, or did it define you who you are today? And that's what I'm asking.
We get to ask the questions, you get to answer.
Okay, well.
Okay.
Well, it's, I didn't grow up with a silver spoon in my mouth, and it's made me who I am today. Because, my parents didn't have all those benefits and, income coming in. They just said, work hard, and at the end of the day, it comes to you by your hard work. So if these two individuals wanted to get pregnant, maybe they should have made a contract. Let's see if the contract gets, if that lady says, hey, you know what, if you get me pregnant, you're going to be responsible for this baby from day one, and everything else that comes along with it. Let's see if the contract now would be something that would be for everybody. In fact, the entire United States. That way we could eliminate all these bills, rules, laws, and regulations to just, you know what? Let's start from the very beginning. That way we don't go down this road. So I think it'd be a lot easier just to say, just no, I don't want to. I don't want to get you pregnant. Not if we're going to go through all that hoops. I mean, I don't know about all these. You know, anybody else would. I certainly wouldn't. But I was thrown into it, and it sucks. Perfect timing.
All right, thank you. Thank you,
Questions?
Mr. Damon. Any questions from this witness, members? Not hearing any. Thank you very much for your testimony.
Thank you, Mr. Lynn.
Chair calls Stuart McMullen. Here's Stuart.
Patterson is the same bill like Leach, but it's slightly different. And he has the same witnesses. Let's have him go. So you can just say if anyone's not going to have anything different to say, don't go.
Hi, my name is Stuart McMullen, representing myself. I'm testifying on the bill. And I combined two bills into one testimony because Representative Patterson has a similar one. But respect both Representative Leach and Patterson, and we agree on just about everything politically speaking. And I understand the intent of these bills, and I agree with the concept that life begins at conception. I also believe that both parents should be financially responsible for their children, and there's no argument from me on those points. However, I do have some suggestions and concerns regarding this bill. My main concern is that there does not seem to be much protection for fathers. For example, these bills would give mothers an open checkbook to unilaterally spend without limits on prenatal and postnatal expenses with no input from the father. If paternity is not established immediately, this will put the father in the hole financially, and he would start off with possibly huge arrearages. Shouldn't there be some limit on the amount that is to be reimbursed for discretionary prenatal and postnatal expenses? Or maybe there should be a list of expenses that are reimbursable. Second thing is these bills do not protect or guarantee the father's ability, desire, or willingness to have equal or nearly equal periods of possession and access to the child after the child is born. These bills only mandate a financial obligation for the father, a monthly paycheck. Not all fathers are bad, so please stop lumping us all into the same category. Children need a healthy bond with both parents. In order for that bond to be strong and healthy with the father, there needs to be language that safeguards the child's relationship with their father. Third thing is, as this bill is written, these bills automatically assume that the father is a possessory conservator at best, which is very degrading, and it instantly reduces him to a visitor to his own child if he gets any possession at all. These bills should mandate equal custody, as it is in the best interest of the child if both parents are fit, willing, and able. In addition, these bills should also protect the father and mandate that the father have the right of first refusal for full custody should the mother not want to care for the child or wants to put the child up for adoption. In closing, if you're going to pass these bills, they should be amended to put a cap on the discretionary prenatal and postnatal expenses, ensure that the children have a meaningful relationship with their fathers by mandating equal possessions, equal periods of possession, and protect fathers' rights to take full custody of the child should the mother want to put the child up for adoption. With these changes, the father will be able to be a fully active participant in the upbringing, care, custody, and control of their own child. Thank you for your time and your service to our state.
All right, thank you, Mr. McMullen, for your testimony. Are there any questions, members? Not hearing any. Thank you again. Chair calls Anton Golokob, I believe it is. Anton Golokob. Anton Golokob, please. All right. The chair will show Anton as not having testified, but neutral on House Bill 1734. Chair calls Brandon Johnson. Brandon Johnson.
for me to begin. Thank you, Chairman Dutton. My name is Brandon Johnson. I'm against the bill. I logged in all the, in the back that it was just on the bill.
Wait just a minute. Hold on just a minute. We have you registered as being neutral on the bill.
And you can leave it that way if you'd like, but I've
I
looked at it.
we just want to reflect
Okay.
what you want.
Well,
That
I
is-
would like to change that to being against the bill.
Okay, is it okay if we change it in our system?
Yes, sir.
Okay, we have your permission to do that. Thank you, we'll do that.
And we live in an era now where single mothers are glorified. And I understand the intent of the bill wanting to acknowledge life from conception, but there's not a whole lot given toward what happens to these kids after the fact, after they're born. And so nobody's speaking out against it. This bill's a golden parachute for these mothers without ever mentioning the father's right to the child other than his paycheck. You know, the bill asks for equal financial resources without equal access. Responsibility without authority is slavery. So what if, these women, they like all the, what I call the cash prizes and custody that come from being a single mom. And I'm not against women, but I'm just stating a fact. So what if all she was looking for was a sperm donor without the expense of going to an in vitro clinic or a sperm bank? Where's the woman's responsibility mentioned about caring for the child in the womb? You want the child born, but what if she's on drugs? And then it creates permanent, life-changing, brain damage. I mean, it could a lot of things could happen. She could be drinking alcohol. I don't know what all could happen, but while she's in the womb, she's got to take care of herself. Where's that mentioned? And then you mentioned abusive men. Look, if the man's abusive, why is he not criminally charged? In all of these contested family law cases, abuse is alleged. So I would reference something ought to be kind of combined with House Bill 1087, Hull's bill, which says there has to be a verified complaint or verified allegations. It's just not right that we've elevated women to the point where they can just say whatever they want and get what they want. Thank you, Doug.
All right, thank you. Are there any questions of Mr. Johnson, members? Not hearing any. Thank you, Mr. Johnson, for your testimony. Chair calls David Green.
Thank you, Chairman Dunn. My name is David Green, and I am against this bill. This bill orders the retroactive child support back to the time of conception as provided by Section 154.0091, which is the child support section of the Family Code. But this bill does not make any updates to that code. So, however, the child support section of the Family Code was not built or designed or developed to cover the expenses of an unborn child. It was developed for expenses like diapers, cribs, childcare. So if this bill passes, judges will have to order support amounts that in no way correspond to the expense of actually carrying a child. Additionally, what counts as child support by the father for an unborn child? In the current law and in cases, the father can often show they bought these types of items for their child and are able to reduce the retroactive child support. I can't imagine a scenario where a father is going to be able to prove that the groceries that he bought went to the child's mother. If the real goal is to encourage the birth of children, there are better ways to do that. And I understand the prenatal and postnatal care that is fine with me, but this bill goes beyond that. This bill orders the standard child support guidelines, which would start at least 20% of net resources. Thank you.
All right, thank you. Mr. Green, any questions of Mr. Green, members? I think Representative Cook has a question.
I share the same concern that you just raised, but I think it may be even more than that. I mean, because it says and. It says the court shall apply the child support guidelines provided by this chapter and on a proper showing order the man to pay an equitable portion of all the prenatal and postnatal health care expenses of the mother and child.
Oh yeah, it's double. It's a lot. I mean, in my scenario, that'd be 15,000 for those, or it could be 15,000 for that 9 months plus, however much that out-of-pocket expenses.
Yeah, I mean, because to me, it's if the guideline amount says when a child is born that it's 20% for one child, and and the child doesn't have daycare expenses and food and shelter and all those types of expenses. So I will visit with Chairman Leach and see what his intent is. But I think the way the bill is drafted, it would not only have the court setting guideline child support at 20%, plus, it would also be setting forth prenatal and postnatal expenses for the mother and the child. So that seems like this bill would provide for more child support than if the child was born. Is that your understanding?
Yeah, that is my understanding of the bill.
Thank you.
All right, any further questions of Mr. Green, members? Not hearing any. Thank you, Mr. Green. Chair calls Dr. Joe Pullman.
Mr. Chairman, members, my name is Dr. Joe Poyman. I'm Executive Director of Texas Alliance for Life. We strongly support this bill, House Bill 1734, and we thank Chair Leach for authoring it. It has been the policy of this state to recognize the personhood of the unborn child for decades. Since 2003, if a pregnant woman is assaulted and the unborn child dies as a result of that assault, as a result of that offense, it's recognized as a crime of homicide of the unborn child. That protection for the unborn child begins at the child's conception. This bill would protect the mother and the unborn child with respect to paternity, especially the cost of pregnancy and childbirth. It would begin to correct the injustice that has existed for decades, and that's why we support it.
All right, thank you, Doctor. Let me ask you a question, though. If, and I think one of the witnesses alluded to this earlier, if the mother engages in certain behavior that results in the cost of medical care for some reason being different than it would have been ordinarily, does that factor into this, or should that factor into it?
I'm not really sure, but I think there's a discretion of the court to award the costs. So presumably the judge could take that into account.
Well, then that raises a question, too. Maybe I'll ask Chairman Leach, but, I mean, does this become sort of an increased cost? Because now one expert, I assume, is going to talk about the medical cost, and the other side's going to have an expert to take a look at that and determine whether, and of course, I see it says reasonable, but I don't know if that means it's going to be reasonable and necessary. And whether or not you're going to now have the battle of the experts trying to decide, first of all, when conception exists. Secondly, whether or not the medical care that was provided was in total necessary.
That's a very good question. I think the bill does address the question of conception, and it's the earliest possible time of conception, because you have to define that someplace. You're not necessarily sure exactly when that happens.
Right.
With regard to the other costs, again, maybe Mr. Chairman Leach could answer that. I confess I'm not sure what his intent is.
All right, okay. All right, thanks. Any other questions, members? All right. Yeah. Chair at this time calls Steve Breslin.
Thank you, Mr. Chairman. I'm Steve Breslin. I'm here on my own behalf It's a rarity here. Sometimes I get asked to talk about things where I don't have a client I'm representing. It's unusual for me to testify on something on my own behalf, but just because I register with the Ethics Commission doesn't mean I don't have the same rights as any other American. I appreciate you very much for bringing this bill, which I fully support. And in particular, I want to emphasize the prenatal and postnatal health care cost. Mr. Chairman, was there a substitute laid out, or am I on the bill as filed?
There is a substitute laid out.
Okay, I'm going to refer to the substitute. I think the answer, and I'm going to make a suggestion to Chairman Leach and the committee. In the substitute, on line, as I've printed it out, line 132, it's in subsection H of the bill. It calls for an equitable portion of prenatal and postnatal expenses. This is not an open checkbook for anybody. And certainly, a woman's conduct before or during pregnancy that might have affected those costs could certainly be included in the calculation of what was equitable. If her insurance covered the cost, that could figure into whether it was equitable. Or if somebody else, if her family paid the cost, the court could figure that. The court could even figure, determine equity. She may be a moneyed person who could afford those things, and the man may not be able to afford anything, or may be able to afford less. I started using the term carrying costs for this, that the woman experiences the carrying costs. This has gone on since the beginning of time with no a foolproof way to get compensation. So while I was sitting there, I looked up the term carrying cost because I knew it from business when I was in retailing. And it's the amount that a business spends on holding inventory over a period of time. I don't want to refer to children as inventory, but these are expenses incurred by a woman in the time she's holding the child and then shortly after giving birth. My suggestion, Mr. Chairman, there's an ambiguity in my opinion, in the substitute. In the new subsection G that's in section 2, it says the court shall, on request of a party and a proper showing, order retroactive support as in 151, 131. And when you go back to that, it says may award an equitable portion of prenatal and postnatal health care expenses. I think that should be cleared up, and it should be mandatory. If anything should be mandatory, a woman's carrying costs for that pregnancy ought to be able to be reimbursed on an equitable basis. We don't agree on a lot of things. If you follow my Twitter, I don't like where we are after Dobbs. I don't think you'll doubt that in any way. But we can damn sure agree that if women are going to be having kids forced to term by state policy, then by God, they ought to be reimbursed for their prenatal and postnatal health care expenses related to that on an equitable basis.
Let me ask you a question, though, Steve.
Yes, sir.
You talked about the woman incurring the cost. You know, we have a philosophy in the law that requires it not to only be incurred but paid.
Yes, sir.
And does that apply? Should that apply here also?
I think that if the short answer is, if you drag me into a paid or incurred and make me put my trial lawyer representative hat on, I'm going to be very unhappy about that. So, but let me answer you this way. Equity has been established for centuries in the law of this country and the country it came from. So courts can do equity by considering all of these considerations. They're thoughtful considerations that y'all have brought up, very thoughtful. But the word equity can do a lot, and that's why that line and that word is so important. But direct the courts to do equity. Don't just leave it up to them to do it or not do it, please.
Okay. All right. Any questions? I think Representative Cook has a question.
Under current law, do you think a state district judge has the authority to order prenatal expenses?
There's a
under-
May in 154, 131 currently.
Thank you.
Okay. Any further questions, members? All right. Steve, thank you for being
Thank you
here.
very
Thank you
much.
for your testimony. And we have a resource witness here, Joel Rogers. Anybody want to have a question of Joel, members? I think Representative Cook has a question.
I'm Joel Rogers. I'm Associate Deputy Attorney General for Child Support Legal Services, and I'm here as a resource witness on the bill.
All right. Chair recognizes Representative Cook.
Thank you, Mr. Chairman. So have you had a chance to review the sub?
Yes.
Okay. And I have not, so I want to start there. So have not. So under the sub, do you believe the court has the ability, or actually the mandate, to order child support under guideline support plus pre and postnatal expenses?
The substitute continues the current language for pre and postnatal expenses. Reasonable, may order reasonable and necessary health care expense, whatever the current version of it says. So you can ask the question again. I'm sorry, I may have misunderstood what you're asking.
Let me just pull it up real quick. Yeah, so under the original bill, and so like I said, may have changed, but at line 14 it says on page 1, it says the court shall order the man to pay retroactive child support for the child beginning on the earliest possible date of the child's conception as determined by physician. And if you go down, in ordering retroactive child support under this section, the court shall apply the child support guidelines. The Attorney General's office is responsible for setting forth the guidelines, correct?
Yeah, we set child support according to the guidelines.
But I mean, you update it on a regular basis, correct?
We update the upper limit of the child support guidelines, the cap, but we issue a report to the legislature every 4 years on the adequacy of the child support guidelines.
Okay. And so what I'm asking, I mean, you're here representing the Attorney General's office, who is responsible for child support collections probably for, what, 80 or 90% of all cases. Is that?
I'm not sure it's that high, but it's certainly the lower income cases. We get probably a majority of those.
I guess in other conversations I've had with you, you've indicated to me that y'all have the lion's share of child support accounts. But
right, we have a large percentage of it, I would say.
So as the agency that's responsible for that, how would you interpret this provision beginning at line 17 of the original bill? Like I said, it may have changed, but as it states right now, it says, in ordering retroactive child support under this section, the court shall apply the child support guidelines provided by this chapter, which is 154,
right, and
on a proper showing, order the man to pay an equitable portion of all of the prenatal and postnatal. A minute ago, you said it says may, but, and again, maybe the substitute does.
The substitute actually does change it to a may.
Good. And so is it your testimony that a mother is going to incur more expenses prior to the child being born than she's going to incur once the child is born?
I wouldn't say that, no.
Right.
I mean,
nor
this would
would
be
I.
an addition. The pre and postnatal expenses has been in the law for as long as I've been doing child support. This is just in addition to that. It's basically setting guideline child support during period of conception. Plus, you could also, as you can now.
So let's talk about pre and postnatal expenses. Prenatal expenses would be doctors. You know, mom goes to doctor, incurs a medical bill. That's a prenatal expense. Right. All right. So are you saying that you should be collecting child support at 20% of a person's net resources plus prenatal expenses? That's what you believe?
I'm saying that's what the bill does. It does say that.
And do you
I'm
believe?
not saying whether it should or shouldn't say that.
Okay. Well, in looking at expenses, I mean, obviously the Attorney General's office, receives all the income for everyone and often looks at expenses as well. I mean, would you agree with me that a mother would incur more expenses once a child is born as opposed to prior to being born?
I would probably say that that's probably a true statement.
Probably? Have you paid child care expenses lately?
No, I haven't. I don't have any.
I bet it's about $250 a week for a newborn on a good day. So that's about $1,000 a month. And so I want to make sure that the intent is not to charge someone more than what we charge today for a child that's already born.
Well, today you can get postnatal expenses plus the retroactive child support post birth.
No. You can't do that today. You
Postnatal?
can't. What? I mean, you can order child support once the child is born, but you can't order child support prior. That's what the purpose.
No, you can't do it now. But once the child is born and you're getting a retroactive support judgment, you can get retroactive child support from the date of birth, plus postnatal expenses as well.
Right, and which
Equitable
is
portion of that.
Which a lot of the comments we've had today, I believe, are not really relevant to this discussion because under existing law, you can already do a lot of what this bill does. Not everything that the
That's
bill does.
correct.
But it just seems to me, would you agree with me that based on the current language, a person would be ordered to pay more child support for a child that's not born than a child that is born?
Well, they wouldn't pay more in terms of the amount. It'd still be based on the guideline amount.
Okay.
But it would be an additional period where child support is not currently, retroactive child support can't currently be ordered until the child's born.
All right. What's the norm for out-of-pocket medical expenses? 50-50, correct?
It's generally 50-50. In a lot of the cases that my agency covers, the mother's on Medicaid. So
But the orders generally say 50-50 for each parent, correct?
Once you establish an order, typically the order orders both parents to share 50-50 in unreimbursed medical expenses.
Right. And so what this bill says is that order the man to pay an equitable portion of all the prenatal and postnatal health care expenses. And so my point is that if you're paying guideline child support, which is 20% for if it's the first child, is this bill would be requiring the father in this particular instance to pay 20% plus prenatal expenses. Is that your interpretation?
That's my interpretation.
All right. Thank you.
Can I say one other thing?
Sure.
The committee substitute, actually, our agency did attach a fiscal note to the filed version of the bill. The committee substitute would remove the fiscal note to the bill because it was based upon the unique interest statute that this bill created, which was taken out. And so retroactive judgments, all retroactive judgments will have the same interest accrual rules.
Yeah. Let me ask you a couple of questions. The bill says the earliest possible date of the child's conception as determined by. Does that mean what I think it means? Because it says by either a physician or by a preponderance of the evidence presented to the court, including the testimony of a parent of the child. I'm just trying to figure out.
The substitute?
Yes.
That we recommended that language because in cases that the 4D agency handles, it'd be very unlikely that the parties are going to have a physician available to testify or be able to. We were just concerned that this would never be applied in Title 40 cases because the folks in our cases are pretty much 90% of the cases that we establish, our agency new obligations, both parties are pro se. And so there's not lots of lawyers involved to get this, the information. Generally, courts in the past can use testimony to determine. We have these paternity wheels that we use sometimes to figure out what, if the child was born, this would have been the normal period of conception. So I think judges can determine that in some respects. My concern is that this was going to leave a lot of the lower income folks who are pro se, they would not have the information necessary to do that. So we were trying to allow the court some discretion in how to determine that.
Yeah, but it seems like the same fence that you're building to protect them kind of imprisons the guy too.
Well, I would be fine, our agency would be fine if they put it as a physician as well. We were just trying to make sure
Well,
that,
if you
that this was able, that the folks that we deal with
Yes.
would be able
I
to
understand.
try to utilize
understand
this
that.
if they requested.
I'm just curious about how, if you took that out and it said a physician, what would you do in that case?
They would probably either have to have a physician's testimony or an affidavit from their doctor that they could get. Now,
So you assume then that under that language, you could use a doctor's affidavit as a determination of the earliest possible conception date.
I think the court would accept that if there wasn't an objection to it.
And if there is an objection, which almost, I can just foresee that there would always be an objection, then what happens?
And then it'd be up to the court whether to admit the affidavit. In our cases, like I said, 90% of the folks are pro se. They don't.
Right, I
There's not a
understand
lot of objections that are
Yeah.
done by pro se folks in our caseloads.
But I think for us, we gotta kind of ensure that the landing strip is there and we know what's gonna take off. And what worries me is that if you take out the section allowing a parent to do it, you're gonna have to have a doctor show up to testify.
That was our concern, and that's why we added we recommended the additional language for the committee substitute to give the court more discretion on how to establish what the earliest conception date would be.
Okay, and then secondly, I guess the question I had is when, again, back to my question I think I asked Mr. President about incurred versus paid medical expenses and whether or not those expenses had to be reasonable and necessary. Because the bill says reasonable, it uses the word reasonable and here related to the determination of when conception exists. But I wonder about the medical expenses themselves, and does the mother just get up on the stand and say, this is what I paid, and that's the evidence that's required?
Well, I'm probably not the best person to ask because we don't have a lot of, we don't do a lot of that in 4D cases because like I said, the mothers in our caseloads are typically lower income, so they're on Medicaid. So there's not a lot of out-of-pocket medical expenses. I would assume that you would have to have some proof for bills or things like that. I don't know that under current law you have to show that those expenses have been paid. You just have to show that they've been incurred.
Oh, you don't have to show that they've been paid?
I don't. The way the current law is written, it says reasonable prenatal, postnatal health care expenses. I don't believe there's anything in there that says that the expenses have to have been paid.
Okay, we might.
It's not my practice. It's not my practice.
Okay.
I think you are the best person, Mr. Chairman, and since you suggested the language, who better?
Yeah, we'll figure that out. Okay, any other questions, members of Mr. Oh, I think Ms. Lopez has a question.
Thank you, Chairman. A lot of the testimonies that were given today were men against the bill. And I wanted to know, do you have any statistics or any data to let us know what percentage of women ask for child support or are receiving child support compared to men?
I don't have exact statistics. In fact, I anticipated that question. I was trying to find that in our caseload. I can only speak to it's in the Title 40 caseload. I would say anecdotally that it's mostly the customers, that we call them customers, both the custodial and non-custodial parents. But the cases that we get are either referrals because the mother's on Medicaid, or the mother and the child are on Medicaid, or that they've come to us and opened a case with us. And I would say a very high percentage of the cases we get, the women are the ones seeking the establishment of this support order.
If you had to take a guess, I know it's not an exact number, but if you had to take a guess, what percentage would it be of women that need these services?
In our caseload, it would be over 90%.
Over
That would
90%.
be my guess.
Okay, all right, thank you.
All right, I think Representative Cook has a question.
Under current law, are you able to finalize a divorce without a child being born?
A divorce, I think the child has to be born before that it can be finalized.
And you know,
that's taken out, the committee substitute takes out that language.
so do you know why that would?
It takes out the language allowing the proceedings prior to birth.
So do you know why they would do that?
Why they would?
Why they would wait? Why would a court want to wait? Why would the state of Texas want to wait until the child was born?
Oh, well, I mean, you need things in the order like the name and date of birth of the child, things that are required to be in the order.
Or you need a paternity test if there's.
Yeah, the bill, I'm not sure that the original filed version of this bill did talk about in utero testing. That is not in the committee substitute. Obviously, if you want a genetic test under the committee substitute, you would have to wait until the child was born.
Right, so that's I'm really surprised that the Attorney General's office would suggest language that we're just going to base it on what a parent says. You know, I haven't had sex with any other man, I've not had any sex with any other, person. That's what, when you say the earliest possible date of the child's conception, including the testimony of a parent of the child, we rely on DNA for paternity testing, correct?
Right. This is all part of a SAP, a suit affecting parent-child relationship. So the retroactive child support couldn't be ordered until the court, if the person wants a genetic test, those would be conducted first. And then if the person is the father, they would be subject to orders for retroactive child support.
So you don't see the suits in 1734 going forward until after a child was born?
Yeah, well, in our caseload, the committee substitute removes the language in the filed bill that talks about proceedings before birth.
Then why would you still need a physician using standard medical practice? I mean,
well, that was in the original version of the bill, and then we wanted to expand it to allow that there be other forms of testimonial proof or other evidence that could help the court to establish what that time period would be.
Okay, thank you.
All right. Any further questions of Mr. Rogers, members? Not hearing any. Thank you, Mr. Rogers. Thank you for being here. Is there anyone else here who would like to testify for, on, or against House Bill 1734? What's your name, sir? Oh. Is there anyone else who would like to testify on, for, or against House Bill 1734? Chair hears none. Chair recognizes Representative Leach to close.
Thank you, Mr. Chair. I'm happy to take any questions. If there are none, then I close.
Okay. All right. Thank you.
All right.
The chair, without objection, withdraws the committee substitute for House Bill 1734 and leaves House Bill 1734 without objection as a matter of pending business before the full committee. Okay. The chair is going to lay out House Bill 532 by Patterson et al. It is a bill that is very similar, to 1734, which we just heard. And so what we're going to do is let Representative Patterson lay out his bill. We will transfer all of the comments that were done on House Bill 1734 to House Bill 532, unless there's objection. Without objection, chair hears none, we'll do it. Chair recognizes Representative Patterson.
Thank you, Mr. Chairman. Thank you for the time, and thank you for running such a concise committee hearing. My staff wrote a great long explanation here, but you've heard a lot about this topic. What I do want to mention are really two things. Number one, Chairman Leach is a mentor of mine and a great member of this body, and I greatly appreciate his leadership on this issue. There is a slight difference between the filed bill that I filed with his, and that does include the in utero testing to hopefully get this process through the court system, if it needs to go that far, more quickly, so that these moms can get the resources that they need more quickly. Other than that, we will have a committee substitute that we didn't get to you in time today, but it's just some clarifications from the AG's office about how this would work logistically. We will get that to you before you take any action, should you do so.
All right.
With that, I'd be happy to take any questions.
Thank you. Any questions of Representative Patterson, members? Not hearing any. Thank you for bringing this bill, and we'll wait on the committee substitute before we do anything.
Yes, sir.
Okay?
Mr. Chairman, do I close now, or are you going to take other?
No,
transfer?
we're gonna just transfer all the testimony on 1734 to your bill.
Yes, sir.
As well, and we did that without objection, so it's done. So.
Yes, sir.
You're closed.
Thank you, sir.
All right.
Thank you.
All right. All right. Thanks, Representative Patterson. The chair leaves House Bill 532 pending before the full committee without objection. Chair has none, and so ordered. Do what?
Representative Mesa's House Bill 811.
Which one is it? Chair at this time lays out House Bill 811 and recognizes the Honorable Representative Mesa to lay it out. There is a committee substitute. The chair at this time lays out without objection the committee substitute, the House Bill 811, and ask Representative Mesa to explain it.
Thank you, Chairman. Co-Chair Smithy and other committee members. Are you the co-chair?
No, I'm just here.
You're the co-chair. I need to look over this way. Co-Chairman Lujan, excuse me.
We're all co-chairs.
And other committee members. This bill, Bill CS-HB 811, seeks to address the unintended consequences that come from medical professionals reporting expectant mothers with a substance use disorder for child abuse. This bill may sound familiar to you. It passed the House last session. In last session, I worked with colleagues on both sides of the aisle and the other side of the aisle to add accountability measures. This bill maintains those changes. So I had met with people from don't know what my colleagues call it, but it would be our equivalent of a strategy policy committee meeting. So, and they had asked to see some language in the bill that showed accountability, and so that was added in last session when it passed, and this bill maintains those changes. So what this bill is about substance misuse during pregnancy. It's a significant public health concern. We should be concerned about it. It can result in adverse health outcomes for both the mother and the child. So what happens now is that reporting expectant women for child abuse due to substance misuse can have some unintended consequences that ultimately harm both the mother and the child. We put a mother, expectant mother, who has a substance abuse problem in kind of a no-win situation, that she can either let people know that she has a substance abuse problem and is seeking help about it when she has understanding that she's expecting a child and she wants the child to be born healthy. She needs to do something about her substance abuse problem, and so she takes some action, but then she gets red flagged for that, so that when the child is born, that the CPS can remove the child from her custody. The other option is that the expectant mom who knows she has a substance abuse problem but is afraid that if she reports it, she'll lose her child, and so she doesn't seek help with her substance abuse problem. So neither one of those are very good options. So the legal consequences make it more difficult for a mother to access care and the support she needs, and it creates a culture of fear that discourages women from seeking help for their substance abuse disorder. Instead of reporting expectant moms for child abuse, what are we suggesting? We're suggesting that medical professionals should focus on connecting them with substance treatment programs that provide comprehensive care and support that will address both the addiction and any other health concerns. So that would lead to a better outcome for both the mother and the child, as well as a reduction in substance misuse rates among expecting mothers. So House Bill 811 aims to put a balance there between the need to protect children from abuse and neglect, while also recognizing the unique circumstances faced by expecting moms struggling with substance abuse. So this bill allows medical professionals not to report a woman for child abuse if she makes a reasonable effort to enroll in a treatment program. The exemptions provided in the legislation incentivize expecting moms to seek medical care and substance abuse treatment without fear of legal consequences, thus improving health outcomes for both the mother and the child. So this committee substitute for this bill adds an and, the word and. It's a little word, but they can be very important, right? On page 1, line 18, to allow reporting if there is an immediate risk of harm to the child, which is a necessary addition to the legislation, I think you'll agree. It ensures that medical professionals can report cases where a child's endangered, and while still protecting expected individuals from unnecessary legal consequences. So thank you for your consideration of this bill. The Texas Public Policy calls this bill a safe harbor bill, and I think that's a good name for it, the safe harbor bill.
All right.
So thank you for consideration. Reserve the right to close.
All right. Any questions of Representative Mesa, members? Not hearing any. Thank you. We'll give you the right to close.
Thank you, Chairman.
The chair at this time starts the public testimony on House Bill 811. The chair calls Arnold Gann, testifying neutral on House Bill 811 for himself. You can just give it to him. Mm-hmm. You may proceed, sir.
Mr. Chairman, and this bill is about to report the...
Hold on, you got to give us your name, who you represent, and your position on the bill.
Mr. Chairman, I'm Arnold Yen. I represent myself. This bill is about the
And
reporting...
you're neutral on the bill.
I'm neutral on the bill.
Okay, thank you.
And this bill, the subject is about reporting those conduct things to the authority. I want coming here because when you talk about report, you always talk about there's always something involved. You talk about aggravated perjury in the court. So I'm coming here. The neutral is I want to emphasize something. I object to all the bills this committee intend to vote on, particularly those related to the criminal charge, because our Texas government executive branch has found a loophole to bypass the power of the legislative branch. Everything you are discussing here is just a facade if the legislative branch fail to pay attention on how the executive branch operates the law in Texas. I have an official response letter here from the DA, from the Sheriff Department. It states that criminal DA office will only open or investigate criminal complaint only if it's under the request of the legislative branch. So if you pass the bill, you have to report that. Otherwise, they don't prosecute it. You own it. If the request is not made, the DA office, which is the state agency and part of the executive branch, will not prosecute criminal charge. I questioned this policy with the state AG office, and the clarification I received is that this policy is called prosecutorial discretion. However, when they call that discretion, I call that dictatorship. In the Federalist paper on page 47, the author James Madison has recognized that the tyranny is the accumulation of excessive authority in single branch. He said, concentration of the power is tyranny. The DA office did exactly by transferring their prosecutorial power to a different branch, stripping off the indictment power of the grand jury and the conviction power of the jury. I did not consent to DA office have the prosecutorial power to set up a policy that breaks the fundamental principle of the Constitution, Article 1, the separation of the powers. Therefore, I have filed a facial constitutional challenge against both of them in the federal court right now. I'm a first-generation immigrant who grew up in communist China. In the last century, the U.S. has always, like a lighthouse, showed the path to liberty for people living under the Iron Curtain. I lived through the great cultural revolution, and I know what the tyranny smells, tastes, and looks like. It's regrettable that the United States has reached a point where a Chinese immigrant must fight for constitutional right against the government. However, I'm committed to this fight. I do this for the power of America and for all of those who value the Constitution in the last 200 years. Politicians have come and gone, but the Constitution stays forever. Mr. Chairman and the committee, if you do not fix the separation of power violation, your bill will be meaningless. Every Texas law is moot.
All right, thank you, Mr. Yan.
Do you have any questions?
Have you seen the committee substitute for the bill?
Yes.
You have seen it?
It talk about the reporting things, and there's a lot of bills going to passing today. A lot of it was talking about, fight a criminal charge over certain behavior. I'm just trying to tell you right now, we government branch has a policy, they don't prosecute perjury. So all the law you try to pass has no meaning. They said if any criminal complaint against the perjury have to be filed only under the request of legislative branch. Right. If that's the case, there's no law. Perjury is the foundation of the justice. If they allow perjury to happen, whatever the law it apply, there's no justice. Because they can use discretion to determine which side they're going to lean on. They allow perjury, there's no balance. The outcome is guaranteed by who decide where perjury can happen.
All right, thank you very much. Are there any questions for
I got
Mr. Yan?
I attached that. You can see that.
Any other?
Words is
Hold on. Any other questions for Mr. Yan, members? Not hearing any. Thank you, Mr. Yan. Thank you.
Do you have any?
We don't have any questions. Thank you. Chair calls Jeffrey Morgan.
Should I just?
Just give him the.
Thank you. I appreciate it. Thank you so much. My name is Jeffrey Morgan. I am testifying on the bill at this point. I'm speaking for myself. And the positives that I see in this bill is that there are I would hope that there'd be some consistent standards that start to be developed regarding CPS. I've seen children that have had or parents that have had their children taken away because they had a bruise or a scratch or were considered a dangerous parent. And it seems to me like if you have a situation here, as the one representative mentioned, that mom can possibly be smoking crack pipes or whatever, but as long as she's getting treatment, it's okay. I think we need to tighten up the consistency between those two things. In 201-101C, it talks about the requirements to report under the section applies without exception, and all of these people are professionals. I am really concerned about, and this probably isn't addressed completely here, but I'm really concerned about the anonymity privilege that professionals get. Professionals should be able to put their name behind something. I'm a professional. When I examine a financial institution, my name is on the report. They know who to come to. And this anonymity causes a lot of problems when it comes down to CPS cases. And there's also been instances where I've heard, I have not verified this, that because in a child custody situation or something like that, an attorney from a law firm will call CPS and file a complaint against the opposing side. It just seems like there's some room for dirtiness in here. So if we can do something that brings consistency and sanity to these standards, that's a good thing. My last point here is going to dovetail a little bit with what these bills are that we're just talking about. We have a mother who's seeking to get better and get treatment. And maybe in those cases as well, we ought to be saying, hey, maybe the father should be the person who has the primary custodialship or whatever we want to call it at that time of the child. We want to see our, whoever it is with problems get well, but at the same time, we cannot risk child endangerment. And so I first got involved, actually, Chairman Dutton, coming down here because of a CPS case, a personal case, which CPS individuals lied through me under the bus, and then also because of Liliana Wright, the 4-year-old who was killed in Fort Worth. And in that case, that was a grandmother who wanted to get the child out of a mother who may have been recovering, and also the father was trying to do the same thing. They had no recourse. So anything for me that limits CPS's authority, because I think it's probably the most brutal agency in our state, the Gestapo, I think it's good. I think that there are some things that raise some questions regarding consistency and so on with me. And again, the professional to report, I have some concerns with the anonymity of that. If you report, take ownership. Thank you.
Mr.
Any
Morgan,
questions?
thank you very much for your testimony. Any questions, members? Not hearing any. Show Representative Leo Wilson present. Thank you for your testimony.
Thank you so much.
Thank you for being here. Chair calls Carlos Damon.
Hello. Carlos. Presenting myself.
Give us your full name and what.
Oh, it's Carlos.
Carlos?
Yeah, Carlos.
You're registered as Carlos Damon.
Oh, yes, sir. Yeah.
Okay. And you're representing yourself,
I'm presenting myself.
and you're neutral on the bill.
Yes, sir. You know what? I'd like to switch it over to not in favor.
Against? Would you give us permission to change that on here?
Absolutely.
On your, okay. We will now show you against House Bill 811.
Yeah, I think it's a bad idea. I think it's very counterintuitive. In fact, kind of coincides with that House Bill 1734. Because if we're going to allow the women to carry this baby and she's doing drugs, you know, and still wants the money, and then at the end of her termination, it's like, oh, the baby died. I still collected the money, still got all the benefits, but I'm still not going to, there's no repercussion for me. It just makes no sense for this bill to pass. And according to the gentleman who said that 90% of those women are seeking those services when it comes to the resources, but they're already getting, you know, the WIC, TANF, Medicaid, you know, what else are we going to throw at them? You know, how about, like what the gentleman said, we take ownership of what we're doing. If you're going to have the kid, you know, I think both individuals need to take responsibility in sharing that kid. You just can't, you know, show up to court and say, hey, I think he's the father. I want money and I want benefits. You know, that just doesn't.
Have you seen the committee substitute for this bill?
You know what? I have not.
Okay. Okay, I didn't think so, because you're testifying about matters that are not in this bill. So, can I ask you to get with the author of the bill and get a copy of the bill so
Sure.
that your testimony will be appropriate at that point? Okay, I don't want to cut you off, but I'm just noticing that you were going down a road that had nothing to do with this bill.
If I'm not mistaken, this bill, the 811, was if the parent or the mom was using drugs, she didn't have the ability or did not have to report the drug abuse as long as she was going in a rehab.
Well, that's not quite what the sub does, but that's closer than where you were at first.
Okay.
Okay.
That's the way
Yeah.
I read it.
All right.
So,
Okay. Any further questions of Mr. Damon, members? Not hearing it. Thank you.
Mr. Wood, looks like you were offended by it.
Thank
so
you.
I apologize if I offended
Thank you. Thank you for your testimony, sir.
Okay.
Thank
Yeah.
you. Chair calls Julia Hatcher.
Chair Dutton, committee members, my name is Julia Hatcher. I'm an attorney in Galveston, and I'm also president of the Texas Association of Family Defense Attorneys. We are a statewide organization of attorneys representing parents and children in CPS cases. And I am here to testify in favor of this bill. Frankly, anything that keeps CPS out of parents' lives is good with us. But especially this bill is important because it empowers women to seek the medical treatment that they need to care for not only themselves but for their unborn child without fear that the medical provider is going to call CPS. Too often we see when medical providers call CPS in these instances, and CPS is there on the day of delivery to swoop the baby up. And it's not always necessary. As long as a woman is getting help for herself, and as long as the baby is not harmed, then we think that the woman can get community services. I'm sorry, the woman can get services through the community for her drug treatment, and leave the government out of the picture. And that's pretty much all I have to say on the bill, if anybody has any questions.
Ms. Hatcher, thank you for your testimony. Any questions of Ms. Hatcher, members? Not hearing any. Thank you again.
Thank you.
Chair calls Anton Kolokov. He was not here on the other bill. Appears that he's not here. He was testifying for himself neutrally on House Bill 8011. Will be shown that way. The chair calls Brandon Johnson. Brandon Johnson was testifying for himself and neutral also on House Bill 8011. Oh, is this Brandon Johnson?
Yes, sir.
Oh, I'm sorry. Chair calls Brandon Johnson.
Brandon Johnson, I'm testifying on behalf of myself. And I'll remain neutral on the bill because I have the same sentiments as the previous speaker, and I empathize with the sentiment of the bill. But there's a couple things. You know, is this going to apply to men as well? I know they're not carrying the baby, so it's not in the womb, in their body, but I see it a lot of times, you know, a guy will lose custody based on substance abuse, but other than that, he's a productive member of society and he poses no harm to the child. Now, I know that, you know, each of these bills is somewhat specific, but there's also a lot of overlap in these bills. You know, but one of the particular to this bill, though, who defines what a controlled substance is and if it does or doesn't pose harm? Where is this going to be defined? Beer cans and cigarettes have disclaimers of potential harm to unborn children. So who makes this determination that it's illegal or a risk to the child? And then, you know, also, I'm going to mention it, that it doesn't address the equal protection of men, as I've previously stated. There is overlap in so many of these bills that y'all are hearing today. You know, I'm the one that brought it up earlier. What if the woman is not protecting the child in the womb? And CPS or whoever's going to make this determination that she's posing no harm to the child, that leaves the man on the hook to pay this child support from conception and possibly deal with, that's going to be addressed later, you know, the lifetime of this child being brain damaged because of it, and he had no say in the process. One other thing that I want to address as far as the child support, because it is relatively attached to this bill, is that the state benefits from the Title 4D reimbursements and incentives from the Federal Office of Child Support Enforcement, which is basically the Title 40 agency housed in the OAG here in Texas, is a federal franchise. But to paraphrase, the benefit to the child support is to benefit the state. It's a profit center to the state. The benefit to the mother and the child is merely incidental. That's a paraphrase from Blessings versus Freestone, a Supreme Court case. So this whole idea about child support, when you're leaving these children with the mother and you're bending over backwards and jumping through all these hoops to make sure that child remains with a mother who's abusing drugs and could very well possibly be in a single mom for the benefits of cash prizes and custody that society and the state bestows upon them, you know, it's a windfall to the mother, it's a windfall to the state. And so I think it's worth considering these other factors that are we going to bend over backwards to let these women who don't need the kid have the kid just to be able to profit, the state profit? Ms. Lopez asked how many men were on child support. 92.7%, I believe, is what the number is. And it's not just people who go ask for services. 201-107 of the Family Code says judges shall maximize Title 40 funds, which means every man in the state of Texas is on child support if he does not remain in a relationship with the mother. Thank you for your time.
All right, thank you. Any questions of this witness, members? Not hearing any, thank you. That's all the witnesses we have. Is there anyone else here who would like to testify for, on, or against House Bill 811? Not hearing any, the chair recognizes the Honorable Representative Mesa to close.
Thank you, Mr. Chairman. In a way, I feel like it's kind of unfortunate, although I'm glad to have the quick hearing, that it was on the same time as this other bill because it seems to be causing confusion between the two bills. I served 2 years, two sessions on Human Services bill, on a Human Services Committee, so I'm very sensitive to the issues about CPS, about foster care, about how our goal is to, as best we can, leave children with their families or with family members, because it's so traumatic for them to be pulled from their families. So I'm very sensitive to all those issues. Little Leliana Wright that a witness mentioned was actually from Grand Prairie. She died in a closet. CPS is in a very difficult position, aren't they? Have you ever thought about it? They have to make the call. They get criticized sometimes if they make the call to remove a child from a home because they think it might be premature or they might be making a mistake. They get criticized if they don't take a child from the home, as to what happened with little Leliana Wright because she died. So this is not intended in any way to be criticism of CPS. It's just that the current policy is that if it's known that the expectant mom had substance abuse issues, that then she's kind of flagged, for lack of a better term, for the child to be removed. So this bill doesn't say that they get to, it's interesting they used the term crack, didn't say cocaine, but crack. It was an example, and we're not talking about someone still continuing to abuse drugs and being allowed to keep their child. We're talking about someone who admits, comes forward and says, I have a problem and I'm seeking help. And that then there is some evidence, proof that they're in a program seeking treatment for their substance abuse problem. So that's what this bill is about. And so we want to help the moms who admit that they have an issue, want to keep their child, and agree that they're going to be in a substance abuse prevention treatment program to get over their substance abuse problem, and have a concern for the health of their child, and have a concern that they want to keep their child, that we allow them to do that.
All right.
Do I have any questions from the committee?
Thank you. I think Representative Wu has a question.
Thank you, Mr. Chairman. I just want to just bring a couple of thoughts to your attention, and I really appreciate the sentiment of this legislation. When I've been doing this, passing similar legislation throughout. I mean, we added a whole bunch of stuff that denied the state's ability to remove a child or terminate a parent based on like marijuana use and some other stuff like that. But here, I just have a couple of quick concerns for you. All right. One of the things is that I think this is it's a very broad language, that meaning that what kind of cases or what kind of situations can fall under this is very wide. So like there's a big difference between, like, let's say someone who's pregnant says, oops, you know, I encountered marijuana at a party while I was pregnant, right? Just one time, and they tell their OBGYN, right? Versus someone who comes in and says, yeah, I use cocaine 3 times a week, right? Those are two very different situations. And part of that concern is sort of like in all of our CPS reporting requirements, our child abuse reporting requirements, there's no consideration of individual judgment. It's like, look, if you believe that this is abuse, not whether this is high abuse or this is low abuse, if you believe there's abuse, the law requires you to report. And here we're kind of creating this situation where, they're going to be exempted from reporting. And if there's a situation where like they don't report it, mom says, yeah, I'm going to go into treatment, but kind of does go into treatment, kind of doesn't. Like a lot of CPS cases that I'm a part of, the parents kind of, sometimes people with serious drug addictions may need to go into treatment 2 and 3 times before it sticks, right? And if that baby is born high level positive for cocaine, and the mom goes, well, my doctor said it was fine. Like my doctor didn't report me. I think there's potential problems, like legal problems for that doctor. There might be liability issues. Just something to consider, right? The second thing is, I think one of the foundational facets of our CPS reporting system is that all reports are anonymous. In fact, like nobody can force the information out of CPS of who reported, right? And there's provisions in this bill, like, so the person provides the proof to their doctor that they've done this or they've not done this or whatever it is. If they say like, well, I'm going to go to this treatment program, but doesn't, and then a report comes in, well, that person knows exactly who reported them, right? That's kind of like one of those situations where I think we need to be careful about that, because I know one of the witnesses said like they don't like the anonymity. I think anonymity is very important for our reporting system, so people are free to report what they need to report without fear of reprisal. And the third one is the last section of 8-1 is essentially a strict prohibition against filing charges or filing a CPS case on someone that has gone through or has made an attempt to go through substance abuse counseling. And I'll just say it like a lot of my cases, parents who are addicts come in, they say, I'll do this, I promise, I swear. They start, they do a couple of sessions, and then nothing. And then they fall off the wagon, and they're using again. We'll drag them back in, we'll have a come to Jesus meeting, and we say, hey, you got to do this, you got to do this. And they go, okay, I'm back. And then they come in, they do it for a little while, and because drug addiction is a pain, and it's serious and it's real, they fall back off the wagon. And this could happen multiple times throughout the pendency of a case. And if you're saying that if they started, it doesn't say that they completed it or that they are successfully in route to completion. It just says that they have started, CPS can't do anything. That's, I think, dangerous, right? Because CPS might come in and say, like, look, hey, I know you're trying, but you failed for the 3rd and 4th time, and you've had a year, you've not done this. We have to do something, right? Or your child was born positive with a high level of cocaine in their system. And if their prior efforts to get treatment block CPS from intervening now when the baby's born positive, that could be really disastrous. Just something to think about, right?
No, I'm thinking about what you're saying and trying to remember all the different points that I would like to respond to.
We can talk after.
When you talked about maybe smoking one time versus something more serious, and I think that's when you get into what is abuse and misuse, and I know you're giving extreme examples to make your point, but of course somebody that just smokes a cigarette one time is not going to be considered abuse or misuse where they would need to seek treatment. So then you also talked about whether or not the accountability in being in a treatment program. And you're right that it does take more than one attempt frequently for someone to kick an addiction, that it's not something easily done. In a previous life, I worked for the Tarrant Council on Alcoholism and Drug Abuse, and that's when I learned a lot about that. So trying, failing, and trying again shouldn't be held against the mom, because that's what we understand will probably happen, that they'll have to try, they'll slip, and they'll have to try again, they'll have to keep trying. But they do have to be enrolled in a treatment program, and they do have to be seeking treatment. So I think that's the important part. And I don't think that any of your comments are meant to say that we're not wanting expectant moms who are having substance abuse problems, that we don't want them to seek treatment. I think we do want them to seek treatment. Just have to recognize, as you said, that they may try and fail several times, and we want to be sure that they're in a treatment program and not just saying. Saying is not being in a treatment program, so they really need to be in a treatment program. We just don't want them to be flagged for coming forward and trying to do the right thing. When they're not being forced to go into a treatment program, particularly because they came forward to say, or otherwise we wouldn't know about them. These are expectant moms who've admitted that they have a problem, and they're concerned about it because they don't want to lose their child. And so I think they have a special motivation versus an expectant mom who has a substance abuse problem and doesn't come forward and say, I don't want to lose my child. I want to do something about this problem. I think that's more dangerous than the situation I've outlined here, where they've come forward. We don't want them to not feel like they can come forward and seek treatment for fear that they're going to lose their child.
Okay, thank you, Representative Mesa. Thank you. As Chair withdraws the committee substitute for House Bill 811 and leaves the House Bill 811 as a matter of pending business before the full committee without objection.
Thank you, committee, for your
Chair at this time lays out House Bill 1499 and recognizes Representative Campos to explain it.
Good afternoon, Chairman Dutton and Vice Chair Lujan and committee members. Thank you for the opportunity to lay out House Bill 1499, duties of court-appointed ad litems, attorney ad litems, and attorneys in certain suit affecting and parent-child relationship. During the interim, concerns were raised from DFPS management, placement, and indigent parents over poor representation from attorneys ad litems. For example, court-appointed attorneys met at last as the day of the scheduled hearing. My staff and I witnessed attorneys make requests to the court without even meeting with the child they represent. In 2018, the Children's Commission did a study of representation in CPS cases, and the study found that despite surveyed lawyers saying they provided high-quality representation, the parents and caseworkers did not agree. In that study, 35% of the children in care who were surveyed stated their attorney never met with them before the court hearing. HB 1499 provides a more defined timeline of when court-appointed attorneys and advocates must consult with their clients and uphold the Texas Family Code's definition listed in Section 107.001 of undivided loyalty and competent representation, because they are appointed to represent the best interests of the child. Specifically, attorneys and advocates must consult with their client not later than 7 days after the appointment, must consult at least 72 hours prior to each scheduled hearing, and visit the child at least once each month to properly monitor the child's safety and well-being. A pending committee substitute will allow outside sources to the case be interviewed by the attorneys within 15 calendar days, and include the requirement that both types of ad litems must ensure their clients, depending on the age, have their state or federal documentation. Substituted judgment under Section 107.008 will be amended to only apply to children with IDD, because stakeholders have indicated this type of representation is being seriously abused. During the interim, I did a lot of work with CPS, and so this is where my bill is coming from. I had some parents and DFPS, management that I spoke with, because I do my best to try to work it with as many as possible to collaborate to make things better for our children. And so this is where my bill stems from, and I'm here if you have any questions, and I reserve the right to close.
All right. Representative Campos, let's see if there are any questions. I don't believe so. And so we will give you the right to close. We will start the public testimony now. Chair calls Jeffrey Morgan, again representing himself and testifying neutrally on House Bill 1499.
Thank you. My name's Jeffrey Morgan. I am testifying for myself. I'm testifying on the bill. Representative Campos, I think that you brought some very good points on up. What I have seen, what I've heard, and for those who don't know, I've been looking at this family court stuff and what's taking place in our Texas family courts for probably 10 years. I've got about 2,100 videos on my YouTube channel, that's what these QRs are to. If you put them in your phone, you can see them. I've talked with people all over the place, and regarding some of the stuff that takes place. A couple of videos that I put down here is that the guardian ad litem, the ad litems and the amicus attorneys actually have the expertise to make sound recommendations. And basically the idea that ad litem sometimes think that they can rearrange families. But those are the two videos that I had down there. But the things that I wanted to mention here just in my testimony real quickly is that an ad litem is always a stranger to the child. And even though the ad litem is supposed to be representing the child, still is a stranger. Maybe sees a child for a couple of hours before representing the child, or as you mentioned, maybe the day of the representation or whatever. And it's been a lot of very ineffective representation of children. I also think that, so I think what you're getting at is that there's some type of corruption, some type of mismanagement, fraud, or whatever in the system as it is right now. The two other things I'd like to see is I'd love to see the ad litem fees be capped. Because right now, the ad litems can charge whatever they want, whatever they call reasonable. Is that not true, Representative Wu? Okay, if it's not true, that's fine. I was unaware of that then. So, and the other thing is that, and I apologize if that's the case, maybe I'm confusing two things, but the other thing is the best interest of the child. The guardian ad litem, or the ad litem is supposed to be representing the best interest of the child. No one yet has defined what that means. That is a very nebulous term. Representative Leach said it's paying money out. There's always something that we say in the best interest of the child. There is no objective meaning to that. And even the experts who deal with this tell you there is no objective meaning to that. I talked with a judge who said it is a subjective term. So the best interest of the child for one ad litem might be completely different than what it is for another ad litem. If you look at KP 0241, the Attorney General Ken Paxson wrote, fit and willing parents are supposed to be presumed to act in the best interest of the children. Anyway, that's all I had to say about that. I'm just testifying on the bill. I appreciate, Representative Campos, that you brought out some of these issues because I think that they are big issues, especially in our courts today, our family courts.
All right. Any questions for Mr. Morgan, members? Not hearing any. Thank you, Mr. Morgan,
Thank you so
for
much.
being here. Thank you for your testimony. Chair calls Taryn Champagne.
Good afternoon. My name is Taryn Champagne, and I am testifying in support of this bill. Two big thumbs up on this bill. While I may find that court-appointed guardians ad litem, attorneys ad litem, or amicus attorneys may not necessarily be representative of what is in the best interest of the child, I find this bill to be a great bill, and that it removes vague language in the family code and inserts specific timelines in so as to ensure that there are measurable timeframes to ensure adequate delivery of services. This is much needed, and perhaps in addition to these timelines, there should be some sort of performance metrics available if they fail to meet these timelines as outlined in the family code in this bill. And that is all I have to testify on. Any questions? Thank you very much.
All right. Thank you, Mr. Champagne. Thank you for your testimony. I guess there are no questions. The chair calls Carlos Damon.
Hello, Carlos. What other information do you need from me, Mr. Dutton?
Please give us I'll say this again for you. Every time you come up here, you have to start by giving us your name first, who you represent, and your position on the bill. Okay?
The position on the bill is...
Yeah, wait, stop. You have it?
Carlos,
Okay. Carlos what?
the man.
Okay, thank you.
And
Your
I am in
position on the
favor
bill,
I'm in favor of this bill.
okay, and you're testifying for yourself.
That's correct.
Well, our our computer says you were testifying neutrally.
Actually, I'd like to keep it a neutral.
You don't want to change it to, okay.
It's neutral. One thing that I like to have in that is just what part of the requisites are the guardian ad litem coming into this adjudication for the kid. So I don't see any prerequisites for the guardian ad litem. What kind of certifications do they have other than just a card? So if they have some sort of expertise, I'd like to say if they've had any type of additional training hours that makes them a little bit more better than the other one, it's down the street. That's the only thing I'd like for it to be added.
Any questions of Mr. Damon? I think Representative Wu has a question.
Yes, sir.
I can't speak for every county, but in my county, it's you pass law school, you pass the bar exam, and then you are have at least 15 hours of CPS-based training every year in CLE, and also that you qualify under the judge's requirements for the court to be appointed as a guardian, as an attorney ad litem.
Thank you.
All right. Any further questions of Mr. Damon, members? Not hearing any. Thank you for being here. Thank you for your testimony. Chair calls Julia Hatcher.
Chair Dutton, committee members, my name's Julia Hatcher. I'm an attorney in Galveston. I'm also president of the Texas Association of Family Defense Attorneys. We're a statewide organization of attorneys representing parents and children in cases involving CPS. We are strongly in favor of this bill. I can also tell you that I actually sit on the Legal Representation Committee of the Children's Commission, and so I was intimately involved with the report that came out in 2018. And that is one of the reasons why TAFTA was founded, to help train attorneys to get better in the courtroom advocating for their clients. One of the biggest problems with attorneys right now, attorney ad litems, that is outlined in that report, is that they're not listening to their clients. And as attorneys, we're all supposed to do what our clients want us to do. And that is why I'm so glad that Representative Campos wrote in the section deleting substituted judgment. The ABA model rules for representing children do not include substituted judgment. Several states in our country do not include substituted judgment. And it's become apparent in Texas that it has become very abused and misused by attorneys who don't want to listen to their clients and just do what they think is in the children's best interest when that's not their job. That's the job of the guardian ad litem. It's also become a problem across the state with attorneys not meeting their clients prior to the adversary hearing or not visiting their clients before any hearing. And so we're glad that these timelines are put into place to require that, to make that to happen. Other than that, like I said, we're strongly in support of the bill. And if you have any questions, I'd be happy to answer them.
All right. Any questions of Ms. Hatcher, members? Not hearing any. Thank you, Ms. Hatcher, for being here. Thank you for your testimony. Come on, give me the whole list. The chair calls Anton Golokov. He's not here. He was testifying for himself and neutral on the bill. Brandon Johnson, the chair calls Brandon Johnson.
I'm Brandon Johnson, testifying for myself, and I'd like to change it from neutral to strongly for the bill.
So you're okay with us doing that, changing it?
Yes, sir.
Show you're for the bill as opposed to neutral. Okay.
Yes, sir.
We've done it.
Yes, I appreciated hearing from Representative Campos on this bill. just putting the timeline, the deadlines on this for government agents or these items to perform is a good thing. And then it makes them accountable, just having them accountable for meeting with the client and all that stuff, because we do see this in a lot of these court cases. And one of those is, 2/3 of the docket in our courts are taken up by family law cases. And, it could be possible that, as I've stated last time I was up here, there's a lot of overlap. So I think it could be that these items are overworked and they get behind and lackadaisical. So hopefully they can come next year and say, look, if y'all will lighten our load by passing the equal shared parenting, I'm going to plug that for you, Representative Wu, because that will lighten the load and get some of the controversy outside of the courts. Thank you, Representative Campos.
All right, thank you. Any questions of Mr. Johnson, members? Not hearing any, thank you. Chair calls Aaron Robb.
Good afternoon, Chairman Dutton, members of the committee. I'm Dr. Aaron Robb. I'm here on House Bill 1449. I'm neutral on the bill. To give you a little bit of my background to start with, I have a PhD in social work. My area of research is the intersection of mental health and the law. I'm a former CPS worker, and I'm in private practice where I focus on high-conflict family court cases. I've seen the kinds of things that this bill is designed to prevent go on since I was a caseworker in the late 90s. Attorneys who don't show up until minutes before the hearing to meet their clients. That's a real problem. But unfortunately, the scope of the bill is broader than those attorneys. By including guardian ad litem, which I've been a GAL as a volunteer for CASA, I've been a GAL as a privately appointed person in difficult cases involving severe mental health issues for families. And often in those kind of cases, when you look at the timeframes under 107-002B in the proposed bill, we don't even get the orders into our office within the first 7 days of them being signed. There are some easy fixes to this. There are some easy ways to identify cases involving the department versus private cases. I think there are some real needs. This has been going on my entire career, that there are some real needs to address these issues, and I appreciate that the sponsor has done that. All in all, the other thing is, what are the parents able to do? I deal with a lot of parents who cannot drop everything to go meet with a guardian ad litem within those first 7 days after appointment. Often those 7 days after appointment are coming after a 14-day adversarial hearing where everyone is scrambling to set up services to hopefully not lose your job as you lose your children into a state care system. And so there are a lot of struggles that go on that this may actually burden parents inadvertently. It's an unintended consequence as, again, we try to fix a real problem. And the last piece of that is there is no enforcement mechanism here. We can say, see your kids within 7 days of getting appointed, or we're going to tell you you should see your kids in 7 days of getting appointed, just like for the last 30 years we've said, see them in a reasonable time frame. No one has ever argued that hours before a hearing is a reasonable time frame, yet it is the common practice. I'd encourage you to have some form of action involved in this as you separate out the duties of the attorneys versus other kinds of GALs, and thank you for your time.
Thank you, Dr. Robb. Members, any questions? Thank you. Okay. Is there anyone else who wishes to testify on or for or against HB 1499? If not, Representative Campos, close.
Again, thank you, members. HB 1499 provides timeless for a timeline for attorneys and advocates to work together to get the support that they need. Families and children will have a standard of representation they should expect. With that, I respectfully ask for your support. Thank you, and I close.
All right, thank you. Representative Wu?
Thank you, and I really appreciate this legislation. I know this is an important part of CPS cases, but I'm happy to work with you and talk with through some of the issues, and I think we can make this work. But I just want to use this opportunity to say, I think a lot of this issue is not necessarily what requirements are put onto the parties involved in a CPS case, but is that there's no enforcement, right? So, like in my practice area, judges are very clear about what the expectations are. Attorneys, especially if they're representing children, not only submit written notice that they've done their visits, and they, like when I do it, I describe when I did it, what the situation was, what I viewed. Sometimes if there's a cute picture I can attach with it, I'll attach a cute picture with it.
Right.
But if we put more rules in, but we still have courts that don't enforce those rules and don't care, then adding more rules doesn't do anything.
Right.
And I'm happy to work with you on this, and we want to make sure it's something that actually is manageable.
Yeah, no, absolutely. And again, this stems from the work that I did this interim.
Absolutely.
And so I
appreciate your work on that. That was really important stuff.
thank you so much.
Thank
and
you.
I'm open to working with you in any way possible to make things better.
Thank you, Representative Campos. If there's no objection, HB 1499 will be left pending.
Thank you.
Thank you. All right, at this time, Chair will lay out HB 1529. Who's that? Representative Campos.
It's me again. Good afternoon, Vice Chair Lujan and committee members. Thank you for the opportunity to lay out House Bill 15.
Excuse me 1 minute. The chair offers up a committee substitute to HB 1529. And go ahead.
Thank you for the opportunity to lay out House Bill 1529 relating to the duties of court-appointed guardian ad litems, attorneys ad litems, and attorneys in certain suit-affecting parent-child relationships. Last session, HB 135 was passed, which requires DFPS investigators to verbally in writing notify an alleged perpetrator their right to audio or video record interviews, and before the interview is conducted, be notified in writing of their right to request an administrative review, which they must sign in acknowledgement. Currently, there is no court requirement to ensure the 2021 enrolled law is being followed. HB 1529 provides a subsection in Chapter 261 of the Texas Family Code to include the court's responsibility. In order for more direct supervision of DFPS investigative work, the court must review and definitely conclude the department followed the laws established last session. Additionally, the bill allows better data to be collected for the department's administrative review investigative findings report, because more families will be aware of the right to request this review. The court, before the adversary hearing, will be required to confirm in writing and in open court an alleged perpetrator was notified of their right to audio or video recording any interview with DFPS and their right to an administrative review. If the court finds the alleged perpetrator was not fully informed of their codified rights, the court may not consider the evidence gathered from the alleged perpetrator in the investigation or interview. An example of the evidence gathered includes a drug specimen collected at the residence of the alleged perpetrator, which in common practices in DFPS investigations. A committee substitute will update the language to ensure only the ill-gotten information gathered from the alleged person or persons will not be used in the adversary hearing. The substitute ensures witness or professional interviews and evidence can still be presented. I'm here for questions, and I reserve the right to close.
Thank you. Members, any questions? No? Okay. At this time, the chair calls up Cindy Dyer. give us your full name, who you represent, if you're on for or against the bill.
Good afternoon. My name is Cindy Dyer, and I'm an attorney with Texas Rio Grande Legal Aid. I manage the Family Defense Project. My testimony was invited, and in my capacity here as a legal aid attorney, I registered as neutral, as I thought that did indicate the resource witness that we had talked about me testifying as, so apologies if I selected the wrong button. For context, my project at Legal Aid, we represent indigent parents at all stages of CPS intervention with a focus on early defense, meaning we are some of the few attorneys who are out in the field with our clients during an active investigation. We are one of only 3 projects or programs in Texas to offer this service, and there are very few attorneys and very little oversight in the investigative field. While we and our clients do appreciate the actual written notifications being provided during the investigative stage, as this was implemented in the 2021 session, not everyone receives those. There are 2 requirements from the last session. The requirement to be notified in writing that the parent has, or the alleged perpetrator has the right to record that initial interview, and also the right to an administrative review. However, there's no current enforcement or relief mechanisms available in existing law for when our clients do not receive those notifications during the investigation. The current only option available to parents or alleged perpetrators who have not received those required written notifications from 2021 session is to make a complaint to the Office of Consumer Affairs, which typically just results in a letter to the parent that there was a policy violation, but there's no impact on the parent's case even if there was no notification provided. So this bill, since there is no oversight during the investigative stage, either judicial or otherwise, this bill actually allows relief for a parent to seek if they're not provided with the required notices. If the department is already following the 2021 laws and providing those 2 notices during the investigation, then there should be 0 issue for the department to say so and attest to that in court at their adversary hearing, which is all this bill provides. Per this bill and the committee's sub, the only time evidence under this bill is excluded is when the department doesn't follow the existing law that has been in place for over 2 years. I'm simplifying this due to time limitations, but any lawyer can tell you that if a party doesn't follow the rules in obtaining or disclosing evidence in regular litigation, there are various provisions in the rules of civil procedure and rule of evidence to exclude that evidence. So adding in additional protections for families to the investigation stage, as continues to happen in every legislative session, is helpful to all Texan families. But it's bills such as 1529 that actually allows something to happen when a state agency itself doesn't follow the law. Thank you.
Thank you so much. I know we have a question. Representative Wu?
Yeah, thank you, Vice Chair. And we've had this discussion on another bill that I'm not going to bring up right now that we've heard in this committee already. And I think the comparison that we always make is like this is comparable to Miranda, right?
Sure.
Like, and when you violate Miranda warnings, there is a clear consequence, fruit of the poisonous tree, and evidence is knocked out. So, but my kind of like the conundrum that I've been like rolling around in my head in dealing with all these bills is like Miranda applies at arrest, right? And that's a very clear black and white demarcation. When you're arrested is very clear in the law. My concern on this type of situation is when does your right to be informed of your rights get invoked, right? Because if you, like a lot of times at the beginning of the investigation, CPS just is talking to people, and they may suspect that one person is the perpetrator, and so my example would be like let's say auntie calls in a child abuse report, and she says, oh, it's the dad, right? And they go talk to auntie first, get the information. They don't warn her. They don't provide any warnings, and then they go talk to dad. They do provide him with warnings and everything else because they think he's the suspect or he's the perpetrator. But dad provides a lot of evidence saying, hey, no, this is like the 4th or 5th time auntie's done this. She's it's a vendetta. She's the one who actually is causing the abuse, right?
Sure.
And they go and say, you're right. There is evidence that Auntie is the perpetrator, but they didn't warn her when they first talked to her because, right? She wasn't a suspect, wasn't a possible perpetrator. So my question is then, does everything that they collected from her, from Auntie, that is very self-incriminating, is that now knocked out because they didn't warn her because Auntie wasn't ever considered at the beginning?
And I think my struggle with that fact scenario is that if the aunt didn't have conservatorship rights, then the adversary hearing doesn't involve her, right? So if she is the perpetrator.
Well, we don't know.
Right.
We don't know. Auntie might have the kids. Auntie might not have the kids.
Sure. And I mean, the rules are already in place that the notifications have to be
Right.
provided.
No, and that's a frustration. I get it.
Yeah. And so our issue is there's no teeth to anything, right? So we can tell people all day, sure, did you get that warning? No. Well, what am I going to do about it now? They already have all the information, and now we're barreling towards court. If not this, then what? With no judicial or other oversight. And I think that providing everyone those rights that is being talked to by the department isn't hurtful. It is already a pre-printed form that can be distributed, telling everyone they have the right when they meet CPS, just like they have the right when they talk to law enforcement to have an attorney present or to record the interview. I'm not sure of the downside of that.
Fair. Thank you.
Sure.
Members, any other questions? Thank you very much.
Thank you.
This time, the chair calls Carrie Wilcoxon. If you can let us know your full name, who you represent, and if you're on for or against.
Good afternoon, Vice Chair Lujan and other distinguished committee members. My name is Carrie Wilcoxon, and I am testifying in support of 1529. I helped draft this.
Representing yourself?
I'm representing myself, sir, yes. I helped draft this piece of legislation. I will be testifying from perspectives of a former investigator and a business owner that now provides CPS case consultation services to attorneys and parents throughout Texas. I think that the witness before me laid out some really great, that's exactly what I would have said, right? Like, this is a checks and balance. And it was born out of a meeting with a legislative representative here and with some attorneys. And the question in the meeting was, how do we force CPS to follow law? We have all these wonderful laws and policies around these child abuse investigations, but how do we enforce them to follow them? And so that's where this comes from. The idea would be that, of course, if we provide 307 rights up front and we ensure that those were provided, the consequence being at an adversarial hearing that if they weren't provided, that ill-gotten information and evidence cannot be used, specific to the alleged person. But I appreciate your question, and I'm not an attorney, Representative Wu. I'm just somebody that kind of comes in here and does this stuff, and from the perspective of a former investigator and been consulting on these cases. But I would imagine in a criminal investigation, if a detective's talking to a neighbor who's just a witness at that point, and then later on in their investigation, they discovered that individual may be a suspect, then when that suspect becomes a suspect related to that crime, that's when they're provided their Miranda. And so just like, I don't know. No, okay. Well, in CPS cases, if they're talking to grandmother, if she's not a suspect at the beginning of the investigation, during that investigation, if she does become an alleged perpetrator, she is then titled inside the state system as an alleged perpetrator. And at that point, 307 should be read to her. Those rights should be provided to her.
And I think what the previous witness said, and in her answer, and I don't necessarily disagree with it, is just that CPS would need to, in order to deal with the fact that there is no Miranda-like clear nexus where there's a very clear cutoff point of, hey, you're under arrest, therefore you get Mirandized. Because we don't have that in a CPS case, that go ahead and just warn everybody. Anybody that you talk to, no matter who they are, If they're not an employee of the state, if they're not an employee of the government, you hand them a piece of paper that says here are your rights, and we don't know if you're a suspect or you're a possible perpetrator or not. Here are your rights, and you're talking to us voluntarily, and anything you say can and be used against you. So, I mean, that's a fair way to do it.
When I wrote this, and the intent of it was to protect those that were subject of a CPS investigation that would then expose their parental rights to termination.
No, but like I think my point was that during investigations, I've seen this in cases before, is that you don't always know who the target is until later on, until everything's been fleshed out, right? And then that's when we end up having. My concern is that somebody gets away with something because they weren't the first person to be talked to, or they weren't suspected at first.
Okay.
Is that fair?
Yes, I understand. I would only submit that this is a starting point
Yeah.
for checks and balances. We don't have anything like this just yet, and it would at least start us moving in the right direction.
Yeah, and like I said, I'm appreciative of this, and I totally understand the need to put teeth into legislation, because I'm all about the or what part of legislation.
Okay. Thank you very much, committee members.
Any other questions, members? Nothing? Thank you so much. Appreciate it. At this time, the chair will call up Jeffrey Morgan.
Thank you. My name is Jeffrey Morgan. I'm testifying on myself in support of this bill. There's really not much for me to add, so I'll keep this really short. I just want to thank Representative Campos and the other lady who was working on this. We have to protect our families from the tactics that CPS has used. Probably the most complaints that I get have been from people that have been abused by CPS, and it seems like there's no recourse. These protections are absolutely necessary. Thank you.
Thank you. Any question, members? All right. This time, the chair will call Taryn Champagne.
Good afternoon. My name is Terrence Champagne, and I'm representing myself, and I'm in favor of this bill. I think everybody else has pretty much said what I was going to say, so big thumbs up on this bill, and I hope it passes.
Thank you so much. Appreciate it. Any questions? All right. The chair calls up Carlos Damon. Full name, who you represent, on, for, against.
Oh, thank you, Mr. Blanco.
Okay.
Carlos Flores, I represent myself.
Okay. On, for, against?
In favor.
Okay.
Pretty much, again, with the other two gentlemen in front of me.
Okay.
So, very simple. Looks good.
Thank you. Any questions? All right. Chair calls up Julia Hatcher. Full name, who you represent, on, for, against.
Yes, my name is Julia Hatcher. I'm an attorney in Galveston. I'm also the president of the Texas Association of Family Defense Attorneys, which is a statewide organization of attorneys representing parents and children in CPS cases. And we're strongly in support of this bill.
Says you represent yourself also, correct?
And myself, yes. And what we found is that not only is CPS not giving parents their right to record the interview, but they're telling them specifically, you cannot record the interview. So even though it's been the law for 2 years, they're not following it, whether that's a lack of training, whether that's incompetence, whether that's obtuseness, I don't know. We don't know, but that's what's happening. So we agree with the prior testimony that there needs to be some teeth to the law, because you can put into law anything you want, but if there's no way to make them follow it, it's not really a whole lot of good. As to your suggestion, Representative Wu, I agree with you wholeheartedly. Let's give everybody their rights. And then they don't give the witnesses all the information that give them their rights. They can't use their testimony either. I mean, they can't use their statements either. So let's just tell everybody, and they don't want to follow the law and do what they're supposed to do, then they're not going to have any evidence at a hearing. I think that's a brilliant idea. Thank you for bringing it up.
Thank you, ma'am. Members, any questions? All right, thank you so much.
Thank you.
It's time the chair calls. Jeremiah Michael. Mr. Jeremiah Michael. Once, twice, 3 times, okay. He's was testifying in favor. Okay, at this time the chair calls Paula Lajacos. Really? That's good. Proud of myself. Give us your full name and who you represent on for or against.
I am here representing myself. My name is Paula Vlahakos, and I am testifying in support of. First, let me thank you for allowing me to address you today in support of what I think is a vital piece of legislation. I've been a practicing family law attorney for over 20 years, and from 2015 to 2018, I served as the associate judge in the 247th District Court in Harris County. And in that capacity, I was the judge that presided over our CPS docket. In that capacity, obviously, my job is to protect due process, right, when you're at the courthouse at a minimum. But most CPS cases, many CPS cases, don't end up in court. And although not every CPS referral results in a ultimate court action, every single CPS referral and investigation invokes an alleged perpetrator's constitutional rights at that moment. Maybe not at the referral, that's a good point, Mr. Wu, but certainly before an investigation begins, before they get spoken to, their constitutional rights are invoked and all the due process protections that go along with it. The Fifth Circuit has clearly stated that Fourth Amendment protections extend to social service workers' investigations. So, and the reason is because at that moment, your fundamental constitutional right to stay together as a family and to raise your family without the interference of the state or there's wording in a case, the coercive interference or the coercive power of the state. And those words I chose carefully because although CPS, it's negative, coercive is negative, right? Implies intent. Not necessarily, but I think what we can all probably agree on is that what a CPS investigation is confusing. Who are the perpetrators? When do they become? When are we a social service agency providing help? And when does that turn to then we're also a prosecuting agency and we're also an investigative agency? By its very nature, it's confusing. But as part of that investigation, whether it ultimately gets to court or not, it involves processes that are incredibly invasive. Psychological evaluations, drug tests, counseling, invasive activities that afford incredible amounts of private information to the government. And just like in a criminal investigation where the players are all clear and the roles are clear, the same protections need to be afforded to, the legislation says alleged perpetrators, but I agree, probably everybody we're talking to, because they can become an alleged perpetrator. It can become, we're here to help, and then suddenly or not suddenly become, now we're going to court to ultimately take your parental rights away, which is the death penalty in civil law. This bill addresses this gap in due process protection because I think it mandates that at the outset of the investigation, before you talk to anybody, you need to give them these warnings. And I believe 307 is also being amended to say not as soon as possible, which is what the language currently reads, but at the outset or something similar so that it's immediate. This bill puts the responsibility on the agency, which it already has at some point in the process, to inform the alleged perpetrator of various things set forth in the code, which previous people have said they're not doing or don't do consistently. This puts the onus on them to do it. The timing is critical. The specifics are well set out already. But most importantly, it imposes consequences. And it requires the court to determine that if notice was not given at the outset, and it gives them the ability to exclude that evidence. The necessity of this bill, I don't think, can be overstated. I'm not sure without this type of warning to everybody or just the alleged perpetrator that due process has been afforded at all.
Okay. Thank you very much. Members, any questions? No? Thank you very much. Do we have another one? Okay, at this time, the chair will call. We already did. Roland Ortiz. Roland Ortiz twice. Roland Ortiz, okay. He is not here. We have him 4. Chair calls Anton Golakov. Anton twice, Anton 3 times, not here, okay. We are showing him 4. Chair calls Brandon Johnson. Full name, who are you representing, on for or against?
Brandon Johnson, represent myself. I would like to change on the bill to for the bill.
Okay, change you for the bill. Okay. You give us permission to change it?
Yes, sir.
Okay.
Yes, please change it.
Okay, you are now shown for the bill. Go ahead.
All right, thank you. I've been an advocate since 2017. I've been a court watcher, especially online, since COVID. And so I see quite a bit of one of the things that I see, having said that, is this bill protects the due process. And being able to do the audio and audio video in all proceedings with a timestamp would be preferable. Anytime you have these industry experts, be it judges, guardian lidums, CPS, anybody, there needs to be recordings. And so one of the things that I think, though, comes up, and I'll just say this, many times the government actors, including judges, court personnel, and other industry insiders who become involved in the case conspire to create a narrative and predetermined outcome. And that's kind of what, in this CPS situation, that's where it starts. And then they have so much discretion. They got so much leeway. I've been investigated a couple times and talked to a lawyer. They said, well, you either deal with the retaliation or you just do the interview. Now, it all went away. It was just a one-time interview and dismissed. But I have been through that, and it's a very concerning process. One of the things that I think we could add to this bill, because you get into rules of evidence with somebody just turning on their iPhone, and I'm not sure that would be admissible. So you could hire a notary public who would be a third party that would do the video recording and be able to attest and verify that they did it. It would be time-stamped and whatnot. And then that way, even if it's not prosecuted under this code or this, section, at least you could move forward and maybe have a recourse under something else. And I understand Mr. Wu's concern, with these people, if maybe they were a witness to something that transpired or, have a concern for the kid and they don't want to be retaliated against by this alleged perpetrator. And that makes sense. Anybody could, sympathize, empathize with that. But where's the balance? And it's one thing if it's a one-time and everybody was fair and open and honest. But if this becomes habitual, is there, somebody had mentioned an internal file within the CPS to where you can see a history of what's taking place. Or maybe it's a group of people that are doing this, and it's a form of harassment. Because we see this a whole lot in these family law cases where false allegations, usually disguised as some kind of domestic violence, child abuse, that's nature. Now you're getting the whole power of the state behind you, and there's nothing verified. there's nobody even to go against. You're just going up and against the allegation and losing your kids. And it's just not right. So thank you for Ms. Campos for proposing this bill. At least it's a step in the right direction and gets the conversation going.
Thank you, Mr. Johnson. Any questions, members? All right, thank you. This time the chair will call Cecilia Wood. Ms. Wood, if you can give us your full name, who you're representing, on, for, or against.
Sure. My name is Cecilia Wood. I'm a board-certified attorney in Austin, Texas, and I'm here today representing the Family Freedom Project, which is a project of the Texas Homeschool Coalition, which does many cases and is highly involved in protecting parental rights, specifically in this, or a large part in the area of child protection services, as well as myself, having practiced in this area. And I think that this is an excellent bill. The committee sub what I think the committee sub is going to say is that it will begin before interviewing. These rights will be told to the party or an alleged perpetrator prior to interviewing. But Representative Wu, I just really understand your concerns because at a minimum, every parent or a person with a court-ordered possession should understand these rights. But as you know, the Gates case said that a social worker has the same duties as they are as a civil servant. And so many of these cases, maybe Auntie doesn't have rights, but she may actually be a perpetrator, and now she's facing a criminal conviction. And I do hope that, as a previous speaker talked about, that they will also hand out these 307 brochures in the beginning so that people know, hey, I'm going to call my attorney and then call back. So I think this is great, and I certainly hope you pass it out of committee.
Ms. Wood, thank you for your testimony. Members, any questions? Thank you very much. Appreciate it. It's time the chair will call Jeremy Newman. Mr. Newman, if you can give us your full name, who you're representing, if you're on, for, or against.
Members, I appreciate the time. My name is Jeremy Newman. I'm the VP of Policy for the Family Freedom Project, and we're a statewide organization that works on parental rights issues. A lot of that is litigation related to parental rights, and a lot of that is CPS cases. So I kind of look at this...
And you're for
the bill. Yes, I'm sorry. And I kind of look at this from a little bit of a big picture policy perspective, that very, very frequently this type of situation we discover is that all over the state we're involved in these CPS cases, and the policy of CPS often is actually good. And the difficulty we have is in getting it to actually happen that way. And we'll often end up in communications with the commissioner or people who are in supervisor roles at DFPS who understand what the policy is supposed to be, but there's just this huge difficulty in getting it to filter down all the way to the caseworker level, such that when they're actually talking to the parent at the door, that it's followed correctly. So the thing about this is that it kind of allows you to bypass some of the bureaucratic difficulty in some ways by putting in some accountability that requires that they actually have to follow certain policies and inform people of certain rights at the door. And there's a consequence that comes in that you can hold somebody accountable to if that doesn't happen. And I think that Representative Wu, to the point you made earlier, that the easiest, simplest way to think about this is that it's basically akin to what we do in the criminal process. And, in the criminal process, even if you're not talking about a death penalty case, then you would still have these types of rights. But in the CPS process, they call it the death penalty of civil law because it's so severe. And a lot of people would prefer to go to jail or even be on death row rather than lose their children. And so it just makes sense to include that same level of protection for those types of families.
Thank you. Members, any questions?
Thank you.
Thank you very much. I think that's all our witnesses. Is there anyone else who wishes to testify on, for, or against HB 1529? If not, the chair recognizes Representative Campos to close on HB 1529.
Again, thank you for allowing me to present this bill, and I think it just goes back to accountability and transparency that is much needed with DFPS. And again, with all the cases that I've dealt with in the interim, there was just too many families that didn't know their rights and then winded up in court. And so when you get a knock at the door from CPS, it's terrifying. So we just got to make sure that they're following the process, and they haven't been. And so that's the purpose of this bill. And so thank you, and I close.
Thank you, Representative Campos. The committee substitute is withdrawn, and if there's no objection, HB 1529 will be left pending.
Chair calls, lays out House Bill 120 by Christina Morales, and there is a committee substitute.
Yes.
And so the chair lays out the committee substitute for House Bill 120 without objection and asks Representative Morales to explain it.
Yes, thank you, Chairman Dutton, Vice Chair Lujan, and members. This bill simply clarifies the exchange locations of a child when a party's period of possession begins or ends with the school day and the child is not in school. This addresses current gaps in the code regarding child custody exchanges and terms. This bill is due to a constituent experience during the COVID-19 pandemic. The non-custodial parent was stating that they could not return the child to the custodial parent because the divorce decree stated the return of the child would happen at the school, and the school was closed to due to the pandemic. So we had a constituent call us, and they were just very upset because the non-custodial parent would not return the child because the school was closed, and the court document stated that they should exchange during or at the school. So there are times when a child is not at school. For example, the pandemic or a hurricane, whatever may happen. And when schools cancel classes or when a school moves to a 4-day week, in those situations, parties need to know where to exchange their child if it cannot take place at the school. So the committee substitute has support from the Texas Family Law Council and Texas Council on Family Violence, and both were consulted during the drafting process. And the only thing that we changed is accounting for and ensuring that these agreements are in writing. So this bill ensures that children are not left in between parents due to school closures during pandemics or other events, and ensures that both parents' visitation rights are protected. So thank you. I'll take any questions.
All right, any questions of Representative Morales, members? Not hearing any, thank you. We'll proceed down the public testimony right now. If I can get my computer working. I can't seem to. Okay. Chair calls Cody Taylor. Testifying against House Bill 124 himself.
Reading into this, I'd like to change it. I'll give you permission to. I am for this.
You for it?
I am.
Okay.
You can change it.
We'll change it. You're giving us your permission to change it, and we will do so. Okay.
Yes, Cody Taylor, representing myself, and I am for the bill. I do think that it is laid out better as far as it does need to stipulate some actual constraints. There is a platform that deals with this in the Penal Code of 25.03. I think parents are given too many leeways as to make decisions beyond that. When we do have a pandemic or a school outing or weather or whatever it may be, all of a sudden they take that to be an extreme, and I'm not going to return a child. I'm not going to meet you. This becomes an issue about where and when. There are a lot of places that do offer site points that are recorded to protect anything that does happen. The problem is, though, and I will state this, is that I do think that if we had equal and shared parenting along with this to go with it, you would have a lot more co-parenting situations. I know not every situation brings that, but it would be a better starting point for all parents, especially ones that are being active, that are always there on both sides of the aisle on that one. I do think that school is one of the best ways to do that, because the issue is that some parents can't be in the same room. They don't like to be around each other. They make comments. Things do happen, and we've seen this evidence in the last several months of it actually escalating beyond just an altercation of verbal. It's becoming an issue where parents are together. So getting out of school, parent picks them up. They don't have to see each other. That sometimes is the best remedy for this. So I do think your bill irons that out. I think 25.03 needs to be pushed. If you could work for that to be added into your bill, I think that George Saldana has done a great job in pushing that point across. So
all right.
That's all I have.
Any questions of Mr. Taylor, members? Not hearing any, Mr. Taylor. Thank you for being here. Chair calls Jeffrey Morgan, testifying for himself and neutrally on House Bill 120.
Yes, thank you very much. Jeff Morgan testifying for myself on the bill. And I want to, I think overall, I'm probably leaning for the bill, but I'm just going to remain on the bill right now. I've not had to experience these issues that other people have talked about and that they've experienced themselves. I do know that I've interviewed people who have had killings taking place at child custody exchanges. Chad Reed, Jennifer Reed, actually, her husband was killed recently. We are putting out some videos regarding that will be coming out later on this year, but this is a big issue with regard to the child custody exchange. I think, as Mr. Taylor just mentioned, when you have inequality of parenting, you also have inequality of power. And the inequality of power creates some of these situations where one person can abuse the other. And then the 2503, as is mentioned in the Texas Penal Code, that is a state jail felony. It comes right after bigamy, I believe, as far as a crime against the family, and yet that's really enforced. I've seen that take place on a number of occasions as well. Anyway, I think that it's, like I said, I'm basically favoring it. I think I just kind of wish, this is a comment, and then I'll stop right here. I look at 153.316.1, the managing conservator shall surrender the child to the possessory conservator. I don't like those terms personally. The conservators are parents. And we almost create an adversarial relationship when I'm the managing conservator, and you're the conservator, the possessory, and you must surrender the child. And I just wish that, we should be able to act like adults. I wish that our codes would also express that and I mean, I guess capture that a little bit better. But again, I stay on the bill. Thank you for mentioning it. If other people that are speaking will have much more experience in this than I will, so I do appreciate the fact that the bill is out here. Thank you.
All right. Any questions of Mr. Morgan, members? Not hearing any. Thank you, Mr. Morgan, for being here. Chair calls Taryn Champagne.
Good afternoon. My name is Terrence Champagne. I don't recall signing up to testify for this bill, but it sounds like a great bill to me, so I'm for it.
All right, good. Any questions of Mr. Champagne?
I hope you're okay. Representative.
Everybody's thanking you for your testimony.
Thank you very much, Chair.
Thank you. The chair calls Carlos Domain.
Hello, Mr. Carlos Flores, Damon, and then I'm actually, did I put neutral or in favor?
Yes, it shows you're neutral for this bill.
Okay, just want to make sure. Carlos Damon for the bill.
You're for it or neutral?
Neutral, sorry. I can't, because I'm already kind of thinking of what I want to say ahead of time. Because people have died with this power control of the conservatorship, managing conservator. I was in that same predicament. I'm glad I'm still here. I only got to see my two living, breathing daughters, Marlo Flores and Diana, for 42 days. It was sick. It's disgusting. I think we should add something into that law where if there's a disagreement, default to the police station. How's that sound? That's what I like to end on that note, because I mean it's everybody's fighting about the location. If there's any type of fighting, I think it's just default to the police station.
All right, thank you. Any questions, members of this witness? Not hearing any. Thank you. Thank you for your testimony. Chair calls Anton Golakov, who is not here, but will be shown as not testifying in neutral on the bill, Brandon Johnson. Chair calls Brandon Johnson.
Thank you, Chairman Dutton. Brandon Johnson. I've been an advocate since 2017, court watcher since COVID began online, and I'll remain neutral on this bill. I understand the sentiment for it, but one of the things that's left out in the conversation is the representative's constituents, the father in the case. And I've dealt with this exact issue, and it's disgusting. There's a guy that's got a channel, and he calls these women who do this stuff baby mama terrorists. And what I'm talking about is you get into a situation where the mother takes full control, even though in these divorce decrees it says, well, if both people agree, then you can do whatever you want. Now, I don't know the specifics in this case, but from my own experience and many people that I do know, these women will use a standard order to bully the father to the very bare minimum of time. And according to you folks right up here representing the state of Texas, that's just fine. Until last session, y'all decided to pass an expanded standard schedule that's not being followed. Judges are not writing that into the orders. And you know what? Guys get fed up. I'm completely fed up with the system, but I can't continue to come down here. I haven't seen my kids in 2.5 years. And you know what? It's peaceful that way. I don't have to fight with the mother. I don't have to be badgered and pestered. When you gonna bring them back? When you gonna pick them up? You're 5 minutes early. You're 1 minute late. It gets to be exhausting. If you pass the shared parenting, you remove all this controversy.
Hey, look, can we stay on this?
Yes, and this bill, but that's what I'm saying.
Okay.
This bill, even though, okay, you're right. I'll bring it back to the bill.
Thank you.
The bill, as it is, has problems that you're not seeing. And it needs to reference the expanded standard. It needs to say, hey, you know what? If this is an issue, maybe it creates a change of circumstance, and then you go put the expanded standard in, and then you remove the controversy by having the exchanges at the school where the parents aren't involved anymore. And the way, even in these 4-day weeks, they're getting out on Thursday, so it's a non-issue. Thank you.
All right. Any questions of Mr. Johnson, members? Not hearing any. Thank you, Mr. Johnson, for being here. Who's next? Okay. That looks like all the witnesses we have for this bill. Is there anyone else here who would like to testify for, on, or against House Bill 120? Chair hears none and recognizes the author to close.
Thank you again, Chairman Dutton. As a person who's been through a divorce and had to go through these situations before, I can tell you that many times this bill that I'm working on here or that I filed here is not needed. In most situations, parents work things out and they can exchange the children at each other's homes. But in those rare situations where there are problems, This bill just clarifies where they can exchange the children in situations where the school is closed. And this was very apparent during COVID, but I imagine it could happen during a hurricane or any other natural or man-made disasters. So we want to make sure that both parents are protected and there's a mutual neutral place for them to exchange children. And I do want to point out that this bill passed the full House and the Senate State Affairs Committee last session. So I'm hopeful that we can get it all the way to the governor's desk this session.
All right, thank you. Let's see if there are any questions. Any questions for Representative Morales, members? Not hearing any. It's the chair's intent to withdraw the committee substitute for House Bill 120 and leave House Bill 120 as a matter of pending business before the full committee. Chair lays out House Bill 1086 and recognizes its author, Representative Hull.
Thank you, Mr. Chair, for allowing me to lay out House Bill 1086. Courts are tasked with making important decisions concerning families and child protection cases, and judges should have all of the information from each side involved to protect due process and the rights of both children and parents. During DFPS investigations of child abuse and neglect, CPS investigators will often ask for entrance to a home or school, access to a child for interviewing, and copies of the family's health records. If parents decline, the department may ask a judge to order these things to take place in order to aid the investigation. Unfortunately, these orders to aid investigation are often issued after an ex parte hearing with only a sworn affidavit from the department with no opportunity for the parents to present their side of the investigation. By preventing these ex parte hearings from taking place unless absolutely necessary, and by requiring a record of those hearings, House Bill 1086 will provide due process for families and transparency. House Bill 1086 raises the standard for requesting an aid to an investigation from good cause shown to probable cause to believe that an order is necessary to protect the child from abuse and neglect, which is a standard that more closely matches the immediate risk to the child standard and recognizes the fact that it is sometimes impracticable to hold a full hearing on the matter. When the right to care, custody, and control of your child is at stake, it is imperative to ensure CPS investigations are being conducted properly to protect due process. Finally, this bill requires that in the event that an ex parte order is necessary, there must be a record of that hearing made available to a requesting party. I anticipate a substitute that will allow jurisdictions to utilize whatever form of hearing record they are currently using, including audio, court reporter transcription, or electronic submission such as email. It also extends these due process protections for aid to investigations and to emergency removals as well. This bill provides needed guardrails on ex parte hearings and ensures parties have a record when they do take place. Happy to answer any questions and would like to reserve the right to close.
All right, thank you. Any questions of Representative Hull, members? Not hearing any. Thank you, Representative Hull. We will begin the public testimony. Chair calls Jeffrey Morgan.
Thank you. My name is Jeffrey Morgan. I represent myself. I am for the bill. Thank you, Representative Hall, for bringing this forth. I've got a handout.
Can you send me all of them?
I couldn't help but think of, when I was looking at this bill, the CPS case, the right to lie, how a CPS attorney was trying to convince a 3-judge panel that CPS had a right to lie to them. And the judges were just incredulous. You mean you could stage actors and everything else and just create something, take the kids away? And it was as if the CPS attorney did not know how to respond, was trying to actually defend the practice. And I think as well, when you look at U.S. District Judge Janice Graham-Jack, she found Texas as being in contempt. Texas has not had a very good good record as far as with foster care is concerned. I know that's a little bit different here, but the CPS stuff, again, the CPS, I look at CPS as probably being the Gestapo. There's nobody who looks at, CPS as here as a friend. I've sat in court cases where CPS has actually tried to get me kicked out because I was just simply watching. And I saw the CPS attorney come after me when I asked her what her name was. She wanted to take the kids away from the father because the mother wanted a divorce and thought that they would be better off in a foster care than a father raising a couple of girls. That's how abusive this stuff gets. And Representative Hull, it sounds to me like maybe you've experienced some of this, or at least you've known people that have gone through this. We absolutely need the right to record CPS. I cannot tell you how traumatic this is to the people that go through the CPS process, and they are always disbelieved. So I thank you for this bill. I think that, I'm sorry, am I on the right bill still? It should not be, maybe it was confusing too here. I would also say too, yes, make sure that the parties, and I think this was maybe addressed earlier, make sure that the parties that CPS is going to interview or whatever, I would say they should have the right to record, audio record, video record, perhaps even have other witnesses there. We have to do something to stop the abuse of CPS, and I think that this bill is a good way to start to do that.
All right, thank you, Mr. Morgan. Any questions of this witness? Not hearing any, thank you again.
Thank you.
The chair calls Taryn Champagne.
Good afternoon. My name is Taryn Champagne, and I represent myself, and I am in support of this bill. Currently, the family courts in Texas operate in secrecy in clear violation of the open courts doctrine. Rulings are made in hearings where there is no record of, or the person seeking a transcript is unable to afford the exorbitant fees required to purchase this. It is often said that you can only get the justice that you can afford. By automatically providing a copy of the ex parte hearing to a party requesting it, they may have a better idea of what actually happened in the case. We live in 2023. Audio recordings are easy and cheap to produce and do not require a transcriptionist for them. I've court watched in probably close to 50 cases over the past 3 years and have seen the disgusting ways the attorneys and judges conduct themselves in the courtroom. None of their demeanor or tone of voice is reflected in court transcripts. Supposedly, these individuals are supposed to be professional. What I have seen is they often use tonal cues and expressions to intimidate litigants. By providing an audio recording, it may help with picking up some of these voice tones that may not be reflected in a transcript. I would encourage the author and committee to go even further in providing these audio recordings in all family law cases so as to allow greater access to justice and not simply to those who can afford it. These audios and even video recordings would assist litigants in their case by allowing them to request transcripts at certain sections of the hearing needed for appeals. It would also be useful in exposing corrupted judges and attorneys who many of us know like to beat up litigants behind closed doors where no record will show their contemptible behavior. I have been threatened by and spoken down to by judges and attorneys, and if it weren't for brave individuals who recorded these hearings, there would be no record of this behavior. If individuals are willing to act in such a manner towards litigants who are present, who knows what sort of behavior they may engage in when litigants are not present. Let's do right by our citizens of Texas and have this bill pass and encourage greater access to our courts. Thank you, Representative Hall, for this bill.
All right. Thank you. Any questions of Mr. Champagne, members? Not hearing any, thank you.
Thank you very much.
For your testimony. Chair calls Carlos Domain.
Thank you, Mr. Dunn. Carlos Damon. I'm representing myself, and I'm in favor of this bill.
Okay.
Just pretty much, if I'd like to add something to that too, I'd like to see if they can have a verified complaint. Who's ever going to be making that complaint with under the pains of perjury and penalty into that language. A verifiable complaint under the pains of perjury and penalty. That's
Okay.
it.
All right.
Simple.
Thank you. Any questions of this witness, members? Not hearing any. Thank you. Chair calls Julia Hatcher.
Hi, Chair Dutton, committee members. My name is Julia Hatcher. I'm an attorney in Galveston, president of the Texas Association of Family Defense Attorneys, which is a statewide organization of attorneys representing parents and children in CPS cases. We are very much in support of this bill. We believe to protect the due process rights of parents and the Constitution that it is necessary to not only elevate the standard or the burden to probable cause, that the department has to show probable cause before getting what is akin to a search warrant, because that's what's required under the Fourth Amendment. But we also, there was a case that came out several months ago, might have been a year ago now, Berryman, out of somewhere in East Texas, forgive my memory, where that judge said it had to be probable cause and ruled that CPS did not meet the burden of probable cause and dismissed the whole case. So, or that order, and aid in investigations, said it wasn't any good. So we think that that's very important. Also, the no ex parte hearings we think is very important because they don't have hearings right now. They write an affidavit. The district or county attorney or the regional attorney for CPS hands the affidavit with an order to the judge. Sometimes the judge reads it, sometimes the judge doesn't. Signs the order for CPS. And there's no input from the parents at all. It's a complete violation of due process. Parents ought to be able to, at least the parent in possession of the child, maybe not necessarily both parents, but at least the one who they want to investigate, should be able to have a say in front of the court and answer the allegations made by DFPS as to why they need to be investigated. And I think my time's up, so that's about all I have. If you have any questions, I'd be happy to answer them.
Any questions? I think Representative Wu has a question.
Just real quick, I mean, I know we're comparing this to search warrants, but
kind of
does a suspect have a right to have a hearing on a search warrant?
So I have an answer to that because I asked a criminal defense attorney, and at one of our trainings, one of our CPS trainings, we have some criminal defense lawyers there, and I asked because we looked at the upcoming legislation. I said, what is the difference between this and a search warrant? Because a police officer just takes an affidavit to a magistrate and gets a search warrant. The difference is that the police officer has some credible evidence to base their affidavit upon. They've got a CI, they've done an undercover sting, they've got something that they say in their affidavit. Okay, CPS has nothing. CPS has speculation and allegations.
Wouldn't the person who's calling in the report be a CI?
But they're confidential, and
what is a CI?
If they can't, I understand CIs are confidential, but they have a track record with the police department. They're not just some Joe Schmo who called the police department and says, so-and-so did this and this. CIs they're on contract with police departments, and they have a track record. And if a CI is found to not be credible, then that person is no longer a CI. So I do not think you can compare a CI with a confidential reporter to the CPS hotline.
But wouldn't CPS check a confidential reporter and see if they are credible?
You would hope, but I would say no.
Okay.
It's certainly not required of them to do so.
I mean, I'm just, I don't mind this moving towards like a search warrant standard. I don't mind it at all. But I'm just saying if we're going to make it a search warrant standard, let's make it a search warrant standard.
Then they have to have more evidence than what they're showing up with in these affidavits that are just based on speculation.
Okay.
That's all we're saying.
All right. Any further questions of this witness, members? Ms. Hatcher, thank you for your testimony. Chair calls Anton Golokov, who has not been here all evening, and he was testifying for himself, neutrally on House Bill 1086. Chair calls Brandon Johnson.
Brandon Johnson, testifying on behalf of myself. I'd like to move to being for the bill from being neutral.
You would direct us to change your neutral designation to one of your for the bill?
Yes, sir.
Okay, we'll do that with your permission. All right, thank you.
Okay. Yes, like I said, I've been court watching and an advocate, and what's going on in the courts is a travesty. It's appalling, and this legislative body is supposed to be a check and balance on the judiciary and the executive branch. And for the most part, you know, that doesn't happen, but this is a chance to do that. You know, verified complaints and affidavits has been mentioned, but that'd go a long way. And then I think you have to put something in there about the retaliation and the harassment that people get when they confront the almighty state of Texas. Whoever has that designation of being some kind of ad litem, CPS, or whatever it is. There's zero oversight on any of these people except for you folks. And y'all do the best you can. I get it. You know, y'all pass some bills and then nobody pays attention to them. But that's where I feel like it has to change because this thing is getting out of control on every level. And it'd be real nice if, you know, if somehow in this bill you could say all proceedings need to be recorded because as y'all have kind of alluded to, you got lazy judges, you got lazy CPS workers, or they get complacent. Maybe they're not lazy. Maybe they're not doing it in bad faith. But they get in the routine and they become numb, just as some people do looking at their phones to what people say up here. But for the people watching on the TV screen, okay, it would be nice if we could get recordings of all government proceedings. Y'all recorded, the police are recorded, the judges, these ad litems, all these people, they just got carte blanche to do whatever they want, say what they want, put what they want on paper, and then we have to battle it out on the other side. Thank you, Chairman Dutton.
All right, thank you, Mr. Johnson. Any questions of this witness, members? You're not hearing any. Is there anyone else here who would like to testify for? Did you already sign up?
I didn't sign up, but I want to testify.
Well, you have to sign up before you can do that. So, come on, we'll get somebody to sign you up real quick. Yeah, everybody wrote it down. Okay, and if there's anyone else here who'd like to testify but hadn't signed up on the kiosk outside, it's imperative that you do that because we can't let you testify without you having done that. So we'll say that again.
1086.
1086.
Thank you, Chairman.
Wait just a minute. Hold on.
Hey, refresh. Yeah.
Where is it on here? Chair calls Arnold Yan.
Yes, I'm Arnold Yan. I'm representing myself. I'm for this bill. The reason I testify that is I know this bill is trying to prove the accuracy of the CPS investigation report. And even when CPS has finished all the investigation, when they give the conclusion, they send it to the family. And the real experience is maybe none of the committee members know that. If you saw a conclusion and you didn't realize everything reflect the record has been told to the CPS, you want to know what exact the CPS report is, what exact evidence they took. You ask open record request to the CPS. Do you know how long it takes to get it back? If CPS took any action, how long it took back to know what it was the answer were from their reports? Anybody know that? Anybody here know that? I give you an answer were 12 months. So you don't know what they wrote in the report until 12 months later, but for some parents, their children is already gone, got separated. This is how our government operates at this moment. Even when we have every evidence taken, everything recorded, when we try to pull the report, see what has been accurately recorded, it takes 12 months for family to find out the truth. So with all the bills tried to pass, if we don't improve the efficiency of CPS, how they operate that, none of them actually works to help the family. I think we need to make some amendment, adding some time limits requirement regarding everything they produced. Otherwise, no matter how you want anything recorded, videoed, proceeded that, and it's just sitting there. And my experience dealing with government right now is 50% information you told the government, when they write down, it's not what you said. And when you try to pull the records, they will tell you it's not there. I have dealt with CPS before. I'm not under any, the alienation, or I don't own any 1 penny of child support. I'm not under any false allegation, so I'm not a victim here, try to say that, but I deal with CPS before. I report a child abuse case with them, with video presented to them, video, with child being whipped, 3-year-old girls with bloody welts on the back, whipped by close wire hanger. Guys, Mr. Wu probably know that what a close wire hanger is when they whip kids. I present to CPS, CPS closed that, say nothing they're gonna do, and there's no records. Until now, they didn't provide me any records. How they draw the conclusion in Texas when child was abused, whipped with wire hanger, with blood visible on the back, and there's no investigation, nothing has been done. This is how our government operates. I just want to let you know. This is happening right now. I saw other family, kids got taken away just because CPS showed that there's a blue mark on the skin and the kids was gone. So it's like you talk to CPS, it's like a lucky draw. You never know what tickets you got. What Forrest Gump's mother said, life is like a chocolate, right? You never know what taste you got. So when we're dealing with CPS, yes, we'll open a box of chocolate. We never know what taste we got.
All right, Mr. Yan, thank you.
Thank you. And
Thank
I
you.
finish my-
Any questions of Mr. Yan, members? Not hearing any, thank you again for your testimony. Is there anyone else here now who would like to testify for, on, or against House Bill 1086? Not hearing any, the chair recognizes Representative Holt to close.
Thank you, Mr. Chair, for allowing me to bring this bill. I just want to clarify. So this bill, I think, will help families by helping hold the department more accountable, help bring some transparency to the process. Sometimes these orders can surprise parents who felt they were being cooperative, speaking to the investigator, or letting the investigator speak to their pediatrician, and so they don't know what was presented to the judge that led them to ordering an aid to an investigation, and they aren't allowed to be present or even have a record of it. So I think this will help families. So I appreciate you allowing me to bring this bill, and I close.
Thank you. Thank you. It's the chair's intent to leave House Bill 1086 pending before the full committee without objection. Chair hears none. The House Bill 1086 is before the full committee. Chair at this time lays out House Bill 1087 and recognizes Representative Hull.
Thank you, Mr. Chair, for allowing me to lay out House Bill 1087. Currently, when DFPS decides to remove a child from their home, they are required to make what is called reasonable efforts to prevent that removal.
Oh, hold on for a minute. Let me lay out the committee substitute. The chair at this time lays out the committee substitute for House Bill 1087 and asks Representative Hull to explain it.
So this standard for the reasonable efforts is so important that the federal government mandated this requirement in the Adoption Assistance and Child Welfare Act of 1980, where it has continued in iterations ever since. States cannot receive their Title IV foster care entitlement money if they do not make this effort first before removing a child. Removing children from their parents is one of the most terrifying and traumatic events for a child and family. This decision should not be made lightly and is why the federal government requires this effort to be made before that child is removed. It is like tapping the brakes to ensure that all other resources or possibilities within reason were explored and exhausted before a removal is necessary. Since parents often are unrepresented by legal counsel at their first, and some would say most important hearing, it is imperative for the parents, judges, and their current or future legal representation to understand what reasonable efforts were made that the department swears in their affidavit. The Imprint, a youth and family news publication, cites a family judge from December 5th, 2018, who put it this way: the reasonable efforts, no reasonable efforts finding are the most powerful tools given to the courts by the federal legislation. These findings enable the court to determine whether the agency has done its job to prevent removal. He went on to state another problem is that most judges do not carefully address the reasonable efforts issue. They do not question the social worker who made the removal. So 1087 will simply require the department's sworn affidavits for removals and require a court's initial and adversary hearings findings to describe all reasonable efforts that were made to prevent or eliminate the need for the removal of the child in their orders. Some jurisdictions are getting this right and some are not. My bill will help the department be accountable to what the federal law requires. Families deserve more than a simple statement that reasonable efforts were made before they face this trauma. The committee substitute includes language suggested by DFPS to provide consistency in statute and references to the reasonable efforts that must be described. I'd love to mention that this bill was voted out unanimously from this committee last session. So I'm happy to answer any questions and reserve the right to close.
All right. Any questions of Representative Hull, members? Not hearing any, thank you. We'll give you the right to close. Chair calls Jeffrey Morgan.
My name is Jeffrey Morgan. I am speaking on behalf of myself. I am very much in support of this bill. I'm sorry I have to be up here so many times in front of you, but you gave 18 bills, so I figured I was going to get only one shot down here, and I'd try to testify on all of them. I think this bill is extremely important. KP 0241, as Representative Hall said, that this is an opinion from the Attorney General. Standards courts apply when balancing the rights of the state against fundamental rights of parents to raise their children free from government intrusion. When CPS is involved in a case, that is government intrusion. And the opinion from the Attorney General actually gave some of the rights that we have that should be protected. And I don't think we do a very good job of that in many instances. In Section 262-102 of her bill here, and I hope I have the right bill. You keep on talking about the substitutes. I don't know if I have the substitutes or not. So I just printed off the bills that I saw, but maybe that's something that you could clarify sometime. You don't have to right now or anything. But it talks about the temporary orders, the restraining orders, and it basically says that the agency must describe the reasonable efforts that were made to prevent or eliminate the need for the removal of the child as required by subsection A4. And it talks about the reasonable efforts that were made. And it really... Had CPS, when they got involved with my daughter's life, made any reasonable efforts, you would not have seen my face down here once. I've been down here since 2015 because of what CPS has done. I've been down here repeatedly. The state has done this. My daughter was almost killed thereafter. I've not seen my grandchildren now for 8 years. Why? Because CPS got involved, and rather than telling her what took place, they let me take the hit for something that never actually happened. I have a letter here from the Department of Family and Protective Services. It took me 18 months to get this. I had to talk to 2 senators and a representative, and finally, the DFPS wrote and said, well, we saw nothing about this. So it's not just parents that are impacted by this, it's also grandparents. It's also uncles and aunts. And as one person said, when you talk about a situation where there may be parental termination of rights, that is considered the civil death penalty. And we need to be protecting the parents, the grandparents, the extended family, and the children and the grandchildren that are involved as well. Anyway, I thank Representative Hull for this bill. I'm 100% in support of it. This should have been done a long time ago, but it is what it is right now. Anyway, I appreciate the opportunity.
Thank you, Mr. Morgan. Any questions of this witness, members? Not hearing any? Thank you again.
Thank you once again.
Chair calls Taryn Champagne.
Good afternoon. My name is Taryn Champagne. I'm representing myself, and I am for this bill. Throughout history, it has been shown that the state is not a good parent for children. One of the best examples of this can be seen through the Bucharest project that was conducted in Romania. In 1989, when the Romanian dictator Nicolae Ceausescu was overthrown, it was discovered that 170,000 children had been raised in institutions run by the government. Researchers had a unique opportunity to study the effects of institutionalizations on children, or as related to the bill in this case, study the effects of governments raising children. Children that were raised in these government institutionalized situations were found to have delays in cognitive function, motor development, and language. They also showed deficits in socio-emotional behaviors and experienced more psychiatric disorders. Kids who were moved out of government care into fostered care did fare better. However, they lagged behind children in the control group, those who had never been institutionalized. Even when faring better, they still showed lower development of gray matter volume, which were found to have an increased rate of ADHD. Assuming that the foster care parents are stable and will care adequately for the child. Unfortunately, our state has a horrible track record with our kids in our foster care program. In fact, U.S. District Judge Janice Jack refuses to retire as she has found Texas routinely violates constitutional rights of kids in our foster care system. In addition, our foster care system has lost children, and many children have ended up being sexually trafficked. Our state must do everything it can to protect the parent-child relationship. Many parents may not always be the best parent in the world, but the due process clause does not permit a state to infringe on these fundamental rights of parents to make a child-rearing decision simply because a state judge believes that a better decision could be made. If the state wants to assert harm to a child, it may not presume harm, and it must articulate that harm specifically in writing so that the parents can appropriately respond. By making reasonable efforts to prevent or eliminating removal of the child from the parents, the state of Texas will work to preserve the constitutionally protected bond between parent and child and reduce the need for the state to be a super parent. I can assure you the state of Texas is not a great parent and makes poor decisions regarding our future. We must work to remove the undue influence of the state in the private affairs of our parents. And I'm ready for any questions.
All right. Any questions, members of Mr. Champagne? Not hearing any. Thank you, Mr.
Thank you, sir.
Chair calls Carlos Demon.
Carlos Damon, I represent myself, and I'm in favor of this bill. I heard Title 4D in there. I think that's just a ugly, ugly entity. It's called for what it is, you know. I think it's just a child trafficking scheme done to the exploitation of children by some sort of policy, you know, some sort of procedure, statute, code, by way of, you know, theft, extortion, kidnapping. This could go on and on and on. We need transparency. Transparency here. See cameras? Why isn't there transparency in the family courtrooms? And a friend of mine said, you know, there's only two kinds of people who don't like being recorded. And that's a hot and sweaty stripper after working a 12-hour shift, and a criminal. And that's it. Transparency is what we need in these courtrooms. Period. Are you? Any questions?
All right, thank you, Mr. Demon. Any questions? Not hearing any, thank you. Chair called Julia Hatcher. Is she pulling her bill? I know.
Hi, Chair Dutton, committee members. My name is Julia Hatcher. I'm an attorney in Galveston, president of the Texas Association of Family Defense Attorneys, which is a statewide organization consisted of attorneys representing parents and children in CPS cases. We are for this bill. It is true, not only is it in federal law that reasonable efforts have to be made prior to removal, they have to be made to return the child prior to the adversary hearing. They also have to be made prior to termination, the final trial. And this is all currently in our statute. The problem is the caseworkers don't understand what this is. And I can tell you, I was cross-examining an investigator about a month ago at an adversary hearing, and she described the reasonable efforts that were made to prevent their removal. But then I asked her, what reasonable efforts did you make to return the child before this hearing today? And the response I got was wide eyes like a deer in headlights. And I said, did you make any reasonable efforts to return the child before this hearing today in accordance with our statute? Well, no. Okay. Guess what? I won the hearing. Anyway, the point is, they don't know the law. They don't always follow the law when they know the law. And so this bill would require them to actually describe the reasonable efforts that they made in each circumstance. So then they would have to, rather than just saying in their affidavit reasonable efforts were made, they would have to say what those reasonable efforts were. Then when they were cross-examined, they probably would have an answer. I also think it would be a good addition to this bill, maybe in a committee sub, to add the provision about to describe the reasonable efforts prior to termination. And I think that would flow nicely. So they have describe the reasonable efforts prior to the removal, describe the reasonable efforts to return prior to the adversary hearing, and then describe the reasonable efforts to return the child prior to the termination trial. And that's all I have.
All right, Ms. Hatcher, any questions of this witness, members? Not hearing any, thank you. Chair calls Anton Golokov, who is not here, and will be shown as not testifying, but neutral on House Bill 1087. Chair calls Brandon Johnson.
Brandon Johnson, testifying on behalf of myself. I would like to change my stance from on to for the bill.
Okay, with your permission, we'll do that.
Thank you.
We'll change and show you as being in favor of House Bill 1087.
Thank you, Chairman.
Okay.
Okay, I like, this bill is like the gold standard. Every parent ought to be able to just walk into any proceeding and, or deal with any government agent, say, time out right here. Put it on paper, swear by it. And that includes, it says government entity, so I'm gonna assume that means the court as well. Is that not right? I mean, I don't know, I'll have to look into that. But if it's a government entity, you got a judge, and he's on a daily basis taking kids without providing these things. And so, again, there's bleed over in all these bills that are being presented. And right now, the state of Texas mandates absent fathers in order to capitalize and maximize Title 40 funds, just as they're doing that Ms. Hull referenced as Title E. Janice James, I believe it is, the judge who's been all up on DFS and CPS. She knows this is right. The state of Texas is trying to maximize kids. The state of Texas is prostituting our children for federal funds. That's what y'all are doing. And, you know, in all these proceedings, they're just going in there, nothing sworn, best interest of the child, no fault divorce, judicial discretion. It's happening across the board. You're taking kids out of people's lives. And I like the way that Ms. Hull put it. It's the most tragic event for a child and a family to go through. Someone else said earlier that it's the equivalent of the death penalty on the civil side of this. And y'all are doing it for money. You're doing it for money. You got this guy back here in the back, Joel from the AG's office. They're smirking. I watched them back there, smirking about Mr. Carlos talking about the money that's being made off this stuff. And it's wrong. It's pathetic. And you know what? That's when I realized it's not about shared parenting. It's about the money. It's about balancing the budget by taking kids from families in Texas. Thank you.
All right, thank you, Mr. Johnson. Any questions of this witness, members? Not hearing any. Thank you. Is there anyone else here who would like to testify for, on, or against House Bill 1087? Not hearing any, the chair recognizes Representative Hull to close.
Thank you, Mr. Chair, for letting me lay out this bill. Ask for your favorable consideration. And again, this was voted out unanimously last session from this committee. So happy to answer any questions, and if not, I close.
Any questions, members? Not hearing any. Thank you, Representative Hull. It's the chair's intent to withdraw the substitute for House Bill 1087 and leave House Bill 1087 pending before the full committee. Yeah. The chair now lays out House Bill 2715 by hold.
Thank you, Mr. Chair, for allowing me to lay out House Bill 2715. This bill comes from discussions I have had with family violence advocates who have cited the difficulty of prosecuting anyone for tracking or monitoring a victim of abuse or stalking. This tracking can take many forms, whether it's slipping air tags into someone's purse, physically following them or a family member, or by accessing GPS information on someone's vehicle or cell phone, which perpetrators of family violence are able to do through shared accounts. This bill makes clear that tracking or monitoring someone through a vehicle in their possession, through a tracking application on a tracking device, or by physically following the person without consent constitutes harassment if done with the intent to harass, annoy, alarm, abuse, torment, or embarrass. It is presumed that someone does not consent if they have filed a protective order against the actor or filed for divorce or dissolved a marriage with the actor. In addition to adding this to the harassment offense, a provision prohibiting tracking or monitoring would be added to the conditions of a protective order, a family violence protective order, an emergency protective order, as a condition of bond for family violence offenses, and as a temporary restraining provision in place upon filing a suit for dissolution of marriage. I am anticipating a committee substitute to remove the unnecessary addition of Section 5, which are provisions that apply to both parties of the protective order, because this is already added as a provision in Section 6 on the family violence protective orders. Additionally, the term consent will be replaced with effective consent, which is already defined in Chapter 1 of the Penal Code. I believe this bill will protect Texans from harassment by tracking and monitoring, which is done with the intent to intimidate and control a victim of stalking, assault, or family violence. Imagine the stress and fear that someone is always watching what you are doing and where you are going, both online and in public, and the feeling of helplessness when you're told that there is nothing that can legally be done about it. That is what this bill seeks to address. Thank you for letting me lay this out, and I'm happy to answer any questions and reserve the right to close.
Any questions of this, Representative Hall members? Not hearing any, thank you. We'll give you the right to close. We'll open the public testimony at this point. The chair calls Jeffrey Morgan.
My name is Jeffrey Morgan. I am representing only myself. I am testifying on the bill. I think there's positives and negatives with this bill. I think that sometimes the reason that people want to find out what's going on is because lying is so easily accepted in our courts today. And there are people that I know that have done this because that's how they found out that their wife or their husband was cheating on them. And I think that, I don't know. I mean, we have made everything about family violence and stalking and stuff like that, but there are a lot of other issues that are involved with this. So of course you want to protect every victim, but also there are times that the victim supposedly is actually the victimizer and the abuser at the same time. I don't really have anything else to say about this. I didn't really look at this bill that much. I'm sorry. I put my name down to testify on it, but I wasn't ready really.
All right.
Thank you.
Any questions of Mr. Morgan, members? Not hearing any, thank you, Mr. Morgan, for being here. Chair calls Carlos Damon.
Carlos Tim, represent myself. Unfortunately, I didn't have enough time to look at this bill till just one of the last minute ones, so I apologize.
You have to give us your name.
Carlos.
Same thing you do every time you come
I
up
did.
here.
I just didn't say it loud enough. Sorry, I apologize. Carlos Damon, representing myself, and I don't know enough about this bill for me to give information on.
You're
Yielding.
You've signed up as being neutral.
I did, yeah. I thought it was one of the other bills, 897, sorry.
And you want to leave it that way, as being neutral?
That's correct, yes.
Okay, all right. Okay. Oh, thank you. That's your testimony?
Yes.
That's the best one you had all day. Chair calls Anton Golakov. It's right, he's not here. He hasn't been here all day. He's never been here. I don't know if that's a real person. Neutral, anyway, he says he's neutral on the bill. Chair calls Brandon Johnson.
Hey, that was the same time in JCJ on your bill. Which one? On the who registered wasn't there.
What's his name?
Brandon Johnson, represent myself. I'd like to change the, from being neutral to for the bill.
Okay, with your permission, we will do that. We will show you as being for House Bill 2715.
All right, thank you. I think she explained it fine. I drove down here about 3.5 hours to spend my day with y'all. So I just signed up to testify on all the bills. So thank you. I don't have anything else.
That's your testimony?
That's my testimony.
All right.
Everybody has one good one, right?
It's getting better. It's getting better is all I can tell you.
I'm gonna mute you.
Chair calls Briel Backus.
Hello, committee. My name is Brielle Backus. I am here representing the Texas Council on Family Violence, where I'm a public policy coordinator, and we are registering our strong support for HB 2715. Thank you so much for letting me speak. I know it's been a long day, so thank you for having me, and thank you, Representative Hull, for filing this bill. Technology can be a powerful tool for safety, but it is also a tool for abusers to misuse as a way to control, monitor, and harass victims. A study done by the National Network to End Domestic Violence a few years back found that 97% of victims who sought services from a domestic violence program in the United States were harassed, monitored, and threatened by offenders misusing technology. An updated study in 2021 found that tech abuse increased during the pandemic, with almost 90% of survivors stating they are sometimes, often, or constantly surveilled and monitored by their abuser through the use of phones, social media, cars, or even small tracker devices such as AirTags or Tiles. In 2021, 45% of survivors who were murdered by their intimate partner had attempted to leave or had attempted to leave or sought help before their murder. Leaving is a critical time for survivors, exacerbated even more when their safety concerns mean seeking a protective order. Consider a survivor who has worked to separate completely from her ex-partner just for the ex to place a tracker in or on their car without their knowledge. Or consider this other example of a Texas survivor who had to work tirelessly to get OnStar, the vehicle safety system, to remove their ex-partner's access to the account after their separation. And in the meantime, he was able to view all her movements within the vehicle he no longer had access to. HB 2715 would provide support to survivors in this dangerous situation by amending key provisions of the Texas Code to prohibit this form of abuse and stalking. Tracking and monitoring is not a new tactic by abusers, but we could not have known 20 years ago how technological advances would be used to facilitate abuse in the present. Today, when technology is ubiquitous to everyday life, it is obvious why an explicit addition like this is necessary to ensure judges are thoughtful about the safety risk that technology may create for survivors applying for protective orders, whether that be through personal property, like a cell phone, their vehicle, or other means. We appreciate the language of this bill proposed and see it as language that is narrow enough to prohibit behavior, but general enough to include advances in technology we could not predict in the future. Thank you again to Representative Hall for filing this bill, and we respectfully request the committee vote favorably to create stronger protections for survivors.
Ms. Backus, thank you for your testimony. Let's see if there are any questions. Any questions, members of Ms. Backus? Chair is done. Apparently there's not. Thank you for
all.
being in. Thank you for your patience. Chair calls Carl Hayes.
Good afternoon, Chairman Dutton, members of the committee. My name is Carl Hayes. I am speaking here on my individual capacity in favor of HB 2715. I am an associate district judge in Hays County. I am the presiding judge of the family court in Hays County, and I am strongly in favor of HB 2715, and I'd like to thank Representative Hall for authoring this legislation. It is often said that the law doesn't keep up with technology, and in the area of these tracking devices, that's the situation. I routinely hear protective orders in my court, and it is sometimes difficult to fit this type of behavior where someone is putting a tracking device on a vehicle, a tracking device on their person, even putting tracking devices on the kids. It's hard to fit that under the harassment statute. It's hard to fit that under behavior that I can issue a protective order for. I try to do it because it is clearly harassing behavior, but this bill would correct that. This bill would it would amend 4207 to make this specifically an offense under the penal code. It would also allow a court in a protective order to outlaw this behavior, or prohibit this behavior, not outlaw it, but to prohibit this behavior, because it comes up in all sorts of family law cases. The other thing that I want to mention is it will also provide uniformity throughout the state with respect to what goes into restraining orders in divorce cases, because most counties have standing orders and that go into effect whenever a divorce case gets filed. Those standing orders usually track 6.502 or 501 of the Family Code, and right now this language is not in there, but I'll point out to you that the district courts of Bandera, Gillespie, and Kerr County have a standing order, and in their standing order, they have the foresight. They've included placing a tracking device on a vehicle in the possession of the other party, or placing a tracking device or tracking software on the mobile telephone or electronic devices of a person or party. So that would allow basically every court to look at this, see it in the statute, and put it into their standing order, because again, this comes up in more instances, and sometimes there's not bad intent, but in a lot of instances there is bad intent. And I'll yield to questions if you have any.
Yeah, thank you. Thank you, Judge. Let me ask a question.
Certainly.
I know on some phones, and I'm not too tech savvy, but some phones have location services on it that'll tell you where somebody has been. Would that be caught up in this?
And that's my understanding. It would cover this because we've had that. We've had people where either the husband or the wife is keeping track of the other party, and it does get into the range of domestic violence, because how would you like it if you knew that somebody was keeping track of every place that you went and was keeping those sort of tabs on you?
Well, it wouldn't bother me. I don't go anywhere.
Well put. Well put.
Representative Lopez.
Yes.
Well, I know with cell phones, the telephone companies allow people to have family packages. So, and on there they have family packages for their children, and so parents are able to monitor their children, whether they're underage and they have a vehicle that they're using that's a family's car, or just to be able to make sure that their kids are safe and that they know their whereabouts. So how do you feel about that? Would this bill affect parents that want to monitor their kids?
No, I don't believe so, because it's the intent behind putting the tracking device on there. And also, like, for example, just using the language out of what the standing order is in, which is not the language of the bill. It's putting it on the other party and not on the kids. And if there was a concern about that, I'm certain representatives that could be straightened out to make it to leave that as carve that out as an exception, so that if parents wanted to have that kind of tracking software for their children, it wouldn't fall under this.
Okay, because maybe I'm not seeing this correctly, but it's not specifying to spouses or, anything like that. And so that's my concern, that what if a parent does it and then a child comes back and say, well, there's a law against what you're doing, Mama. You can't be following me. Because you know how it is right now, nowadays. Some kids say, I'm going to call CPS on you, or I'm going to call 911 on you.
Right. And with regard to the 4207, there's an intent requirement in that, which is the penal code provision. In the protective order section of it, where the court can order that you can't do that as part of a protective order, it would only apply if the children were the subject of the protective order. And it would prohibit, say, if it was the protective order was against the mother, and in that instance, then the mother and it was protecting both the father and the children. In that instance, then it would clearly apply that they couldn't use the tracking for the children. But that's because the children would be subject to the protective order.
Okay.
That's all. Thank you, sir.
Any further questions? Yeah, wait. You can't just, this is not that. Not the sing-along. Karaoke's on Thursday.
It's actually today.
Late Thursday, though.
Can you just?
Yes. Any other questions, members?
All right, thank you.
Thank you, Judge. Thank you. Is there anyone else here who would like to testify for, on, or against House Bill 2715? Chair hears none and recognizes Representative Hull.
Thank you for letting me lay this bill out. And to clarify your question, and like the judge just explained, it has to be with the intent to harass. So it wouldn't apply in those situations with parents tracking their kids when it's not involved in this sort of situation. But if there's any other questions, I'm happy to take them. And if not, I close.
Okay, all right, thank you. It's the chair's intent to leave House Bill 2715 pending before the full committee without objection. Chair hears none, so ordered. Chair lays out House Bill 461 by Representative Smith.
Thank you, Mr. Chairman. General Counsel. Good to see y'all. I think we're going to be able to have a sing-along on this bill. This is a real simple deal.
If you hurry.
We'll keep it within the rules. Keep it within the rules. Chairman, the current adoption process is very expensive, as you know, and time-consuming for prospective adopted parents. As requirements for individuals who do adoption evaluations have increased, we have seen a decrease in the number of people offering these services. As a result, for instance, in Grayson County and counties similar in size, we are dealing with a shortage of evaluators. This increases the time it takes for an adoption evaluation to be completed and ends up driving cost up. HB 461 seeks to alleviate the cost and lengthy time frame of this process by allowing the court, in a suit for adoption that is uncontested, to waive the adoption evaluation requirement for prospective adoptive step-parents. Many times the children involved in these cases have lived in the step-parents' home for many years already. The bill still requires a review of investigative records of the Department of Family and Protective Services, if there are any, and any criminal history record information maintained by the Department of Public Safety. I will tell you that I've had an opportunity, Mr. Chairman, to have some conversations with a couple of stakeholders who have given me some information which I think will help make this bill better. And I hope to have you a little bit a substitute regarding that at some point. But I'd be glad to take any questions on this bill, and I'd reserve my right to close.
Any questions of Representative Smith, members? Not hearing any, we'll give you the right to close.
Thank you.
Let's see. Chair calls Jeffrey Morgan.
Can I withdraw my testimony?
No.
Do I need to come?
Wait, you can't testify from back there ever.
Oh, that's okay. No, I
No,
don't wanna-
no, you're still testifying. You have to come to the mic.
Okay, great.
Hey.
I don't know about the procedures.
What? No, you got.
My name's Jeffrey Morgan,
All right,
representing
there you
myself. And I am going to not testify on the bill. I don't know what the substitute is. Like, he's mentioned a word that I did not hear before. My concern was about the step-parents, and when you said uncontested adoption, I'm assuming then that if there are step-parents involved, that it would be just what you said, uncontested. My concern was that I've seen times when one parent wants to have another step-parent adopt the children and erase the original father or mother out
You
of
were
life.
neutral on the bill, though, right?
I believe I was neutral. Yes, I was neutral, but that was just my only concern. That was it.
All right.
Is that good?
We'll just assume that's neutral.
Okay, good enough.
All right. Thank you. Chair calls David Simpson.
They just registering on all this shit.
Mr. Chair, hi, David Simpson with Harris County Domestic Relations Office. I'm asking permission to change my position to neutral and to not offer any testimony.
Okay, we're showing you as being against, but you want to change it to neutral?
Yes, sir.
Okay, and we'll show that you testified, not testifying.
Thank you.
All right. Chair calls Carlos DeMine.
Carlos Damon, representing myself. I'm in neutral position. Is that correct?
Yes.
Okay. Just make sure. Yeah, the adoption process is very lengthy. I know because I come from background of the adoption process, and I just want more interpretation of the process for the guardian ad litem that's going to be there, and for the judge, and for both families to be there during that whole process, because it's very, very cumbersome. If one party's not there, one party is. If everybody's there all at the same time, everybody usually comes to an agreement faster, quicker. That's it.
All right. Thank you, Mr. DeMine. Any questions of this witness, members? Not hearing any, thank you. Chair calls Anton Golohob, who's not here, will be shown as neutral on House Bill 461. Chair calls Brandon Johnson.
Brandon Johnson, representing myself. The only question I had.
Neutral on the bill.
I'm neutral.
Okay.
But I mean, I know I'm here to testify, but my question was, if the court shall evaluate the performance of an adoption evaluation to evaluate each party who requests the termination of the parent-child relationship, I guess this bill kind of takes care of that to where you don't have to. I'll switch my vote to for the bill. I mean, it simplifies things. My concern was I didn't want to have some guy being
Do you
interrogated.
want us to change it or not?
Yeah, let me back up. Change the bill
You want to change
to
it
for the bill.
to show you are for it rather than being neutral?
Yes.
Okay, with your permission, we'll do that. And now we have you in our system as testifying for House Bill 461.
The concern that I had is just somebody who was voluntarily giving up their rights to be interrogated by a custody evaluator. As long as that was being done or done away with. So I'm just hoping I'm understanding the bill properly.
All right, thank you.
Is that right?
Any questions of this witness, members? Not hearing any, thank you. Is there anyone else here? Oh, I'm sorry. Chair calls Christy Bradshaw Schmidt.
Good afternoon, Representative Dutton. It's good to see you back here, members of the committee. My name is Christy Bradshaw Schmidt. I am testifying on House Bill 461, and I am neutral on the bill. I am also one of the stakeholders who does adoption evaluations, who's been talking to Representative Smith, because I do adoption evaluations. So I'm happy to answer any questions, but I think we're in a good spot on where we are. So if I can answer any questions, I'm happy to. Otherwise, thank you for your time.
If it's an agreed adoption and it's done by the step-parent, you don't have any objection to that, right?
With the changes that we're looking at making, I have absolutely no objections.
Okay.
It's just a couple of tweaks more than anything else to
Right,
make sure that we don't have to come back and see you again.
All right, okay.
Next session.
All right, thank you. Any questions of Ms. Schmidt, members? Not hearing any, thank you.
Thank
Christy,
you.
good to see you. Chair calls Dr. Aaron Robb.
Good evening. I guess it was good afternoon when I was here before. Dr. Aaron Robb, testifying on House Bill 461. I am neutral on the bill. I'd like to thank Representative Smith for talking to some of us and sorting out. Over the years, this committee has worked on various issues with CPS records, making sure those are obtained in a timely way and in a way that's cost effective for both the state and parents. And I think we're headed that way again because unfortunately the department has spent a lot of time creating completely unnecessary hurdles for step-parent families who are adopting, even in contested cases, many unnecessary hurdles, but certainly for the uncontested cases that this is intended to target. And I think the tweaks that are going to be written in will fix some of the technical issues we ran into with how would that actually work in practice. So unless there are any questions,
All right.
thank you.
Any questions of this witness, members? Not hearing any, thank you, Dr. Robb. Chair calls Tammy Axelson.
Dr. Axelson had to leave.
Okay, she will be shown as not testifying but neutral on House Bill 461. Chair calls Judge Carl Hayes.
Good evening, Chairman Dedd, members of the committee. My name is Carl Hayes. I'm testifying in favor of HB 461. I'm testifying in my individual capacity, but I am the family court judge in Hays County, and I hear the majority of the agreed upon adoptions that take place in Hays County, and this is a godsend to do this because what happens a lot of times is I'll have a step parent that wants to do an adoption. They have to hire an attorney, so that's a cost. I will waive the appointment of an attorney ad litem, a guardian ad litem, a representative for the child in a step-parent adoption. But right now, the statute says I have to order the adoption study. That's $500, $600, $700, sometimes $1,000. I'd much rather that money, because I've been on the bench for 4 years, been doing dozens of adoptions. the report never comes back with anything other than this is a great idea. And I'd rather that $1,000 go to a college fund. I'd rather that $1,000 go to help the family as opposed to just being a cost that's involved. We've got a parent and a step parent that's stepping up saying, I want to be legally responsible for this child. I want to make this completely legal, and we're putting hurdles in place of in front of these individuals. I want the ability to waive it if I deem that that's something that needs to be that should be done to save the cost. And I want to thank Representative Smith for authoring this legislation, because I think it's going to help and allow courts to do that, and it's going to eliminate the time issue, and it's also going to eliminate an expense that's almost every single time, and every time that I've dealt with it, it's been an unnecessary expense.
Thank you, Judge. Sometimes the problem we cure, at least the solution is worse than the problem.
Yes.
And in this case, that's probably the case. Any questions of the judge members? Not hearing any. Thank you.
Thank you.
Thank you for your testimony. Is there anyone else here who would like to testify for, on, or against House Bill 461? Not hearing any, the chair recognizes Representative Smith to close.
Thank you, Chairman. On the bottom of page 1 there, you'll see the court has reviewed investigative records of the department. You may be wondering how in the world that you have investigative records if you're doing just a step-parent adoption. Well, a lot of times, whenever you have someone do a family evaluation, they'll go look to see if there are records, and they'll come back and they'll say, the record is that there's no record. Okay? And so that's what you get with the family evaluation, is sometimes that they do that for you. In this particular situation, what we're going to do is, in a step-parent adoption situation, the court has the discretion. He can still order one. It's may. But he has the discretion to not do that. The question is, and I think what you're picking up on from the testimony is, how do you, if he says, I'm not going to have an evaluation, how you get him the records from CPS, or which could be a no record. That makes sense to you. And so we're trying to work. That's one of the things we're going to work on, get back to the committee on it. And I just really appreciate you. If you have any questions, be glad to take those.
All right. Any questions of Representative Smith, members? Not hearing any. Thank you. We're going to.
Yes, sir. Thank you.
The chair's intent to leave House Bill 461 pending.
Thank you.
Before the full committee. Chair at this time lays out House Bill 1695 and recognizes its author, Representative Jones.
Thank you, Chairman Dutton and respected committee members. I appreciate the opportunity to speak to you about House Bill 1695, which prohibits parents who are up to date on child support payments from being punished for late payments caused by third-party errors or uncontrollable circumstances. This would be a change in the family code, and I've styled this bill. It's not in there, but for me to remember it, I call this the not my fault default. HB 1695 protects parents from unfair punishment, encourages compliance with child support orders, and ensures fairness and equity. In doing so, courts may not hold the respondent in contempt for failure to pay child support if the following two requirements are met. Number one, that at the time of the hearing, the respondent shows evidence that the respondent is current in payment. And number two, that the respondent shows evidence that failure to make timely payment was not the respondent's fault. This bill was inspired by something that happened in Houston. It was on the news. A guy named Cliff Hall put himself on child support, and he paid it to the registry so that there would be documentation of it, because he and the baby's mother didn't always see eye to eye. So he puts himself on child support, he gets another job, he makes more money, and there's an agreement that he's going to now pay increased child support, which he is fine with because he now makes more money. He's not a lawyer. The lawyer in the case for the child's mother actually they agreed that she would draft the order, because that happens often when they're lawyers. You agree who's going to draft the order, memorializing the agreement, and they file it. Then what happens is that wage withholding order. So you also have to draft that, where you tell the employer of the person who is the obligor that they have to pay. They take out so much out of their check. Well, in this particular instance, there was a mistake with the employer of Cliff Hall, and they took out random payments, and so he ended up being in arrears, in default, through no fault of his own. When he learned that he was in arrears, he was trying to figure out what's going on. This automatically comes out of my check, and rather than have any problems, he paid the arrearage, and then he went and worked it out with his employer to figure out why. Well, by the time the hearing took place, he was current on his child support payments, and he also had proof that the reason that he was ever in default was because his employer didn't take out the right amounts. But the law as it currently stands doesn't make any exceptions for that. So as a result, he ended up having to be locked up. He was found in contempt because when it was filed, he was in fact in arrears through no fault of his own. And he went to jail for 13 days. He lost his job. In fact, he ended up losing 2 jobs. He got set back. He wasn't able to pay child support because he lost the job, and he ended up just put him in a really bad place. Mr. Hall actually wanted to come and testify today, but it ended up being really late and he couldn't do it. He would have to come from Houston. And so this bill ensures that parents, and let me also say this, the court understood that he was current and that it wasn't his fault, but the court was like, there is no remedy for this. The law doesn't make an exception for this, so we have no choice but to lock you up. So this bill ensures that parents who have attempted but failed to fulfill their child support duties are not held in contempt if non-payment is due to factors beyond their control. This bill will establish trust in the system and further equity and fairness. Moreover, this bill may create improved results for kids and aid in the reinforcement and reunification of families. There was also another case in Houston where we had Hurricane Harvey in Houston, and everything was shut down. And one gentleman was unable to pay because of what happened with Harvey. He too ended up getting locked up. He ended up getting current, but there was just nothing that allowed that you are late because a natural disaster happens. So all I'll say to you is that this is a much needed bill, because when someone loses their job or they're locked up, there are a variety of things that happens. But if you're locked up, you can't earn a living, you can't pay your bills, and it sets you behind. So I'm happy to answer any questions, and I reserve the right to close.
Thank you, Representative Jones. Members, any questions? No? All right. At this time, we'll take some witness testimony. Chair calls up Cody Taylor. Cody, just remind you, give us your full name, who you represent, on, for, or against.
I'm Cody Taylor. I represent myself, and I'm for the bill, 100%. I think that anybody who can show a record.
Hold on. Did you register against the bill? We have you registered against the bill.
It might have been an error on my part, but I am for the bill.
You are for the, so we have your permission to change it.
Absolutely, 100%. Might have been there's several bills, so.
Okay. Go ahead. I'm sorry. Go ahead.
I think that anybody who can provide an accurate record, a detailed record, or especially something that goes to a government agency, and for heaven be it our communications between courts and courthouses, also the agencies for the state, they don't communicate sometimes daily or even monthly, and they get behind, and there's a lag. And then all of a sudden somebody decides to take a vindictive measure that forces another parent to now shuck out thousands of dollars with attorney's fees because most of them don't know the law, or a pro se litigant who can't afford it, and then they're put behind the 8 ball immediately. So with this, if you can show the record and you can absolutely prove that you've paid what you needed to pay, then I don't think that anybody should be held accountable, much less go to jail and potentially lose the ability to move forward with their lives. The other side of that too is that this happened in my case. The paperwork was never filed. There was actually never a case on record. They filed multiple points in their contempt against it. We actually had to bring an individual in from the agency, and they actually provided the document that said that there's no case open, which when it was originally filed, they didn't do the proper paperwork and it was never filed. They were trying to have me arrested, thrown in jail, and yet we had to have an agency state that he's never been behind, here's an accurate record. But if we didn't have that, I would be in that man's position, and I would have been affected by that. So I'm very much for this. I think that this should have been done a while back, and I think it's common sense as well. Judges should be able to see through that, but most don't. They don't do their due diligence, and a lot of them are lazy. So thank you.
Thank you, Mr. Taylor. Appreciate it. Members, any questions? If not, chair calls Jeffrey Morgan. Mr. Morgan, once again, full name, who you represent, on, for, or against.
Name's Jeffrey Morgan, representing myself, and I am for the bill, completely for the bill. Thank you for the bill. And I've never dealt with the child support situation at all from a personal level, so I speak a little bit out of ignorance here. There's a couple of things that I want to comment on at the same time. The court may not find a respondent in contempt of court for failure to pay a child support if the respondent appears at the hearing, and he goes on and on and on. I've talked with a lot of people that have gone through just this, and they have to take time off of work. And it's not just been because there's been tracking issues. Sometimes it's been because of the software issues. And so you have this electronic system. Where I work, electronic system is supposed to be accurate. When it comes down to the child support system, it's not always accurate. And they've had to go and dredge up records that they have to show that they were completely on time. And I've seen their records. And I think that in some situations like this, perhaps we ought to be putting some type of retribution or reparation upon the state for the damage that are caused to the individual. It's either taking them money and time off of work, or in the case that Jolanda was mentioning right there, person loses his job. And the whole thing about being thrown in jail for contempt of court, Article 1, Section 18 of our Texas Constitution says imprisonment for debt. No person shall ever be in prison for debt. I realize we've done the semantic games. We call this imprisonment to debt contempt of court. But if you look at the Child Support Enforcement Program, the basics, this comes from the Congressional Research Service. Originally, the child support system was designed to reimburse the state for the costs of child support. It was a welfare recovery program. So I have a little bit of a difficult time with seeing the draconian punishments that are being put upon people when sometimes the errors are as a result of the state or record keeping or something like that. But I think that this type of a bill would really help those people in that situation. I would, again, like to see perhaps some teeth against the state, because if the state is making some mistakes, why do the individuals have to suffer for that? It just seems to be only right.
Thank you, Mr. Morgan. Members, any questions? Not, the chair calls. Thank you.
Thank you.
The chair calls Taryn Champagne. Mr. Champagne, your full name, who you represent, on, for, or against.
My name is Taryn Champagne. I represent myself, and I am big supporter of this bill. I am for this bill. The state should work to prevent individuals who to prevent harm to individuals who have tried to pay their child support. The Office of the Attorney General's child support tracking system is a perfect example of how errors like this can show up. First of all, parents who are even joint managing conservators are listed in their system as absent parents. I've had this conversation with the Office of the Attorney General. This can be in spite of being active in the child's life. There's also a chance that the system has not tracked those payments properly. In 2019, I was involved in a head-on collision with a drunk driver. The state of Texas then proceeded to place a lien on my insurance payments that were to pay for my medical expenses. In the words, and I have this email from the Office of the Attorney General, they stated, "You had a case in our system since 2015. However, the order, for whatever reason, was not entered on this case until last month in November. This was November of 2019. As you have been sending payments before this order was updated, these payments needed to be moved to credit the new cause that was updated." I did not have any sort of contempt meted out against me, but Let me finish this. While this process was being done, you temporarily showed an arrears balance due to the fact that the payments had not been fully credited yet. As the lien process is automated when you made a claim and the insurance company checked for child support arrears, which they are required by law to do so, it saw you at that time in arrears before your case was fully updated. This was despite the fact that I had been paying my child support and I was up to date. It was an automatic withdrawal. Our system is broken here in Texas when it comes to child support, and no better illustration of this can be found than the money pit that was the T2 system that ended up costing the state $367 million. There are a multitude of reasons why child support may not be credited, but the state of Texas should work to prevent finding these people in contempt when it is of no fault of the child support obligor. And with that, if there are any questions.
Thank you, Mr. Champagne. Any questions, members? Thank you very much.
Thank you very much, Representative Jones.
All right, at this time, Chair calls Carlos Damon.
Carlos Damon. I'm representing myself, and I'm for this bill.
Thank you.
Oh, man. Oh, man, where do I start? Well, I think this bill clearly helps out what's called the non-custodial fathers, because let's face it, 92% of the fathers are what's called a non-custodial parent. As we've been labeled that by the state of Texas. But every day I come home, or on the weekends, every other weekend, my daughter does not call me, hey, non-custodial parent. She calls me dad. That's not in the paperwork. And I've been labeled a non-beat, non-custodial parent from day one, unbeknownst, because my lawyer didn't tell me that I was an absent parent from some public policy, 92 through 107, I believe. So, yeah, it sounds to me like this is still a money marketing scheme done at the exploitation of children, period. By way of extortion, theft, and kidnapping. Tell me I'm wrong. I yield.
Thank you, Mr. Damon. Any questions, members? If not, the chair calls. Thank you. The chair calls Robert Garza. Mr. Garza, of course, tell us your name, who you represent, on, for, or against the bill.
Robert Garza. I'm a parent, and I'm for the bill. Actually, I came up to testify on some other bills, but this one kind of struck me because it just happened to a friend of mine. She was a mom. She's had a primary parent. She was the primary parent for probably 3 years. She just got arrested about 4 months ago. Came, arrested her, said that she was for child support. The system had got it wrong. When she was the other parent, she had made her payments, but somehow it got mixed up in the system. She ended up in jail, stayed for several hours, and the reason I knew her husband came for my help to see if he can get her out somehow. Got a bail bondsman and everything else, but anyway, she ended up staying pretty much the whole night, and so when the system gets it wrong, I think laws like this can help out a parent. So anyway, so my testimony, I'm for the bill.
Thank you, sir. Members, any questions? If not, the chair calls. Thank you. The chair calls Brandon Johnson. Mr. Johnson, I remind you, give us your full name, who you represent, on, for, or against.
Brandon Johnson, represent myself, and I would like to change it from neutral to for the bill.
Okay, so we have you neutral right now, and you're giving us permission to put for the bill. Is that correct?
Correct.
Okay. Go ahead.
Yes, passage of this bill will definitely be an improvement. Ideally, it would be amended to say that there must be proof the respondent was not mandated absent by a judge without specific findings or by way of fraud, threat, duress, coercion, or intimidation by any attorney, Office of Attorney General officer, or any industry personnel. As we've stated, 93% of the time, judges are handing down boilerplate orders placing men in debt by mandating them absent. Now, it's worth mentioning that these 93% of non-custodial fathers are absent parents, as Terrence Champagne just testified. In the Attorney General's own system, we're labeled absent parents, and for good reason. For good reason. And this is because when the Texas Family Code was written in 1995 to capitalize on the windfall profits from Title 4D, they knew that Public Law 104-193, which was passed at the federal level in 1996, would be a windfall to the state and the counties via these federal reimbursements, the 66% reimbursement, along with all of the income streams, the incentives that were provided that amount to, when you add it all up, between $800 and $1 billion to the state. In that bill, 104-193, it said that the state must, in their, and you'll see this, if you look at the bottom of all that, where it says amended, or whatnot, they said you have to amend absent parent and make it non-custodial. They wanted to shield the reason for what they were doing. And so this bill, but I just want to mention this as well. The Title 4D is a business operating it's a federal franchise operating within the Office of Attorney General, and it routinely engages in predatory practices for their insatiable appetite to maximize these Title 4D funds. And they routinely hold payments to trigger arrearages and interest to draw on funds held in those accounts by law. That's in the statutes. They will hold federal tax refunds up to 6 months to maximize those interest payments. Now, I don't know. I've never received child support, but I do think that you get this animosity going on sometimes between parents because the mom's saying, where's the money? And the man's paying the money, just as the representative has testified to. And he's saying, well, I paid in. They took it out of my check. And the next thing you know, he's in cuffs. This is predatory collection practices, and it's appalling to me. So thank you, and I please hope that you pass this bill.
Thank you, Mr. Johnson. Members, any questions, Mr. Johnson? Nope.
I'm happy to answer.
No. Okay, we got a couple.
How could the state have known in 1995 what the United States was going to do in 1996?
That is a very good question.
I think so.
No, and I appreciate you asking that. Now, God rest his soul, Toby Goodman's dead now. He was chairman of this committee, and he knew that you had to have 50-50.
He knew what 435 members of Congress and 100.
Look.
Was going to do
Let's back. Well, I don't know firsthand exactly how he knew, but it's circumstantial evidence. You pass, when you read throughout, and I've printed almost 15, 16, probably more pages now of the Texas Family Code in PDF format. The Family Code, the Texas Family Code was written in 1995. Up to then, you had a hodgepodge.
That's not correct.
Well, we can, I don't mind discussing it, but it was rewritten to capitalize on those funds. You had, and I'd have to go back to the record, but we had one of the guys I'm in a group with, he had a specific conversation, not paid. He calls up Toby Goodman and talks to him about this. And
my question is how did Representative Goodman know what 435 members of Congress were going to do the following year? It's impossible.
Well, it's impossible until you go read, 261, I believe, which addresses the whole Title 4D agency. And you had the counties. You had every county, or I don't know about every county, but you had a lot of counties coming down here saying, hey, you got to pass this or we're going to lose out on these funds. We know that there are contracts between the counties and the Attorney General's office. We also know that this was mandated by, I don't know if Justice Heck was Chief Justice at the time, but Toby Goodman said, hey, look, the Supreme Court, this was what he told my buddy. He said, the Supreme Court of Texas calls me up. He said, you cannot do you can't do equal parenting, because at the time, Toby he wanted to do an equal parenting bill. But they said, you can't do that. You have to do a standard possession order to maximize those funds.
What does equal parenting mean to you?
Well, equal parenting means that I have equal access. I have equal eyeball to eyeball time.
What did Toby Goodman and Chris Harris do in 1995? They passed a presumption that joint managing and conservatorship was in the best interest of the...
Oh, exactly. Yeah, for the Title 40 funds.
No, it had nothing.
Yeah, they did. Look at the evidence.
I was here. I worked here.
You were here. Okay. Well, yeah. But why didn't they say equal parenting time? Because you would have lost out on, you're talking about 20%, and then it goes up from there.
I thought you said this law you were talking about passed in 1996.
Oh, yeah, Public Law 104-193. How could they not? When you had the Supreme Court...
Because the law wasn't even in effect. You just...
Oh, exactly. But yet, you're right on that. You're right on that, Mr. Cook. But circumstantial evidence says if you have all these incentives and they mesh, it's like they were given the playbook. They were given the playbook, and then they wrote this into the family code because they didn't want to miss out on 1 year of those incentive payments.
This obviously doesn't make sense.
I know it.
That's all the question I have on that.
No, and
next question I have is you keep saying absent versus non-custodial parent. So what's your beef with that?
Well, because in that law, it said you have to substitute, and a substitute is what? Sugar for sweet and low? I mean, I don't know. It's the same thing. It's a sweetener. You call it one for the one, but it's the same. So you say, we're going to take out absent parent because who's going to volunteer to be an absent parent? But if you say, I'm a non-custodial, I'll be a non-custodial parent.
You know what that means? Like custodial, so you have three different things. We have custody, we have possession, and we have support. So when we say non-custodial parent, all it means is you're not the custodial parent. You're not the primary parent. So that's what NCP means, is non-custodial parent. That's all it means. It doesn't mean you're absent. It doesn't mean
if it's a substitution, if you go back and you say, what's the substitution?
NCP means non-custodial parent. That's all it is. It's not.
Well, and sir, you can say that all you want, but I'm talking about in practice. We're a second-class citizen. The guy's getting locked up because he's a non-custodial parent arbitrarily.
You read the bill?
Yeah, I just did.
Okay, so show me where it talks about the Attorney General's office in here.
And that's my whole point in bringing up all this backstory.
It's not in here, right?
Well, the reason that I'm mentioning this stuff, because it is pertinent to the bill, you have to mandate parents absent.
You made the mistake in the case that Representative Jones is bringing before us. Do you know who made the mistake?
Which mistake?
The mistake that resulted in this person being incarcerated. I know that you and...
Well, what I'm saying is that the Attorney General, in their insatiable appetite for the money...
What I asked you is, a very simple question. Do you know who made the mistake in the instance that Representative Jones has brought to us this evening?
I honestly don't think it was a mistake.
Well, okay. Well, she gets an opportunity to close in just a moment, so I want you to listen closely when she reiterates to you that this gentleman's employer made a mistake and did not take money out and send it to the Attorney General's office so that the custodial parent could be paid. That's why he went to jail. It wasn't no fault of his. It was the fault of his of his employer, not the state of Texas, and not the person that was incarcerated. It was a mistake of his employer.
That was an isolated incident.
Well, that's what this bill is about, sir. That's what we're talking about.
And that's okay, and that's fine, but I'm just saying that that's an isolated incident, that this goes on day in, day out.
That's what's in y'all's head.
Oh, well, it's in your head, sir, that you want to not believe that the whole code dealing with Title 4D was written in 1995, and in 1996, 96 at the federal level. How could it be? Yeah, we do. It's a federal franchise. It's word for word. That's why else would you change it from absent parent, which it was an absent parent prior to 1995 in Texas. And then after, all you did was write in federal code. That's all you did.
All right, thank you. Thank you, Mr. Johnson. Any other questions, members? All right. Chair calls Lynn Kamen. Lynn Kamen twice, Lynn Kamen 3 times.
She'll be shown as for.
She'll be shown as for the bill.
Anton, just call Anton
Anton Kolakov. I know we've called him a couple of times. Anton Kolakov, twice, 3 times.
Representative.
All right.
Representative Jones Clovis.
All right. That takes care of all of our registered witnesses. Anybody else want to testify on, for, or against? If not, Representative Jones, if you can come up here and close.
Be right there, Chair.
You know, I forgot when I was up here before to tell you that I actually practice family law. And I've been a member of the family law section of the bar since I think 1998, if my brain goes back. And so, for the record, I represent moms and dads and guardians. This bill was not designed for either a mom or dad. I mean, one side or the other. This bill was written because if you're doing what you can do to pay your child support, because children need money to be able to have the things that they need, and it's not your fault, then you should be able to present evidence to show that it's not your fault. In this particular case, Representative Cook, it was the employer who made the mistake, but I don't even believe that was intentional. I just think it was an oversight. So, look, I saw a problem. I tried to fix it. I don't know if there were going to be all these speakers in favor, but hey, that works. But thank you for allowing me to lay this bill out. Thank you for your time. I know it's late. If you have any questions, I'm happy to answer those questions now. And if you have none, then I respectfully request that you vote in favor of HB 1695. Thank you.
Any no questions? All right, if there's no objection, HB 1695 will be left pending. Thank you, Representative Jones. Appreciate it. At this time, the chair lays out HB 4062 and recognizes Chairman Harris to explain the bill.
Thank you, Mr. Chairman and members. I know it's been a long day of hearing for y'all and for everybody here waiting to testify, so I'll make my layout pretty brief, but I want to start by making it clear that this bill, the idea for this bill and the need for this bill was brought to me by a constituent. And I know that especially you on this committee understand how critically important it is to get the facts right on cases where child custody are involved, and make sure that we do everything we can to make sure that the facts are disclosed, that a decision can be made in the best interest of the child. And so with that, House Bill 4602 amends the Family Code to require a child custody evaluator to create an audio or video recording of each interview an evaluator conducts with a child who is the subject of a suit seeking conservatorship of, possession of, or access to a child, unless the interview is conducted in the presence of all parties to the suit. So with that, Mr. Chairman and members, I thank you, and I reserve the right to close, and will defer to witnesses to speak for the bill.
Any question, members? All right, thank you. This time, we'll be calling up Robert Garza. Mr. Garza, full name, who you represent, on, for, or against?
Robert Garza. I represent myself. I'm a parent, and I'm for the bill. I think that there should be full disclosure, especially when it comes to children. I think it's, full transparency is the best. I went through a couple of home studies, psych evals, where they questioned the children. And I think it's better that, they have full disclosure. That way nothing can be taken out of context or anything else. Even when our judge talked to the children, there was a transcript that was made. And So I think full disclosure is better. Thank you.
All right, thank you. Any questions, members? Okay, if not, thank you very much. The chair calls up Cody Taylor. Once again, name, full name, who you represent on for or against.
Yes, sir. Cody Taylor. I'm for myself, and I am the one who crafted this with Mr. Harris. Let me give you a small scenario. I got 3 minutes. I'll talk fast. Small scenario. You're a parent. You go into, you already have a child custody case, or you just have started a divorce that involves children. And there's allegations. So a judge does what he does best. He relies on professionals. He orders a child custody evaluator to be a part of your case, person that you may have never met. But here's the problem, is that child custody evaluator may have sat in that courtroom 100 times. One time, never. Doesn't matter. You go through a 6-month process, and they visit with your child without you present. They visit with you and your child together with the other parent, whatever it may be. Everything goes fine. You talk to them for the last time, and they say, hey, man, everything seems to be good. I don't have anything. I'm not bringing anything to light. They sit on the stand, and they say, well, through everything that I saw, everything that I was talked about, we're going to pick this parent, parent A, to be the primary custodial parent. Wait a second. Why? What's the issue? Well, the child made this comment. The child said this. We had multiple conversations, and nothing was brought to light. Well, it was the mannerisms. Every time I asked a question about a parent, they would look for the door. They would look to see if they were being watched. Well, here's the thing. I have the audio recordings of a mental health professional that sat there on the stand and testified and lied under oath, committed aggravated perjury. And her audio recordings were leading the child down a path, Golden Brick Road, to make sure that child said exactly what that the person wanted them to testify to. Here's the issue. Professionals are humans. They make mistakes. I don't think anybody here is going to argue with that. We do at some point, right? The problem with it is that these professionals, child custody evaluators, are the ones who get to make the decisions of where the child's going to go. Those mistakes can set people back tens of thousands of dollars, and in my case, 3+ years of not being able to see my child. 3+ years. My daughter was subjected to multiple mental health professionals. And in a case underneath 107 of the Family Code, any county that has under 250,000 residents, a mental health professional, any mental health professional that meets certain requirements can be deemed a child custody evaluator. Those child custody or mental health professionals sit in these courtrooms like Wild Wild West. They're hired guns to the highest bidder or the first person who gets in their ear. This bill sets forth at least a point where I can at least go back and say, what day did this occurrence happen and what did they say? I can at least point this bill into, or at least point this video or audio into, the child said this or they did this. Wait a second. On the 10th minute of the second evaluation or the second day, what you stated is that the child looked for the door, but yet they're still drawing on the table. How is that possible? The other side of this is it affects the administrative code that governs these individuals. If I could, 34 seconds. These individuals are paid thousands. I'm not talking about a little bit. I'm talking about upwards of $20,000 and $40,000 to impact lives of kids. Representative Harris has listened to me, and my father's here today as well. It's affected our lives. We hope that you pass this bill the way it is intended to protect the children and to protect the parents going through this situation. Thank you, Representative Harris. And I'll take any questions.
Mr. Taylor, thank you for your testimony. Members, any questions? Representative Lopez.
Thank you for your testimony, sir. I'm sorry that happened to you. I, as a licensed professional counselor, know that we're not supposed to impose our own values on our clients. And if that did happen, it shouldn't have happened. However, my concern is, and I'd like your feedback on this, as licensed counselors ourselves, we know that we need to protect our client as much as we can. So if a judge ever requests for us to release records, we can let the judge know because we want to protect the child. Mm-hmm. We'd rather not release records for that child. Mm-hmm. Why? Let me tell you why. Because whatever you take to court is now public records. Anybody can see those records. And what I'm concerned about is when a child has made an outcry of abuse, and it was true abuse, right? I'm not saying where in your case where it seems like they lied about it based on what you're saying. But when there's abuse and a child is describing the abuse, sometimes they might draw pictures or they might state exactly what happened to them. And so putting that out there in public, one, it can cause shame for the child, and two, it could traumatize the child more as they grow up. Because, like I said, that's public records now, and 10, 20 years later, somebody can get access to that and use it for wrong. And so that is my concern in having children videotaped and now going to having that go to the court and making it public. So how would we protect those children so that it doesn't happen to them?
Everything that you just said is an excellent point. It happened in my case. The way that you protect it, though, under 261, when you say that there's an actual outcry, right? An outcry. If you're at LPC, then you are mandated to report that outcry. You can't just walk into court, and that's what happened in our case. You can't just walk into court and start saying, well, this is an outcry. If you had an outcry during one of your sessions, you're mandated to report that to CPS, DFPS, or law enforcement. It's in your codes. It's in the administrative codes. The way that you have to protect that, though, is that you can have hearings separate of full-on fledged out in the public hearings. And the judge can actually seal a record based off of those hearings. They have the discretion to do that. That would be one way to be able to do that. But for one party not to have the evidence or to have the ability to see what's going on when there was no outcry made, and I know that you're talking about a specific possible scenario, right? If those scenarios never happened and the outcry was the first time happening in the courtroom, then technically by what your administrative codes and the family codes require, that's already been violated. And this is to protect the fact that if there is an outcry, you can go, well, December 17th, 2020, during our third session, this is where it was. Judge, this would be an in-camera review with all parties. We would want to go back to chambers to do that. They have the discretion to do that. Judges are available to seal records based off what that outcry might be. When CPS or Department of Family Protective Services or law enforcement get involved, just like sexual assault cases or family violence, spousal violence cases, they have the ability to protect the victim, which in this case would be the child, for that not to be seen by the public. And that's the way, I say this in all due respect, but BHEC, and we talk about agencies all the time, but BHEC, which you're familiar with BHEC, right? Behavioral Health Executive Council. BHEC is failing to go through the process of the complaints when these things actually happen inside of family courts, and they're used as these Wild Wild West, the hitman, to be able to pull them in and bring them and testify. They're not reporting outcries. That's a violation. Judges aren't doing anything. Or if they are accused and then later they are proven to have committed aggravated perjury, which is a felony, agency's not doing anything. Right now, BHEC is sitting on hundreds of complaints in family court cases of child custody evaluators and mental health professionals that they're not following through with their codes and then implementing those. And I think that BHEC should be investigated. I think that it should be required. And I think that Darrell Spinks should be removed from his position as executive director immediately. He has failed family code, the family courts, and then y'all as the professionals, he's not having y'all uphold that in family court cases where there is bias or there is a rogue individual that puts a damper on the entire profession that you have. And I hate that because we sit here today testifying the way that we are, and I'm a father testifying for most fathers, but I'm testifying for children because my case isn't the only one in our county. My case isn't the only one who's had a mental health professional lie under oath for a parent. And this bill protects that so that the child can actually, you can actually see what the child said rather than somebody taking, I talk with my hands. Some people take that as aggressive. I come from a background of a DPS officer. I come from a stern environment. I played, college baseball. That's a stern environment. If you're not in morning workout, somebody's talking to you with their hands too. That interpretation can be used in family court to take a child away. I don't think that should be allowed. And I think when somebody gets it wrong and makes a mistake and they knowingly violate something, they should be instantly reported. They should be instantly taken care of, and especially when it comes to false allegations. Under 261 of the Family Code, there is a false allegation portion to that, and when it's proven to be false, custody is flipped. Judge should do that. They don't.
If I may ask you, you said the counselors are trained evaluators. No, you said they're evaluators. Are they trained? Do they go through specific training for that?
If they are a child custody evaluator and they are deemed that, they have to have a portion of forensic psychology. They have to have a portion of forensic. If they're a county or they haven't met those requirements, a county that has 250,000 or less under Texas Family Code 107, they can deem an individual that if they meet certain requirements, right? Or they're working towards those requirements. And in our county, in Jefferson County, we don't have anybody. So there's a couple of people that are almost there, and they're getting deemed that. They're able to see those cases.
Okay, because as counselors, we don't get trained on that. So that's why I'm asking, because
it would be further.
That's concerning to me. So I would want to make sure that they do have the proper training to be evaluators if they are evaluating.
I echo what you just said. Absolutely.
And they can if they get the right training, right?
Yes, ma'am.
So I'm not saying they can't, but I just want to make sure that it's not something that they're doing just because
we
they
want
feel
that, right?
they can do it.
There's a lot of cases out there in child custody, especially where a child doesn't follow the normal path of problems. So they kind of have to figure out where that's at. Is it in the weeds? You can't just do that. I can't do it, and probably nobody else on this panel, maybe you with your training, but I couldn't do that. I'm just a normal average citizen. That I don't have that type of training. I don't have those type of investigative clues in mental health. So that's a great point. So thank you, Representative, and I appreciate the questions.
Thank you.
Thank you for your testimony, Mr. Taylor. Anybody else have any questions?
Not a question, just a comment. I just want to say good job. Your knowledge and preparedness is impressive and appreciated.
Thank you, Mr. Cook. We've had some time to work on it. Unfortunately, on the negative side, with BHEC, I've had to learn black and white. So thank you.
Thank you. At this time, the chair calls Arnold Yan. Mr. Yan, I'd like to remind you, please state your full name, who you represent, if you're on for or against the bill.
Hi, I'm Arnold Yan. I'm representing myself. I'm for this bill, and I want to make a disclosure again. And I don't under any allegations or I don't own any child support bill. I'm paying that, but I don't own anything, so I'm not coming here to defend any of my own interest. But I like transparency in the family court case. I like honesty. And I support this bill because it will provide a recording for the evaluation. I heard a lot of litigants tell me we do have a child evaluator come to the court without bringing one single piece of paper, just coming to testify, hey, this is the things, this is the case, I believe the child should be doing like that. And they even denied the subpoena from the court to get the original report. And the judge is not doing anything. No contempt of court because the child evaluator is the appointed one by the court. So they just go in there, say anything they want without providing any proof, and it doesn't make parents happy at all. And they flip. There are even cases that tell one parent, I'm going to the court to say this, because your child tell me that. When he went to the standing, he said the opposite way and gave a surprise to the parents, and they don't know how to do that because suddenly everything got flipped. This is what happened in the real world, in the real court, and the parents are not happy. That's why everyone, you can see that. A lot of parents coming out to testify, including mom, including dad. And BHAC has a lot of complaint case. Our CDC has a lot of complaint case about integrity too, about the law, perjury. We need to prevent that. If we allow child evaluator, we allow lawyer to speak lie in court, there's no justice. There's no justice. I just studied my battle in the family court for about 1 year. I already made a tax record. Do you know why? You went to file grievance to CDC and you appear to BODA. You know what a BODA is here, right? Everybody know that. The BODA appeal rate is only 6%. I already struck 2 lawyers down in BODA, straight, 2 in a row. 2 lawyers in my case right now is heading to the disbarment right now. Nobody in Texas ever achieved that. That tells you how messy our system is, how civilian their perjury is. And I just present a case. Nobody want to prosecute that because everybody protect everybody. We don't have any class have the privilege with the criminal immunity, but right now, everyone walking to the court has immunity and they will not be criminal charged, protected by our DA office. Who suffer death penalty for all these parents? They lost custody. I'm telling you guys the reality. This is why you have people coming here to hear again and again. You don't fix that, people will come here every year.
Thank you, Mr. Yan, for your testimony. Members, any questions?
Any question?
If not, thank you, Mr. Yan, for your testimony. This time the chair calls up Tim Taylor. Mr. Taylor, if you can give us your full name, who you represent, if you're on for or against the bill.
Full name is Tim G. Taylor. I represent myself, and I'm for this bill. I appreciate Representative Harris drafting the bill. Thank you all for your time. I've been in law enforcement, civil work most of my life. Started out right down the road on Lamar Avenue for DPS. I worked for district attorney investigators. I had interviewed some children because back in the day, we didn't have CPS investigators in rural counties. When I moved out of Houston to Cherokee County, the judges asked me, could I do them? Yes, sir, we'll try. We called the state, got approval. I went through a little course. I did social studies. That's what we called them today. I would not do a child interview without a tape recorder going, unbeknownst or whichever, just depending on what we were doing. It covers me because sometimes I had to interview little girls, and that's not an easy thing to do. Finally, we got a lady over in Athens to do it. But my point being, I would not interview a child, especially when this started with my son. She was 5 years old. Now, you can't see, if it's just an audio, you can't see a little girl playing with toys saying yes or no. You can't see that. It's got to be both. I don't think you could get by with it, with one or not. In 1985, we started videotaping DWIs, offendants. Why? Because some of them were not drunk. And the tape will show that man can walk straight as a line, he can talk ABCs, he might have had a drink on his breath, but he was not intoxicated before breathalyzer and during breathalyzer. If we can do that to, I'm not going to call them criminals, but DWI defendants, why can't we do it with a child? I think it would help. It would stop 99% of what we lost, and this is what we lost. And there's not a better dad sitting in this county than that man right there. He is better than I raised my kids. And they're both very productive, both of them. Thank you, Representative Harris. I can't appreciate you most for getting this bill going. I think it's mandatory because there's 2 LPCs involved in this case. They both have been proven committed aggravated perjury. One of them made a mistake in saying, by the way, Judge, I audio-taped my interviews. It was Christmas when we got our interviews, and guess what? What she said in that courtroom under oath on the stand was not what my granddaughter said at age 5. Wasn't the same thing. They have not done anything to her yet. VHEC is not enforcing their rules, and I will mention the head investigator and I had a conversation on the phone. And he told me specifically, that lady can't do what she did, but there is not anything done to that person to this date. And that's all I've got. Thank you for your time. Appreciate you.
Mr. Taylor, hold on real quick. Members, any questions? No, but thank you for your service to Texas. Awesome. Yes, sir. Oh, excuse me, Mr. Taylor. Representative Lopez.
Mr. Taylor, thank you for your service. I'm sorry that you all went through this. And, like I said, there are codes of ethics that we do have to be following. And even us as counselors, yeah, like you said, we can make our errors, but an error that permanently affects a child is not okay. And just know that you all, even though maybe you had conversations with the behavioral health, you can file a complaint against the counselor in case you haven't.
Because
But and they would investigate and then decide to take.
from
We
that
can lose our.
county all the way to Austin, nothing has been done for that man. And to lose that little girl, and I'm gonna throw one thing out. We had a jury trial in August. Guess what the jury said? After 5 days, the jury said, give that man joint custody back to him, just like it was when he was divorced. Monday morning, it was taken away from him, and we haven't seen her since. He gets to talk to her 15 minutes every other Saturday, but she can't ask Dad, why can't I come see you? Video after video of her running to him was not allowed by that judge. And I'm sorry, Judge, you're still here. There's some of them not as good as you.
Well, just know what your rights are. You do have the right to complain against a counselor, and we can lose our license. So, thank you, sir.
Thank you, Mr. Taylor. This time the chair calls Jeffrey Morgan. Mr. Morgan, once again, give us your full name, who you represent on for or against the bill.
Thank you. My name is Jeffrey Morgan. I represent myself. I am 100% for this bill. I've talked with a number of these people in here about child custody evaluators. I've talked with people that talked about the fees that they charge, the bias, the aggravated perjury. I'm so glad that Mr. Taylor and his father came here today to talk about this. I know there's other people that have the same story as well. Child custody evaluators are not negative, are not neutral. They can be purchased. They can be bought. They do interpret a lot of what they see through their own prism. I know of one person in particular that probably has a dozen complaints filed against her. I've read some of them. And she continues to be used again and again and again. I'm not going to mention her name in public, but this is a real problem with what's going on with this child custody evaluation stuff. Got another friend. He said the judge made him get 2 child custody evaluations. One of them cost him and his wife $60,000. The other one cost him $80,000, $140,000. And what was the result? I sat at his trial in 2019, and they had an expert come in and who said he read the child custody evaluation, and he said, based on this one sentence alone, I knew the guy did not know what he was talking about. It was still $80,000 for that one guy. Some of the issues, in order to keep an accurate record, we absolutely must have audio and video, and I would say also, as other people have said, in the courtroom. You guys have no idea. I shouldn't say that because you guys have been in the courtroom. Some of you have been. But what we've witnessed in the courtroom, I've probably been in almost 200 cases over the last couple of years, virtually in person. I've traveled throughout the state. It has been atrocious. I have no confidence in the judiciary. I have a negative confidence. That's how bad it is. The only thing I'd say here is, though, that the playing in the presence of all parties to the suit, the only concern that I would have with that and is that I remember Frank Abagnale, the guy, Catch Me If You Can. He talked about how he was pulled out of school, taken to the judge, and had no idea that his parents were going through a divorce. And the judge says, who do you want to live with, your mother or your father? He said, he ran out, he cried. And that's when he started his life of everything else that he's supposedly famous for. But he said it broke him. We put burdens upon our kids when we make them do stuff like this. I look at the parenting issue much more as not like who's 95%, who's 90%. But when I got commissioned as a financial institution examiner, we had to pass a certain threshold level. If I passed that level with 75 or whatever it was, versus somebody who passed it with 95, there was no difference. We were both still commissioned examiners. And I think that when we look at the fit parent presumption, that's what we need to start doing. Both parents are fit. If they're not fit, that is a different story. Both parents created the child. And when we remove a parent out of a child's life, so much is being lost for that child. We talk about the best interest of the child, and I'll talk about this in an upcoming bill that's going to be discussed here as well. But I look at the identity. Is it time for me? I got a few more minutes. The identity of a child has to be formed from both his mother and father. And if you only have one part of that identity there, you're going to have a misformed child who will suffer lots of trauma. There'll be a lot of issues later on. Anyway, sorry for going a few minutes over, but I do appreciate your time here. And I stand Thank you so much. Is that your son? You should be proud of your dad.
Thank you, Mr. Moore, for your testimony. Members, any questions? If not, thank you very much. The chair calls Taryn Champagne. Know the drill. Name, who you represent, on, for, or against.
It's now good evening, everybody. My name is Taryn Champagne. I represent myself, and I'm for this bill. There's a lot better testimony that's been said on this. Representative Lopez, you mentioned you were worried about harm to the child regarding kind of exposing maybe some of this information documentation. My concern also relates to harm to the child, but what about if this child custody evaluator states something false or does something false and there's no record of this, and now that child has harm done to them because of the child custody evaluator, because they got it wrong or they deliberately did something wrong, like in Mr. Taylor's case over here. It doesn't just affect that child. There's a little boy sitting right in the back there. That's my son, all right? Because of a false child custody evaluation, he has lost his friend. He has lost his friend who is like a little brother to him. A friend of his, my son very likely will never be able to have a little brother due to my wife and I's situation. And he lost his friend because of this child custody evaluator. Their interviews absolutely must be recorded, and we must be able to expose them for corruption if there is there. Sunlight is the best disinfectant, and it's time we open the windows on this whole family court system. Thank you. Any testimony? Any questions?
All right, thank you. Members, any questions? All right, thank you.
Thank you.
Testimony. Call up David Simpson. Mr. Simpson, you give us your full name, who you represent, on, for, or against the bill.
Thank you, Mr. Chair. I'm David Simpson. I'm the director of the Harris County Domestic Relations Office. Committee members, we have a family court services division in our office in Houston, Texas, and we employ over 10.
Are you on, for, or against the bill?
I'm sorry. My apologies. I am opposed to the bill as written, and
Okay.
I'll tell you why in my testimony.
Okay.
Sorry about that. We have about 10 licensed mental health professionals in our office that do exclusive work on child custody evaluations. We receive over 350 orders annually from our Harris County family courts to do this work. There's a process in place that was adopted by this committee years ago and put in place. There are basic elements and additional elements that must be completed before a child custody evaluator can make a recommendation in a custody matter. This new requirement, I am fearful, requiring that a child be interviewed and be recorded adds an element that I fear will cause harm to the child and also create an unfunded mandate. Children, much like adults, tend to be less than forthcoming if they feel that the information shared may resurface or be used against them. Having their interviews recorded may cause added stress and anxiety for children. If children know they're being recorded while their parents are in a custody dispute, they may be less candid for fear that their parents will hear what they say to an evaluator. Children may not be forthcoming regarding abuse, concerns, or their wishes. Most children did not wait to express a choice and are worried about hurting one parent over the other. Mandating recordings may create fear in children that a parent may confront them regarding their statements, make them believe that they have been disloyal to one parent over the other, or cause additional anxiety. I mentioned earlier the elements that are out there. We're required to interview children during the possession, when each parent has possession of a child. We interview our children usually in their homes. Sometimes we interview them in their schools, sometimes in our office. All of our evaluators have gone through extensive training. I also feel like this bill would be an unfunded mandate. If we're required to take recording equipment into homes, into schools, we'll have to purchase the equipment. We'll have to hire staff to respond to subpoenas, to respond to additional testimony in court. The safeguards are already out there in the elements that we have. And I think the solution to this problem can be, if you want your child's interview recorded in an evaluation, put that in your court order. Ask the judge to order that, or hire an evaluator that already uses that as part of their protocols. I've already talked to Representative Harris. I'm hopeful we can work through some little nuances to make this bill passable, and I can support it.
Thank you, Mr. Simpson, for your testimony. Members, any questions? Representative Cook?
It didn't cost me anything to hit the record button on my iPad here. Do your caseworkers have like iPads or laptops or something like that?
Some do, and some just take notes on paper.
Does the county provide a computer for your staff?
Yes.
Okay. And you think it'd be pretty easy just to hit the button like I did and start a video and you? It didn't cost me anything?
It didn't cost you anything, no, sir.
Okay. I do share some of the concerns. I mean, like, as far as the video is concerned, like in 153.009 is where a judge interviews a child, and it's the same thing. And one of the witnesses, I think, kind of contradicted himself when he said he supported the bill, but then he also gave an example of where he felt like that it was, I don't remember the person's name that he referred to, but he said that when the person was put in a position where he had to choose his mother or father. So I see some of what you're saying, but the unfunded mandate is, to me, is a pretty ridiculous argument. But
Well, I think it will increase the need to respond to subpoenas that we currently don't have. We'll certainly have to respond to subpoenas, but certainly my testimony was mostly about the damage to a child.
let me just assure you, you having to respond to a subpoena will have no bearing on how I vote on this matter. I mean, that's just part of the process, and the judge has the authority to limit. Under 107 already, and you probably know that as well as I do. That I don't see anything in this bill that restricts the judge's ability to do that. Do you?
To do what, sir?
To restrict. Do you see anything in the proposed bill that would restrict the judge's authority to provide privilege or any type of confidential nature?
I don't. The evidentiary rules still apply.
Well,
but we certainly do respond to many subpoenas in our office, and this will increase that volume.
It's just part of the
But
process.
I will also, if you don't mind, our evaluation recommendations don't hinge solely on what a child tells us. It's rare. There are so many different elements that come into play, and they're all set out in the basic and additional elements in Chapter 107. It's one of many things that our evaluators look at.
Sure, I agree. Thank you.
Thank you, Representative Cook. Anybody else? Members? Simpson, thank you for your testimony. This time the chair calls Carlos Damon. Mr. Damon, once again, full name, who you represent, on, for, or against the bill.
Get it. Mr. Nahon. Carlos Damon. I'm representing myself, and I'm in favor of this bill. We need full transparency. Absolutely. Why? So that we can trust the justice system, right? It's all about the trust. If you can't trust the system, why do we need a system? It's all going to be about the trust, right? Executor, beneficiary. If you can't trust the trustee making those decisions, we don't need a justice law system. So remember, cameras in the courtrooms. Remember, there's only two kinds of individuals that don't like cameras in the courtrooms. Is that hot and sweaty porn star after working 12-hour shift, or a criminal? Period. Oh, and for the record, man, you know, I have to say this. Why? Because I don't know about you guys, but I'm a Christian.
Talking about porn stars?
Yeah. Yeah, but we're all sinners. Or, I mean, I am at least. So.
Let me remind you, we do have young children in here.
Yeah, that's right. I do apologize. So, and I'll apologize for this because I only have one judge, and that's my Lord Savior, Jesus Christ, and I only accept one as my Savior. So I accept no other judge before me because I only have one. So, and Representative Lopez, complaints are definitely good. I like those. We can make complaints, but I think we need to start making I apologize. We need to start filing claims for us individuals who have been injured. I'm tired of complaining, and it's time for us to start filing claims. So I think that's what we need to be kind of teaching ourselves, teaching other individuals. If we've been hurt or injured in this court system, I think we need to start getting compensated for that.
Thank you. Thank you for your testimony. Members, any questions? All right, thank you very much. Is that it? At this time, the chair calls Christy Bradshaw Schmidt. Once again, full name, Will you represent on for or against the bill?
Yes, sir. My name is Christy Bradshaw Schmidt. I am testifying on House Bill 4062. I'm neutral on the bill, and I'm testifying on behalf of myself. I'm a child custody evaluator as well as an adoption evaluator, and I also do expert witness work. I review other custody evaluators and their work product reviews and provide testimony to the court when they are subpar. I worked on the bill that Mr. Simpson talked about as well that has the qualifications to do this work. I have done 600 evaluations myself, on or around that, and I've been doing it for 23 years. I think this bill has a place, but I think there's some changes that need to be made. My first one is the one that nobody's talked about yet. The second half of this bill says that if we are not audio or video recording, we are to interview these children in the presence of both their parents. That flies in the face of peer-reviewed research. You are not, the likelihood we get accurate, valid, and reliable data from children is difficult as it is in these cases, because these kids are in high conflict situations. They have loyalty binds, they're stuck between their parents, and they don't want to choose. So they're scared to talk anyway. And if we have to start interviewing them in the presence of both their children, I am very concerned with the potential harm that would cause. So that's the second half of the bill that I have a significant concern about more than anything else. I get that there are concerns from other evaluators and how things are done, and I sympathize with the gentleman in this room because that's not okay. That shouldn't be happening. And you are correct, we should have proper training. The problem is recording, as much as, yes, it is easy to push a button on our computer and record, the other problem is it's the cost to store those recordings for 7 years after that child turns the age of 18. For a solo practitioner, and I don't work in a rural community, that would be a burden on my practice, certainly would be in the rural communities. That's the concern of this. I get we're supposed to be transparent. I'm as transparent as it can get. You get my notes on a custody evaluation, you're gonna know every question I asked that child and every answer I got. And you know what? That's not what every custody evaluator is doing, and we know that. This bill's not gonna fix that. And now, with that said, I think judges can order that we have to record. I think that's an option. I think we could put into a law that says, you know, under the appropriate circumstances, with good cause, and the court orders it and decides who pays for it, so we know how that's going to be, you know, contained for however many years it has to be maintained. I think there's a way to work around that. We're happy to come across the table and work with you and figure this out and make something that works for the citizens of Texas. But those are the suggestions that I have to hopefully improve this, to protect the families and the citizens, but more importantly, the children that we serve every day. Thank you for your time. I'm happy to answer any questions that y'all may have.
Members, any questions? Representative Lopez?
What would be your suggestion on this bill, on how to?
I think there's some language in regards to just what I said, and I've made some notes. So under certain circumstances, the judge can already order it. So the fix is to put something in there is that it can be ordered with good cause shown, or on the request of a party with the order of the court and an order of who pays for it. I think that's one way to get over this hurdle, is to address the payment issue, and it has to be for good cause. We already have the option and the discretion to do it, and judges already have the discretion to order it, but we can certainly clarify that. I do think the piece about having to be interviewed in the presence of both their parents needs to come out. That actually violates a part of 107, 109, which is the custody evaluation statute that says I'm to interview that child outside the presence of a party. So there's supposed to be individual interviews. We've got conflicting codes there, but I certainly think there are some ways to improve this. Transparency, I mean, everybody who's testified that we need transparency, they're not wrong. The only thing in my process people should not have access to is the CPS records, because they're unredacted in law enforcement, and those can be acquired with a court order. Everything else is free game. They get a copy of it. So, but that's my suggestion. Does that answer your question?
Yes, ma'am.
Thank you.
Thank you.
But it's not free, right? You can charge for it, correct?
I can. It's those smaller towns, those smaller rural communities, and those families who simply can't afford it. We're concerned about an access to justice for them more than anything else. Some of us certainly can afford to put that off on our clients. The case I've got that I'm working on right now doesn't have the money to do that. So it's how do we balance that that's the key.
But the current statute authorizes a person maintaining records subject to disclosure under this section to charge a reasonable fee for producing the records, right?
What that actually means is I don't get to charge for my time. I get to charge what FedEx office allows me to scan it in and pass that bill along. We can't charge for our time on that.
I don't know about you, but my office is automated. I mean, like, I'm not paperless, but I'm paper light, and so
that's where I'm at.
Okay, well then you don't have to go drive somewhere. You just walk down to the copy machine and you put it through the scanner, and you get a I'm like Chairman Dutton. I'm not the most sophisticated or the most high tech, but I have good people that can do that, where you put it into a file and you
I'm a solo practitioner. I don't have anybody else in my office. I have files that are this tall and paper files. That
well, then
people
if
give
you,
me.
that's up to
the
you.
piece that
I'm
takes
just saying there's technologies there today to where if you want to scan stuff in and use it electronically.
It is, and I pass that along to a client, but I don't get paid for my time for that. They just get to pay for the labor that somebody else did, not me.
Well, the bills I get from you guys certainly charge for it. And you charge from everything, from the time you start working on it until you finish it. So maybe you're different. Maybe you're special.
Well, there are people who do flat fees. That does happen. There
I
are
don't get
people
any
who
flat
do
fees
reduced
either. I get hourly rates, and I've never had 80,000 or whatever was specified to earlier. I've
No,
never heard
sir.
anything like that. But
No, sir. Agreed. But I know that happens in other parts of the
it's generally hourly, hourly work. So I would encourage you to work with
Happy to.
Chairman Harris's office and see if y'all can come to it. But right now the part that you're concerned about is an or. So it's not like it's not it's not a shall or anything like that. So it's not going to hurt you.
It doesn't hurt me. It might hurt some other people who can't afford to do the recording, and that's where my concern lies for those children.
I still don't know. What cost are you referring to?
It's the storage cost. I already pay a significant amount to store things electronically as a solo practitioner. Like I said, I don't even have an assistant. I am my own secretary, janitor, all the way above. It's the storage that I have to pay for electronically until that child is 7 years past the age of 18. That's a lot of files when I've done 600 cases.
Over how many years?
23, but so we're still dealing
That's
with
not-
7 years of
that's-
that. And
I'm
when
not-
they're this tall a piece, that's a lot of storage. So
Really not that many. I could put it in my phone and see how many it is, but that's not that many a year. I mean, 600 over 23 years is not a lot, and you probably have iCloud type storage, right? It's flat.
I don't use iCloud storage. I have to use a HIPAA compliant storage. So that's a completely different setup.
So you're saying that HIPAA precludes you from using iCloud storage or any type of?
I don't know if it does or not, but I try to use the one that's going to make sure that I'm not going to get in trouble with my licensure by how I'm storing records.
I bet you Apple has it figured out.
I also don't have an iPhone. I'm an Android girl. So
Members, any other questions? All right, thank you.
thank you so much, y'all. Well, I appreciate y'all.
I want to make an announcement. Before I call the next witness, I want to remind the audience that we have 6 more bills after this. So we've got a lot to do. So please keep your comments, your testimony specific to the bill, and that we need to be a respecter of everyone's time, right? Okay, with that being said, I'm going to be calling up Stuart McMullen. Stuart McMullen, twice. All right. Anton Golikop. I don't think he's here. We've called him earlier. Brandon Johnson. Mr. Johnson, once again, full name, who you represent, on, for, against the bill.
Brandon Johnson, represent myself. I want to change from being neutral to for the bill.
Okay, so just let me make sure we got you neutral, and you've given us permission to change you for on this bill. Is that correct?
Yes.
Okay.
The only thing that I would add, I don't want to take anything from the bill. It's fine, it's concise, to the point. But one thing that mentioned, and thank you, Mr. Cook, the storage fee, that could easily be built into the cost over the lifetime. You got to keep the information. Storage costs are going down. But I do appreciate the previous woman's testimony. I do kind of agree with her that I would take out both parents. I think that puts the child in a precarious, it's uncomfortable. The child doesn't need to be choosing between both parents, especially when they're both staring at them. I wouldn't want to put my kids through that. And that's also why 50-50 should be a presumption. Kids shouldn't decide. The other thing is, if without taking away from the bill, if you could just add that all proceedings dealing with a child are recorded, even the court hearings, the adversarial committee hearings, because there are the courts have brought up the same thing as the previous testifier, that we don't have the storage. and I call bull on it because I have been in these courthouses. They all have cameras. And they're watching them. A lot of times the deputies are back there watching they'll be downstairs or in another office and they're watching what's going on. There's no reason, and I just find it interesting, that these child custody evaluators are the ones who don't want to be recorded. And you know what? They have moved from a private practice into the public when they get involved in these cases that are public cases. So they should be subject to the same scrutiny that you are, that the police officers on the street are, and that the judges need to be. Because when people know that they're being watched, they act right. Thank you for your time.
Thank you, Mr. Johnson. Members, any questions? Thank you. If not, the chair calls. Dr. Aaron Robb. Full name, who you represent, on, for, against the bill.
Good evening. I'm Dr. Aaron Robb. I'm here representing myself, and I am testifying on the bill. I have mentioned earlier, I have a PhD in social work. My master's is in counseling. I, too, am a licensed professional counselor. And I have to say, much of what I've heard today has rung true. I am routinely reviewing therapist files. I'm routinely reviewing evaluators where we see that they don't report abuse and neglect, one of those very bright line issues. And I understand where some of this is coming in. My background, I started off as a forensic interviewer for CPS. I was doing teamed law enforcement investigations early on, and I've made a professional study of forensic interviewing to the point where I now train judges. I'm on the editorial board of major journals. I publish routinely on this stuff. This summer, I'll be training at the National Council of Juvenile and Family Court Judges as one of the presenters for the courts there. But I don't want to bore you with the academic side of this. That's going to take more than 3 minutes, and there is a huge, nuanced discussion. I want you to imagine that you're a child in the middle of a custody evaluation, and the two people you love the most in the world are fighting, and you know it. It always spills over onto these kids when there's a custody evaluation. We don't get the low conflict kitchen table divorces. And suddenly you're talking to somebody who not only has a notepad and paper out, but they say, oh, make sure to speak up so that I can hear you on the recording. That's a kid who's going to freeze up in a lot of circumstances. That's not a kid who's making a CPS outcry because they've been abused and they're trying to find some sort of escape. That's a kid who is torn and feels like they have to make the choice between their parents, and now they know everything that I say is going to be written down, not only in a notepad, not only presented to the court, presented to my parents, but my voice is going to be on that recording. And maybe if we've got our little tripod stand, we set it up and we get the video of what's going on with the kiddo. And of course, they're going to feel huge amounts of pressure as this is going on. And again, we are solving a problem here today with this bill that is caused not by good, well-trained evaluators. And these figures in the tens of thousands of dollars for an evaluation are appalling to me. I've never charged that kind of fee. That is something that what we're hearing is it's unqualified evaluators that are doing things because they're the best thing that those smaller counties have. And maybe the solution isn't to fix this by putting kids under even more pressure at one of the worst times of their life, but it's to go ahead and say, maybe we don't have unqualified people doing this. This is hard work. This is not what we're taught in graduate school. I teach professionally on forensics routinely, and it is something that takes a lot of effort to do well, and it is very easy to do badly and hurt families that we need to avoid that. I appreciate the time that's gone into this. No one wants to see children hurt. I deeply resent the implication that we're vampires hiding from sunlight, that we are somehow trying to abscond with tens of thousands of dollars in money, hurting children along the way. That's not why I went to school. That's not why I do this kind of work. Most of us out there are good people trying to do the best we can. Every profession has somebody at the bottom, though. All attorneys, I see attorneys getting disbarred all the time when the bar journals come out. My wife is a nurse. I see page after page of nurses disciplined for failures. We all have problem areas. Fixing this on the backs of children is the wrong way to go.
Thank you, Dr. Robb, for the testimony. Members, any questions? All right, thank you. Chair calls Tammy Axelson. Tammy Axelson once, twice? Okay, she'll be shown as registered neutral on the bill. At this time, Chair calls up David O'Connor. Mr. O'Connor, your full name, who you represent, if you're on for or against the bill.
I'm Dr. David O'Connor. I'm
who you
representing myself, and I'm in favor strongly of this bill. Vice Chairman, committee members, thank you for the opportunity. I just recently registered a couple of minutes ago to support this bill. I have been a board-certified adult, child, adolescent psychiatrist for over 25 years in a variety of fields, juvenile justice, adult justice, a variety of outpatient, inpatient settings. I understand the concern that many of the witnesses expressed. And if we look at it, right now we have an outcome. We have an outcome because there's been probably certain outliers in the practice of child custody evaluations that have brought this outcome and brought this bill as well as many other bills. In terms of some of the obstacles of doing things like this, as Representative Cook pointed out, it can be a very easy thing. In short, we're not doing, a David Letterman interview with mics in the faces of the children. In schools, children are surveilled. We're being surveilled right now. We're surveilled on the streets. We're surveilled almost everywhere without ourselves or our children even noticing it. And the same thing can be done during evaluations, are done in the field of in my field without affecting the behavior of children or the parents. So I think that obstacle can be overcome. I think the bill relates to the issue of transparency and integrity because there are outliers, as was pointed out by Dr. Robb earlier, that are not keeping the integrity of their profession, the sanctity of their profession, and somehow through the process of time, lack of training, experience, it's being contaminated. Thank you again for the opportunity. Are there any questions? I guess you should ask that.
Yeah. Thank you, Dr. O'Connor, for your testimony. Members, any questions?
Thank you.
No? Thank you very much. I think that concludes all our testimony. Is there anyone else who wishes to testify on or against HB 4062?
What's his name?
Okay.
Have you registered?
Have you registered? Did you register?
I tried to, but my phone wasn't letting me.
Okay, so we have him register. Can you go walk over there and I'll get you registered? I'm going to use this time to let anybody here, if you want to testify, please register in the back. Will save us all some time. Who's the next one? Who's the next bill? Just give me his paperwork. And then you can go. I think I'll be good. Perfect. All right, Mr. David Bello, give us your full name, who you're representing if you're on for or against the bill.
Michael David Bello Jr. I'm representing myself, and I am in favor of the bill.
Okay.
First off, I apologize about that delay. I wasn't even thinking I was going to be able to testify today. I drove in, didn't have a lot of time, and there were a lot of other points that were made on the bills so far. I didn't feel like I felt like the issues were covered. This bill, though, I just had the urge to jump up and I tried to get on my phone at first. I wasn't able to because it was last minute. My friend Cody Taylor, actually, this bill was inspired by him, and so it's very. I want to express that there are a lot of hurt people. There's a lot of hurt people. Hurt by the court system, hurt by attorneys, judges, counselors. It doesn't mean everyone's bad. And I don't think anyone out here believes that. I do believe it's easy to get caught up in hurt. And in your situation, you do see that the only people around you maybe are doing wrong. And it's easy to project that onto the entire profession. But I want to thank y'all for doing what y'all do and listening to the voters and trying to craft these laws the best way you can. And, there's some of my best friends are family attorneys. There are a lot of good family attorneys out there, but there's also some really bad ones. And when you're in that bad situation and you see somebody who should get disbarred, and maybe they do get disbarred, it affects your judgment of the entire situation because this is your life. Your children are your life. So I want to just stand up here and say, look, you've heard a lot of emotion. Maybe some of the people, you don't even like the way they were, projecting themselves. At the end of the day, I ask that y'all step back and say, you know what, I'm going to look at this. I'm not going to look at, I'm going to vote against this bill because I didn't like the way this person said it, or step back and look at the issues of, you know what, a lot of this hurt could be helped with transparency, better, stricter rules. And this bill, transparency, if a child says something and a counselor goes in and says the child says something, there should be a recording of it. If it's going to be used against someone to take their child away. And so I ask that y'all support this bill because, not because everyone's out there bad, not that everyone's a vampire out to get people, but there are some that are bad. And it would help the whole profession if we do have that transparency where a judge at the end of the day could release or could see those videos in camera behind closed doors with the other parties and just verify that parents and children are being properly evaluated without any outside influences.
Thank you, Mr. Dole, for your testimony. Members, any questions? Okay, thank you very much. Is there anyone else who wants to testify on for or against the bill? Okay, if not, the chair recognizes Chairman Harris to close on HB 4062.
Thank you, Mr. Chairman and members. I do appreciate the committee's time and patience and everyone who has come to testify today. I want to say that I recognize that we want children to be comfortable and feel safe enough to testify or to be honest in these interviews. That's without question. But I think that you would agree with me and you would do the same if this was my child who I was prevented from seeing because of a bad actor in this industry. I would move heaven and earth to correct that situation, just like Mr. Taylor's trying to do. So if this bill isn't the answer and y'all want to join me in going over to BHEC and flipping tables to correct it, let's do it. Whatever we need to do to fix this problem, that's what we need to do. In the meantime, I would request your favorable recommendation of this bill, and with that, I close.
Thank you, Representative Harris. Thank you very much. If there's no objection, oh, go ahead. I'm sorry. Representative Wilson.
Representative Harris, I like the bill. The one thing that I do have questions about is interviewing with both parents present. If it's going to be on videotape anyway, do you need to have both parents present?
Sure. So I think the intent behind including this part of the bill was to give an option where there isn't a video or audio recording involved. So if y'all want to take that part out of the bill and just say let's record every one of them, let's do it.
Do like an either or?
That's the way it is.
That's the way it is.
Yeah.
Okay. Yeah, that part I'm not completely comfortable with both parents being there. I don't know if you'll get in as a school teacher. Kids want to please their parents.
Sure.
For the most part.
Yep.
Most kids do.
Happy to work with you on that.
Yeah, and I just feel like their answers might be skewed by body language or anything that they see, approval in their parents' eyes or not.
Yeah, I think it was more
disappointment,
in the event that both parents are there, that would be the circumstance where we're comfortable with it not being recorded, if that makes sense.
Okay. Thank you.
Members, anything else? All right, if there's no objection, HB 4062 will be left pending. Thank you, Harris. The chair lays out HB 891, and the chair offers up a committee substitute to HB 891, and the chair recognizes Representative Spiller to explain the bill.
Thank you, Mr. Chairman. Mr. Chairman, members, I thank you for allowing me to lay out House Bill 891. According to Chapter 104.008 of the Texas Family Code, says a person may not offer an expert opinion or recommendation relating to the conservatorship of, possession of, or access to a child at issue in a suit unless the person has conducted a child custody evaluation relating to the child under Subchapter D, Chapter 107 of the Texas Family Code. In a recent case from the Austin Court of Appeals, the court interpreted Section 104.008A of the Texas Family Code to state that a party may not use an expert to challenge the methodology of a child custody evaluator if the expert has not conducted his or her own child custody evaluation. That case is the Gopalon case decided out of the Austin Court of Appeals July 15, 2021. Gopalon created confusion by ruling that an expert witness could not critique the work done by an expert witness by a child custody evaluator because the critiquing expert witness had not conducted his or her own child custody evaluation based on the Texas Family Code and Section 104.008. So the Court of Appeals specifically found that since the critiquing expert didn't conduct a child custody evaluation himself, he could not offer expert testimony or recommendation relating to, because back in that original statute it says anything relating to the conservatorship, possession, or access. So the intention of 104.008 was meant to prevent a person from giving expert testimony, expert opinion relating to the conservatorship of, possession of, or access to a child unless they met certain criteria, and that's typically the things that you would do in a child custody evaluation under Chapter 107. So, but that relating to language is a broad term that could be and now has been over-applied as it was in the Gopalon case by preventing a rebuttal witness. Now, House Bill 891 clarifies that a rebuttal expert could testify to challenge the qualifications and the methodology of a child custody evaluation expert without conducting their own child custody evaluation. And this is standard procedure in all areas of the law where you would have certainly someone could question the qualifications or methodology of an expert witness. But in this case, that was denied because that's the way that they interpreted that existing statute. So Section 104.008 was not meant to prohibit an expert witness from challenging the methodology of a child custody evaluator if the expert had not conducted the expert's own custody evaluation. In fact, it was meant to prevent, actually, it's meant to prevent multiple a situation in family code case where you'd have multiple expert opinions relating to conservatorship, custody, and support from multiple witnesses giving multiple opinions. So that's what the statute was enacted for. That's what it was geared toward. But now because of that language, it needs to be clarified. And so 891 eliminates this confusion by adding subsection D to help prevent confusion over the broadness of the term relates to in future litigation regarding rebuttal experts. So with that, Mr. Chairman, subject to any questions that you may have of me, I thank you for your time. Respectfully reserve the right to close.
Thank you, Mr. Spiller. Any questions, members? Nope. Okay, thank you. Chair calls up Lynn Kamen. Full name, who you represent, and if you're on for or against bill.
Yes. My name is Lynn Kamen. I'm a board-certified family law attorney from Houston. I am here on behalf of the Family Law Foundation, and we strongly support this bill. We support this bill for the simple reason that a custody evaluator is required to follow certain standards. And a custody evaluator is the only one who can give a recommendation concerning child custody. That's not what happened in the case in Austin, and also a case out of Dallas County. What occurred is the judges in those cases decided that a retained expert should not be allowed to testify and challenge the methodology and the qualifications of the child custody evaluator. If this bill isn't passed, what will happen is child custody evaluators will be able to testify without anyone questioning the methodology they're using to form an opinion. Texas Rules of Evidence 702, 703 require and state what is necessary for someone to give an expert opinion. The right to challenge an expert is necessary. Daubert recognizes the right to challenge an expert and to question their qualifications, the reliability, and the relevance of the methodology and the facts and data that they used in forming their opinion. So for those reasons, we strongly support this bill. And Representative Spiller, we very much thank you for bringing this bill.
Thank you, Ms. Kamen. Members, any questions? Thank you very much.
Thank you.
Now the chair calls Carl Hayes. Once again, full name, who you represent, on for or against bill.
Members of the committee, good evening. My name is Carl Hayes. I am here to testify in favor of HB 891. As previously stated, I'm the family judge down in...
You're representing yourself, right?
Representing myself, yes, sir. I am the judge of the family court down in Hays County. And in a typical divorce case, if there's an appraiser who testifies and something was done wrong with the appraisal, I want to hear about that. I want to hear another expert come in and tell me what was wrong with the appraisal. If a business evaluation is done and there were problems with the business evaluation, I would expect the other side to come up and bring an expert to testify about what was wrong with the business evaluation. If there's a psychological evaluation done of one or both of the parties and someone challenges that, I would expect that there would be an expert there critiquing the job that was done. Currently, because of the N. Ray Gopalan case, I'm precluded from having an expert testify in my court to challenge anything that a child custody evaluator did. You've heard that there are issues sometimes with child custody evaluations. The way it is now in Austin and, well, basically in the state, because it's this one opinion that's out there, is that a child custody evaluator you can't call someone in to critique their work. And one of the things we want to be able to do is have the ability to critique the work of these child custody evaluators. It's a check and balance on what they do, and you've heard today that that's something that's necessary. So this is a very needed bill to clarify that the intent of 104.008 was never to prevent someone from hiring an expert to come in and say, okay, child custody evaluator did this wrong. They did this wrong. They failed to do this. They didn't meet this standard. But that's what the court in In re Gopalan said, because you take the word related to, that meant they couldn't even testify in critiquing the child custody evaluation. And so this will clarify and allow for what's done in every other instance where we have an expert testify. You're always able to hire a rebuttal expert and have that rebuttal expert testify. And I want that information because I want to know if something was done correctly or not. I'll yield to questions.
All right, thank you for your testimony. Members, any questions?
All right, thank you.
Thank you. This time the chair calls David O'Connor.
Hello.
Sorry about that, Dr. O'Connor. Give us
That's
your
okay.
full name,
That's
who you
okay.
represent, on or against the bill.
David O'Connor, Dr. David O'Connor. I represent myself. I'm strongly in favor of this bill. This is a very good bill, much needed bill. I'm going to speak a little bit out of context, and I understand most, if not all of you, are attorneys. And if I speak out of context, I expect that you'll tell me I'm wrong, but that will be okay. I really support that a second expert should be allowed to scrutinize the report of a first expert. In all areas of law, in all other areas of law, except family law currently, or the family code, equal protection and due process is involved. And with that, equal protection and due process is the ability to impeach the witness, to impeach the expert witness. And as you know, that's done either by cross-examination on the stand to seek the truth, or, as was mentioned earlier, the Daubert or deposition, and also what is called another term, voir dire in Texas, or vaudois up in the Northeast, depending on where you're from. And the cross-examination, as you know, can really tear apart, so to speak, the content of the evaluation, but what's also important is the form. A second expert has the ability to look at any report and look and see if the form, as well as the content, is compliant with Texas statutes and other rules that apply to doing this type of evaluation. It's a very important evaluation. It's a very important process, as you know, because the end result can really decide the outcome of a child, the outcome of the parent-child relationship. As you know already, the Texas Supreme Court uses as its guide SCOTUS. And what usually happens in looking at the family code from my humble infancy experience is the Texas Supreme Court attempts to translate SCOTUS down into the family code, and we see that in several statutes. In every other area of law, whenever there's an expert, part of impeaching that expert is impeaching that report. But we could also see that apply to the family code with this change in this bill. And so I urge that this committee support this bill and make this change. The report and recommendations of forensic child custody evaluators should never be taken as valid on its face. Every avenue should be used to impeach that expert, to impeach the report in order to come to what the ultimate truth is. But oftentimes, feet on the ground, what you're going to see, what you're going to hear about, which I have dozens of times heard about, is that unknowingly the judiciary will more likely just take it on its face as valid. One comment about Gopalan, again in my infancy. In reading Gopalan, and I could probably be corrected, and that's fine, a couple of exclusions apply. If there's irreparable harm, which there can be if there's no scrutiny of the proper scrutiny or impeachment of the expert, and if the second expert cannot be used as for cross-examination. So more likely than not, if what goes on as usual, then we will continue to have irreparable harm with our kids and our parents. Thank you very much.
Thank you, Dr. O'Connor. Members, any questions? Okay, thank you. Chair calls Arnold Yan.
Good evening. Thanks for all the state representatives who work so late with us. And I'm Arnold Yan. I represent myself. I'm in favor of this bill because, as I stated earlier, I have heard about.
Mr. Yan, we have neutral on the bill, right?
Can you change it to 4?
Okay.
Yeah.
I have your permission to change it?
I only changed that once today. Okay. That's the only one I changed. That. Yes, change it for me. Okay. I support this bill because, as I stated earlier, I have heard about horrible story about child evaluator coming to the court, testify without bring any single piece of paper, just to provide opinion without proof any methodology has been relied on. Just a simple conclusion. It caused huge damage to the litigant's kids because sometimes those conclusion is really off the track, and those kind of things we should allow. This kind of story we should allow second expert to challenge them and to reevaluate the things to correct that, because the child custody is very big thing. I mean, matter to child for their lifetime impact. We really don't want someone coming to the court without any respect to their professionalism and just to easily say something without any strong evidence to endorse their statement. And for the best interest of the child, this is an obvious one, and we really want any witness, expert witness, to be challenged.
Thank you very much. Members, any questions? Thank you, Mr. Yan. Chair calls up Tim Taylor. Tim Taylor twice. Oh, he's for the bill? Okay, we have him registered here for the bill. Okay, the chair will now call up Cody Taylor.
My dad was called Tim the Toolman Taylor growing up, so I had to live with that. So, Cody Taylor, represent myself, and I'm strongly for the bill. I think it's excellent. So, this segued into what we were talking about, right? So, you're going to know what I'm talking about, and it's going to sound like gibberish to some, right? Title 22, Texas Administrative Code 681.53, paragraph E, F, and G. I'll specifically state G. No licensee shall give an opinion to the court upon conservatorship, access, or possession unless completing a child custody evaluation. You're familiar? Ish. So when I say that, and I'm not.
I've never been a forensic evaluator, so.
No, this is a part of actually
familiar with
licensed
that
professional
myself.
counselor. So the reason why I say this is huge. In my case, at the very end of the TRO affidavit that was given by the LPC, who did no child custody evaluation, they were independently hired by a parent. It is my recommendation that Mr. Taylor's parenting time be suspended until further professional evaluation is complete and until it is determined that the child will be physically and emotionally safe while in the care and custody of Mr. Taylor. Signed, LPC. That was presented to BHEC per the complaint process. Nothing was done. I think that this should be automatically put in there as a subsection that any mental health professional that offers expert testimony opinion to this and they haven't followed it should be automatically and instantly held in contempt of court. I really strongly think that a subsection should be put in there for that because BHEC's not doing their job. This affects me personally. I'm sorry. I'm not coming at you. It's just that you're familiar. And then I want to speak to you. Are you a teacher?
I was. Retired.
Was.
Retired.
But teachers are used in the capacity because they see kids over the course of their career, right? A lot of times judges allow teachers to actually give opinions based off of mental health. I know. It's cringeworthy. In my county, they do this on the regular. And even then when we go to the board or the bar or anywhere else for the SCJC, They allow this continuous. This one LPC is used on numerous cases, and she gives numerous recommendations. And then when somebody questions whether or not she actually is violating something or following 681.41 of her ethics, she instantly pulls herself out. Can you imagine a parent who's dumped $6,000 to $10,000 into what's court appointed or has to be done, and then she says, well, I'm out because I'm being questioned, I don't want anything? They don't get that money back. And then the board's not doing anything. OOA absolutely strongly supports what is already in TAC, which is a guideline for what y'all are supposed to, as licensed professional counselors or mental health professionals, follow. Daryl Spink should be removed from office, 100%. My case is riddled with problems, and I've lost 3 years of my daughter's life, and I'm still having to suffer. Please support this bill. This bill needs to go in today. It doesn't need to wait till September. Thank you.
Thank you, Mr. Taylor, for your testimony. Members, any questions?
Thank y'all.
Thank you. It's time the chair calls Jeffrey Morgan. Mr. Morgan, full name.
Yes. My name is Jeffrey Morgan. I am for the bill. I'm testifying on behalf of myself. Thank you once again. I wasn't sure if I was going to make it back for this or not. I had to let somebody have access to my car there for a moment. Anyway, I am 100% for this bill. Some of the issues that were talked about earlier with child custody evaluators are good reasons why. I had this whole thing here about the Dauber guidelines and Dauber challenges, but I think that one lady who was in front of me did an excellent job. I think when I came in, I heard the tail end of that. I have seen in courts where they did have an expert in there to perform the Dauber challenge, and the judge absolutely prohibited it from taking place. And because of that, they had a biased report, in my opinion, against an individual. A Dauber challenge should be able to be used. And I think about the Proverbs 18, verse 17. The first to plead his case seems right until another one comes and examines him. That's a biblical standard. And that's a standard of truth. If truth cannot stand scrutiny, maybe we are hiding something. And I thought at this point in time, probably all of you, maybe I'm wrong, but I mean, the movie Divorce Corp came out about 8 or 10 years ago, and it talks about all of this corruption and stuff that's taking place in our divorce courts. I kind of thought everybody had general knowledge of that. One of the cases for that film was actually done from Tarrant County. I know the individual there, and I know the judge. The judge has been down here to testify in front of this committee. We have to have, we must let another expert perform the Dauber challenge or question the reports to make sure that no corruption is taking place. My position will be is that our courts right now are riddled with corruption and fraud. Anyway, that's it. Any questions? I'd be glad to take them.
Thank you, Mr. Morgan. Any questions? Members?
Thank you so much.
Thank you. Chair calls up Taryn Champagne. He left already, okay. Once, twice, 3 times, okay. He'll be registered showing in favor, Bill. At this time, the chair calls Carlos Damon. All right, he's gone also, and we'll show him neutral on it. Where am I now? Anton Golikov. He hasn't been here all day. Last call. He's going to be showing on the bill.
Brandon Johnson.
Chair calls Brandon Johnson. Full name, who you represent on before it gets spelled.
Brandon Johnson. I represent myself and those fellow advocates who were unable to be here, that I'm loosely affiliated with.
We have you neutral, right?
And that was the next thing. I want to switch that for the bill.
Okay, so we have your permission to switch you from neutral to 4.
Yes, sir.
Okay. Okay, you're now for the bill. Go ahead.
It's a rare day that us advocates would be with the in agreement with the Family Law Foundation, but it's a good day to be able to agree on some things sometimes. So it is a good bill. Many times, industry experts, one, they don't use a methodology that can stand up to common sense scrutiny, let alone be challenged by an expert. Number two, they use boilerplate findings. And number three, they frame their opinions as findings that they know will get them additional work, be it appointed by the court or through their affiliation, knowing what the court's looking for. So all these cases end up being about the same, and hopefully this bill will change that. Thank you.
Thank you, Mr. Johnson, for your testimony. Members, any questions? No? Chair calls David Bellow.
Howdy, David Bellow, representing myself for the bill. And the Constitution is the foundation of this country. And one of the things that the Constitution protects is a right to due process. And a lot of what you're hearing today, not just with this bill, there's been a lot of bills that are just unleashing a lot of frustration with people because there are issues, and it's y'all's tough job to wade through those issues and ultimately to do what's best for the kids. That's what this is about. This isn't about mom. This isn't about dad. This isn't about my feelings. This isn't about your feelings. This is about what is best for the kids. And so y'all got a tough job. There's a lot of issues. And this is a good bill because it highlights an issue of, in court, you'd think that one of the things that you'd get is due process of, okay, they presented their evidence, let me present mine. Well, it doesn't happen a lot in courts. A lot of courts can actually deny you the right to even present certain evidence. Cody Taylor here, he had his ex is saying, hey, the kid never wants to see me, never wants to see him, and he's got videos of the kid all day long, playing happy, she loves her dad, crying, going to hug her dad. And that judge wouldn't, allow it to be heard. And part of that was because of only allowing one side in a custody evaluation. So it's important that in family court, whether it's someone who is being accused of not paying the child support, and yet they have proof that they paid it, they're getting sent to jail because there's a flaw in the due process of when mistakes are made, the courts being able to correct them and not send people to jail or hold them in contempt. A lot of people don't realize up to 6 months in jail, you don't even have a right to a trial, which you'd think, because that's in the Constitution, you'd have a right to a jury trial of your peers. That actually the same judge who might not like you might throw you in jail because they don't like you and you don't have a jury trial where you can present your side of things. If you get a custody evaluator who just doesn't like you, or maybe they got paid more from the other side than by you, they might, God forbid, say something that you're a bad father, when a different custody evaluator would say, no, the facts show otherwise. Again, not that everyone's like this. In fact, the vast majority of people in family law wants to help kids, but there are some bad actors, and that's why it is important to reform everything from child support contempt issues all the way over to custody evaluators. So thank you for your time, and y'all have got a tough job. Thanks.
Thank you, Mr. Bellows. Any question, members? Okay, thank you. That's all we have registered. Is there anyone else who wishes to testify on or for or against the bill on 891? If not, the chair recognizes Representative Spiller to close on HB 891.
Thank you, Mr. Chairman. I just want to say I appreciate all the support tonight. And with that, I'm not going to delay any further. I appreciate y'all spending all your evening taking time on this bill, but I appreciate it very much. I'd appreciate your favorable consideration. I close.
Thank you.
Thank you.
Committee substitute is withdrawn at this time, and if there's no objection, HB 891 will be left pending. All right, this time the chair lays out HB 2246. Huh? Oh, go ahead, recognize.
Thank you.
Good. Oh, Smithy, okay, Representative Smithy.
Thank you, Mr. Chairman. House Bill 2246 is a bill with some recommendations from the Office of Attorney General on suits affecting the parental-child relationship. It's a bit of an omnibus bill because it covers a couple of different codes. The first part of the bill is in the Estates Code and is designed to close a loophole when a parent has a judgment for child support. It basically prohibits an assignment or bars an assignment of a inherited property interest in order to evade the child support obligation. Just trying to close that loophole. The rest of the bill deals with the family code, and it's pretty much just cleanup of some of the things that have changed. For example, it adds email addresses to the existing list of contact information that parents must disclose and share with one another. It attempts to increase the efficiency in the use of child support liens, eliminates a statutory barrier that prevents the use of online notarization. Right now, the statute prohibits online notarization. This would reverse that and allow it to complete a judicial waiver of service. It clarifies how courts should treat child support arrears and how they should properly apply certain types of federal lump sum disability payments to child support obligations. And it removes several statutory loopholes that can be utilized, once again, by delinquent obligors to avoid paying child support. So I think it's pretty much just a cleanup bill to clean up some things that are outstanding. And I think we have somebody from the AG's office here to explain that if necessary.
Okay, thank you. Members, are any questions? All right, at this time we'll start our public testimony, and the chair calls. Okay. We'll call our resource witness at this time. Who is that? Joel Rogers.
Good evening. My name is Joel Rogers. I'm Associate Deputy Attorney General for Child Support Legal Services, and I'm here to testify on the bill as a resource witness. I think Chairman Smithy laid out pretty much what this bill does. It does quite a few things that our agency thinks that will assist in the collection of both current and overdue child support in Texas, and enhance our agency's ability to assist individuals who seek child support services from the state. I'll be happy to answer any questions.
Thank you. Members, any questions? No, thank you for being here.
Thank you.
Okay, at this time, the chair calls up Cody Taylor. I think he left once, twice, three times, okay. Chair calls. Okay, show Cody Taylor as against the bill, but he did not testify. Chair calls up Jeffrey Morgan. Mr. Morgan, you've been here all day, you know the drill, right? Full name, who you represent, on for against the bill.
Yes. Name's Jeffrey Morgan. I am representing myself. I stand against this bill. I don't think my testimony is going to be very detailed right now, quite honestly. There's a lot that I don't have all my notes with me, and I apologize for that. I was trying to go through 18 bills yesterday, had to get up at 4 in the morning and just didn't have everything with me. Some of the issues that I would have with it are probably issues that are more systemic than what you can address within this bill. I think that the child support system needs to be looked at. This might be something a little bit different, and maybe if it's outside the scope, that's fine, but I would love to see a detailed accounting of the subledgers of the Title 4D collections where it's being, and the expenditures. Because to me, the way that I see some of this stuff, looking at the reports that the Attorney General's office put out, I see very general categories, And I'd love to see the subcategories. I believe that I overheard a conversation that some of the money is going to pay raises for judges and stuff like that. And I'm like, okay, is that really the purpose of collecting this Title 4D money? I realize this is outside of what you're talking about here. I think that some of the issues with regard to the obligor, obligee, in many instances, the obligor never even wanted to be in a position where he or she is. And I think you're going to have to reform the divorce code in order to make that actually more fair and equitable and just. But that's beyond the scope of this bill right now.
All right, thank you, Mr. Morgan, for your testimony. Members, any questions? Thank you.
Thank you.
Chair calls up Taryn Champagne.
He left.
He left already, okay. Okay, we're showing them against the bill and not testifying. This time, Chair calls up Carlos Damon.
He left as well.
He left. We'll show him as neutral and not testifying. Anton Golikov, not here. Show him as neutral, not testifying. This time, Chair calls Brandon Johnson. Full name, who you represent on for against the bill.
Brandon Johnson, represent myself. I'm neutral, registered neutral. I'll remain that way because it doesn't really matter, except that it does what I explained earlier. This is strictly for the Title 40 agency housed within the Attorney General's office to maximize federal profits. That's what this bill is for. Now, the stuff about the email, of course not. But the substance of this bill is to confiscate resources, and not for the only reason that the Title 40 agency is involved is because it has to go into account, to the account that they can say, hey, we took the money from this man or woman. Maybe it could be a woman, but typically the man. We're going to take it from this person, put it in that account so that we can send it off to the feds, and then they'll compensate us for doing that. That's what this bill does. And, as I've said before, it's a form of slavery when, somebody can't inherit some property from a relative without the state getting their greedy hands on it. And I think it's a travesty. You want their paycheck. And here's another area I'm going to agree with the Family Law Foundation on. It is about the money. It's 100% about the money. It's about the state balancing its budget on broken homes and mandated fathers. And this bill is just another nail in that coffin. So whether I'm for or against it, it's going to happen.
Thank you for your testimony. Any questions? Representative Cook?
You aware of the state surplus?
Oh, yeah, from all the property tax that's gone up and everything like that. Look, when I say, okay.
I thought you said it was from the Attorney General balance in the budget.
Oh, yeah, well, I mean, they're taking, I'm using that as a talking point.
I'll withdraw my question.
Yeah, that's fine.
All right, thank you. This time, is there anybody else? That's all of our testimony. Anybody else that wants to testify on or for against the bill? Okay. If not, the chair recognizes Representative Smithy to close on HB 2246.
Thank you, Mr. Chairman. And, I do need to thank, there were several people who signed up against, several of them came by to see us and talk about the bill, and I appreciate that a lot. Most of the objections, though, were to the system. They were systematic objections to the system that's in place. Really, none of the only possible objection, most of this is just cleanup, and it really doesn't substantively impact the program. I think the most substantive one is the one I discussed first, which was the prohibition of an assignment of an inherited interest to evade a judgment of the court. And that's pretty much the law in regard to any judgment where you transfer property in order to avoid a lawful judgment. And particularly in the child support area, that's an area that we need the enforcement ability to do that. So I think most of the objections are just to the system in general. They want to make changes, and I understand that, but that's not what this bill is designed to do. It's just designed to kind of clean up the legislation that we have.
All right, thank you, Representative Smithy. If there's no objection, HB 2246 will be left pending. This time the chair lays out HB 2247. The chair offers up a committee substitute HB 2247, and the chair recognizes Representative Smithy to explain the bill.
Thank you, Mr. Chairman. 2247 is also what I would phrase as a cleanup bill. I don't do a whole lot that's real substantive in this committee because I don't have a great understanding, but I think I would characterize it as a cleanup on Title 4D and some of the issues that go along with respect to child support or the Title 4D agency services. This bill is are some biennial recommendations from the OAG. It does several things. First, it expands a court's ability to require unemployed or underemployed child support obligors to participate in local employment-related assistance programs, including those available to obligors in Title 4D cases. It conforms existing procedures for the filing of Title 4D child support liens to the procedures for releasing those liens. It maintains judicial efficiencies and flexibilities that were allowed for during the COVID-19 pandemic by continuing to allow Title 4D associate judges the option to continue to conduct certain types of cases of child support hearings using remote communication technology such as video or teleconferencing. It creates an administrative process for the Title D agency to efficiently address child support reviews and modifications for incarcerated individuals, which the agency is required to do pursuant to recent changes in federal regulations. And finally, it allows the Title D agency to utilize the administrative child support review process to address and resolve disputes or facilitate agreements related to child support arrear balances in cases where the obligation ended more than 10 years ago. And so with that, Mr. Chairman, I think there's, once again, a resource witness to answer any specific questions.
Thank you, Representative Smithy. Let's see, any questions for Representative Smithy? Not hearing any. We'll proceed down the public testimony. Right now, the chair calls Lisa Marshall. Says you are testifying neutrally on the bill on behalf of fighting homelessness.
Yes, sir. Hi, my name is Lisa Marshall. Thank you so much, Chairman Dutton. And I'm actually, I signed in neutral because it's such a big, large bill, but I'm opposing Section 12.
But you are neutral on the bill.
I don't know how to do that with the thing.
Well, if you're neutral on the bill, that's what we need to know.
I'm opposing Section 12.
Okay, so do you want us to change it from neutral to opposing?
Well, I think that the remainder of the bill is fine, but the Section 12 is the one that I'm opposing.
Well, that's in the bill, though.
Excuse me?
Section 12 is in the bill.
Right. Okay.
So if you'll be against the bill.
Okay, that's
Okay.
fine. I'll just, yeah.
Do you want it?
Yes, sir.
Can we change it for you to against?
Please.
Okay, let's change it. We'll change it with your permission to against the bill.
The entire bill.
Yes. Yes. And, okay, now you may proceed.
Okay.
Well, let's see, we'll get it changed here in a minute. Can we change it? Okay. Okay, thank you. Go right ahead. I'm
Okay.
sorry.
Thank you again, Chairman Dutton and the members of the committee left. As of 2019, the state of Texas surpassed California in child support debt with over $18 billion in arrears and has maintained this leading position ever since. Texas continues to burden taxpayers, impoverished mothers and children, and incarcerated men and women with the $18 billion in debt. Of the 1.1 million cases owing $18 billion, 70% of the obligors owing earn less than $10,000 a year. Undeniably, the moral obligation of child support is a very complex system, one that seems impossible for previously incarcerated people who reenter society with child support arrears debt and extreme barriers to overcome. The goal of child support is crucial, and the state of Texas collected and distributed $4.5 billion in 2021. Many of these successful collections are paid by higher paying orders, contributing to the $85 million we make in incentives for enforcement. But this enforcement measures comes with a considerable cost on incarcerated individuals with no means to pay, impoverished mothers and children, and taxpayers. There is a vast difference between a deadbeat dad and a dead broke dad. Yet the enforcement measures that defines the label is the same. Unfortunately, the enforcement guidelines for child support arrears do not distinguish between those who refuse to pay and those who cannot pay. As a result, many incarcerated individuals are released with significant debt, suspended license, and poor credit scores, making it difficult to secure employment and housing and leading to a vicious cycle of recidivism. This debt and the ability to secure employment and housing lead them back into the criminal justice system, creating rising Medicaid expenses to cover poor women and children and contributing to our growing homeless population. This situation is particularly troubling because children need both parents financially and emotionally support to thrive. Currently, 1 in 4 children in the United States live without a father at home, and these children are more likely to experience poverty, drug abuse, and incarceration. House Bill 2247, as written, will not allow men and women who were previously incarcerated or incarcerated to support their children. Their tax-paying family members will pay the incarcerated amount proposed, and they will still face a new order once released with no means to pay and enforcement measures to drive them back into prison. HB 2247 should be amended to set the order to 0 if they are incarcerated for more than 180 days. 21 other states have some form of suspension while incarcerated, as well as once they return to society to achieve employment and housing. Oklahoma and Louisiana already have passed legislation with $0 while incarcerated. In Mississippi, a Republican senator passed both legislative houses this session on a $0 order and a 60-day forbearance after their sentence to get back on their feet, and is now at the governor's desk for signature. Oklahoma's forbearance is 90 days after incarceration with a 0, and Louisiana is 60 days forbearance after the 0 order. To address this problem, I urge you not to pass HB 2247 Section 12 as written, which would continue to burden incarcerated individuals and their families with child support debts they cannot afford to pay. Instead, I recommend amending the bill to set the child support order to 0. If any individual is incarcerated for more than 180 days and does not have the income to pay. Please consider the data and evidence supporting this proposed change and support a fair and equitable child support system that benefits all children, parents, and taxpayers.
Thank you.
Thank you for your attention.
Thank you for your testimony. Let me see if there are any questions. I don't believe so. But you are against the bill, right? And it's
I'm just against that one section, but I guess I have to say I'm against that section asks for a $15. It starts at $15, so it's an incarcerated rate, and they don't have $15 to pay. That's the only thing I'm changing, is change it from the incarcerated rate to 0.
Yeah.
And Mr. Chairman, she did come by and visit with us.
Yes, sir.
Okay.
I did.
We appreciate it.
With everyone on the committee.
Yes.
Okay.
Everyone on the committee. And in the packet, I have both the Oklahoma bill, the Louisiana bill. I didn't include Mississippi because it's at the governor's desk.
Okay. All right. Thank you. Thank you for your testimony. Thank you for helping out too. And let me encourage you to continue to visit with the author of the bill. All right. Thank you. Chair calls
Do the next person.
Cody Taylor.
He's gone, I think.
I think he's absent. He was against the bill, 2247, and will be shown as not testifying. James Reed, who is testifying for Dallas Leadership Foundation, and he's neutral on the bill.
Well, now that I'm finding out that I have to be against it because I see that.
So are you against it?
Yes, in that little section.
All right. Well, you do. Do you mind?
No. He needs to stay neutral because he's only opposed to one section. He's not opposed to the whole bill. He just needs to stay neutral because he's not opposed altogether on the bill.
Sweetheart, that is not true.
That is.
You have to know if you're against the bill, if you're against any part of the bill, you have to be against the whole bill.
Okay.
All right? Okay, so we'll show you against the bill. And can we change it?
Yes.
Do we have your permission to change?
Yes.
Okay. All right, thank you. All right, please proceed.
All right. Thank you, Chairman, and all those who are on the committee. I see every day our organization that we work with. I work in the prison every day, helping these men transition back from prison to community, and we also provide transitional housing for these men as well once they get back into the community. And one of the very things that I see a whole lot two things is that while they're incarcerated, these men don't even have access to getting the documentation that is needed for them to file a motion for them to be able to get their reductions if needed be. And then the other part of it is from the post side of things is that when they reach to our transitional home, oftentimes they wind up getting a great job and wanting to be able to pay for their child support payments, but then they get 2 paychecks and then the garnishes get waged and they wind up bringing home $100 versus $800. And so one of the very things that I find even still with that is it causes a large amount of recidivism. That people keep recycling within the system because they seem they can't, number one, understand how to navigate their way to be able to get those modifications being done. And so I would like to see that those things are accessed inside on the pre-side. Those things are accessed on the pre-side that they can begin to start filing the necessary things that they need to file and to understand the language that has to do with taking care of those things as well. And then proceeding once they get out to making sure that they can be able to go back before the courts and get it modified. So again, I really think that what Ms. Marshall, Lisa was talking about was simply is that, we need to be able to make sure that we're in position to help educate our men and women about this issue. And so I strongly agree that we need to also minimize that to 0 as well, as opposed to what's been opposed. Thank you.
All right. Mr. Reed, have you gone by to talk to the author of the bill?
No.
Okay. Let me encourage you to do that.
Yes, sir.
So that there may be some possible resolution to your point of view and his point of view also, okay?
Yes, sir.
All right.
Thank you.
Any further questions?
Well, let me ask you, are you kind of aligned with Ms. Marshall?
Yes.
Okay, we can work through her, I think. You can, if it's inconvenient for you to contact us. We'll be, I understand what you're saying, and we'll certainly try to deal with that.
Okay.
Okay, thank you.
Thank you.
And thanks for what you do.
Thank you.
All right. All right. Thank you. Any other witness? Chair calls Jeffrey Morgan. Any others? Okay, why don't you give me all of them?
My name is Jeffrey Morgan. I am testifying against the bill. I'm testifying on my own behalf, and I am testifying on behalf of the bill. There's somebody who just said that we're filibustering all bills. That's not what we're doing. We're testifying out of our convictions and out of things that we've seen. This bill is 27 pages that I saw, Representative Smithy, so there seems to be like a lot of stuff in there. I was wondering, I mean, there was a lot about the Title IV D agency and stuff like that. If we have any questions about all of that, do we go to you? Do we go to somebody else? Or how do we, because there was a lot of detail about the Title IV D agency, honestly.
I would say if you have any questions, let us know. We'll be glad.
Yeah, I just was wondering, because I just thought that your knowledge of the Title IV D agency was impressive. And Representative Cook, you just mentioned to Brandon Johnson that there is a big surplus in the state of Texas, $45 billion surplus. So I think that in light of that, I mean, maybe we ought to look at some other measures that would actually reduce, make child support a little bit more fair. And Chairman Dutton, that's why I'm actually in support of what you talked about with the shared income model. Because right now we have a single payer model in Texas. And so I think that some of these things would help to address some of these issues. What I see with this bill is there's a couple of things here. Number one, it basically targets one class of person. It's the obligor. And that's why if you had a shared income model, that perhaps there would not be just one obligor. Both parents are important. A shared income model would maybe make it a little bit more fair. And then I see in the part, section A 154.017, employment services related orders for unemployed and underemployed obligors. To me, when I read that, it kind of strikes me as almost an indentured servitude. Well, you're not making enough. Make some more money. We're going to get you a better job. You know, you're underemployed, and we're going to make you do something instead of like perhaps working in a job that you would have been working otherwise. It almost seems, like I said, indentured servitude, which I also refer to as slavery. There was one black sheriff that I talked with a while ago about this whole issue with child support and stuff like that. And what he told me was this. He said, Jeff, in my community, and he was referring to the black community. I don't mean anything racial by this at all, but he just said, in my community, we have mothers who teach mothers to make sure that when you have children, you have 3 different, and what he called baby daddies, because each person gets to provide 20%, 20%, 20%, total of 60% versus 30% if one person had 3 children. I think that, you know, as you mentioned, Representative Smithy, and I appreciate all the stuff that I've read about you, your biography and everything, but I do think that there are some issues here that are more systemic, and that we really should be looking at this. But I am against this bill, especially because of the indentured servitude that I see, that I read in here, and also the 2 classes of people. Anyway, I'm sorry. I guess I'm done. Anyway,
You are?
okay.
All
Glad
right.
to take any questions.
All right, thank you. Any questions? Not hearing any, thank you for being here.
Thank you so much. I
Chair
appreciate it.
calls Taryn Champagne.
He's gone.
He was neutral on the bill, and he will be shown as not testifying. Carlos Damon?
He's gone.
Demand? He is not here, but will be shown as against the bill, but not testifying. And Anton Golokop is not here. He will be shown as not testifying, but neutral on the bill. Brandon Johnson.
Yes, sir. Brandon Johnson, testifying on behalf of myself, and I would like to go ahead and change from being neutral to against the bill.
Okay, so we have your permission to show that you were against the bill, against 2247, and not neutral. Is that right?
Yes, sir.
Okay, thank you.
That's correct. And once again, I'll agree with the Family Law Foundation. It is about the money to the state, money to the attorneys, money to the mother, and then possibly to the child. Now, I'm not against, and I'm actually for a man taking care of his children. But when he's mandated absent via called a non-custodial pay rent, then I'm against it. And I've been doing it for years, and we're reaping what you've you are reaping what we've sown. I mean, it's devastation. All these kids growing up without fathers. And this is evidence of an oppressive system. When these bills, I mean, and I'll take him on good faith, Mr. Smithy's closing loopholes. But y'all have steadily closed loopholes since 1995, tightening the noose around the necks of fathers for state profits. And I'll grant you that now that we're getting raped by property taxes, it's just you're adding to the slush fund. Okay? So let's call it a slush fund instead of a balance in the budget, if that helps. So anything that has to do with this Title 40 agency, all they're doing is making money. It is a profit-generated system. It's a federal program. Even, if I'm not mistaken, Amy Bresnan has even said that it's federal law. Take it up with them.
Must be true.
Do what?
Must be true.
I guess. I mean, she's an expert testimony on a lot of times. But regardless, you can look within our Texas Family Code, and it's verbatim. You're passing federal law directly into the state statutes. So it's real easy to track down and verify what she says. Thank you.
All right. Any questions of this witness? Not hearing any. Thank you. Anybody want to hear from Joel Rogers, who is here with the agency? You want to hear from him?
One question.
All right. Chair calls Joel Rogers.
Mr. Rogers, you've heard the testimony of two people.
Wait a minute. Let him identify.
I'm Joel Rogers, Associate Deputy AG for Child Support Legal Services, and I'm here testifying on the bill as a resource.
All right. Representing Cook.
Thank you, Mr. Chairman. You've heard the testimony earlier from two witnesses with regard to, I believe it was Section 12, if I remember correctly. Do you have any response to that?
Yeah, I do. I respectfully think that they may have misunderstand the purpose of that. There's a federal requirement that all states' Title 40 agencies have to either notify someone, when we find out that someone's incarcerated for over 180 days, we either have to notify them within 15 days of their right to request a review, or we have to just initiate the review and adjustment of the child support. What this would allow us to do is create an administrative process for us to go in and we have, for instance, let me give you some statistics. Right now in our caseload, we have 10,168 cases involving 8,762 incarcerated obligors where there's still an active current child support obligation. These obligations are currently accruing a total of over $3 million each month, resulting in an average of almost $350 being added to the child support arrears balance of these incarcerated parents every month. What we're trying to do is create an expedited administrative process to go in and lower those child support amounts to what they need to be. Now, in many cases, if the person incarcerated has no income, the child support would be set at zero. That's what we're trying to do. And in some cases, if they do have resources where they can pay, we'd set it at the amount based upon the child support guidelines. So we're trying to help those folks by creating a way that they can easily do that. If you take those cases to court, we've been taking them to court. But the problem is the custodial parent typically has no incentive to show up because it's going to lower the child support. And the non-custodial parent obviously can't participate. So we get to court and a lot of judges say, well, there's no one here to testify. You know, what am I supposed to do? So this will give us, we could still do it through judicial ways, but this will also allow us an administrative process to do that. So we're trying to get the child support obligations set. In many cases, they're going to end up being set at zero because most incarcerated folks don't have any income. Right. So that I just want to correct that misimpression of the bill. The bill does say that once they're released, we have to actually then go in and modify the child support. And of course, if they don't have any income when they get out, we're going to wait until they probably have a job to do that. But because if you say, we believe setting child support at the amount based upon actual income. So I think we're trying to actually address the problem that the two earlier folks testified.
Yeah, I think you are too.
Can you visit with them after offline?
Yeah, I'll be glad to do that.
Thank you. Thank you, Mr. Chairman.
Yeah, and so if we don't do that, then their child support obligation, the inmate's obligation would stay where it is. And I mean, they'd get further and further behind.
Yeah, $350 on average in our caseload a month is accruing on those cases because we haven't been able to get them into court fast enough to get those lowered. So this will take those out of the court system and put it in a more expedited administrative process.
Right.
I'll be glad to visit with them if they want to visit
All right.
with me.
Thank you for doing that, Joel. Any further questions? Not hearing any. Thank you. Is there anyone else here who would like to testify for, on, or against House Bill 2247? Chair hears none and recognizes the author of the close.
Well, Mr. Chairman, we've been here a long time, so we'll try to work and see if these, what problems there are and deal with those, if there are any. And with that, I would close.
Well, thank you. It's the chair's intent to leave House Bill 2240. Well, wait a minute. First, the chair withdraws the committee's substitute, House Bill 2247, and leaves House Bill 2247 as a matter of pending business before the full committee without objection. Chair hears none. So ordered. The chair lays out House Bill 980 by Representative Cook and recognizes the author.
Thank you, Mr. Chairman. Members, appreciate the time you've spent today here with me going through all these bills. And this, I have two bills tonight. This one should be very quick, and I'll try to make the layout as short as possible. But in order to promote the free exchange of information in collaborative law cases, certain privileges were set forth in the Texas Family Code in Section 15.114. Unfortunately, we've had some unintended consequences with regard to a legal dispute in a civil case between business partners. In 2020, this provision was relied upon by plaintiffs in a civil case between business partners to subpoena and compel production of both spouses' entire collaborative law files. So obviously, this created a situation where the parties to a collaborative law case expected to have privacy. Instead, their entire file was made public because of this unintended consequence. And so this bill, House Bill 980, simply corrects that by removing Section 115.115A7D. And I'd be glad to answer any questions. Otherwise,
All right.
opportunity to close when appropriate.
Any questions of Representative Cook, members? Not hearing any, we'll grant you the right to close.
Thank you, sir.
And we'll proceed with the public testimony. Chair calls Sherry Evans.
Good evening, Chairman Dutton. Members of the committee, my name is Sherry Evans. I am a board-certified family law attorney from Houston. I have been board-certified since 1998. I'm here on behalf of the Family Law Foundation. We are in support of this bill, and we graciously thank Representative Cook for bringing this bill in on our behalf. As Representative Cook pointed out, this is simply a means to solve a loophole in the system. When parties going through a divorce elect to go through the collaborative process, one of the key components for them is confidentiality. And that's the way that the collaborative law bill was drafted in its original intent. What happened is, quite frankly, in 2011, there was an attempt to make our collaborative bill consistent with the Uniform Law Commission's Uniform Collaborative Law Bill. In doing that, what it did was create certain exceptions to the confidentiality, and one of those exceptions created the loophole that Representative Cook pointed out. All we're simply asking is that that exception be removed so that it can remain the integrity and the confidentiality that the collaborative law process was intended.
All right, thank you. Ms. Evans, are there any questions of Ms. Evans, members? Not hearing any, thank you.
Thank you.
Thank you for being here. Chair calls Cody Taylor. He is not here. He will be shown as he was against House Bill 980. Jeffrey Morgan.
My name is Jeffrey Morgan. I'm testifying on this bill. I'm testifying for myself. And I know that this is talking about the collaborative family law process. And one question I wanted to ask is, I understand Representative Cook owns a law firm that deals with issues of family law and everything. And I was wondering if Article 3, Section 22 of the Texas Constitution applies, where it talks about disclosure of personal or private interest in a measure or bill not to vote. A member who has a personal or private interest in any measure or bill proposed or pending before the legislature shall disclose the fact of the House of which he is a member and shall not vote thereon. Just a question that I've had because I've seen different people come and present bills that seems to me like possibly might benefit their private practice afterwards. Looking at this whole thing with collaborative family law, I realize this is one of the big, people, let's have collaborative family law. It's supposed to be better and easier and cheaper and stuff like that. And yet when I've watched people online talk about the reasonable, necessary, and customary attorney fees, in one case I saw one attorney say her fees were $350 an hour. The opposing counsel said his fees were $650 an hour. Both of them were reasonable, necessary, and customary. And I think that, to me, that almost seems, when you listen to how they set their rates, they do surveys, they talk amongst each other, it seems like it's a little bit of price fixing at the same time. I don't know if there's any type of guidelines that perhaps could be, I realize it's a little bit outside of the scope of this bill here, but that we could make sure that the attorney fees are actually not what I think are price gouging or price fixing activities, and we would be a little bit more accessible to normal people. I thought to myself, it was costing me about $600 to be here today because of the course of the whole week, and yet that's one billable hour for a number of attorneys. Just a couple of things to put out there. Anyway, with regard to the, I don't know if it addresses this here or not, but I know at one time I've talked with people that were involved in the mediation process, and according to her, and I have an audio of that conversation in that QR code right there, it seemed like that was another way to almost to break people. Anyway, so I said I'm testifying on the bill. I think there are positive aspects with collaborative family law. You want to have some type of agreement, some form for agreement, but I've also want to make sure that the people are not being plundered at the same time by the legal system, by the attorneys, and so on. Anyway, that's it.
All right, thank you, Mr. Morgan. Are there any questions? Not hearing any. Thank you again for your testimony.
Thank you.
Chair calls Carlos Damon. He is not here. He will be shown as not testifying, but neutral on House Bill 980. Anton Golub, not here. He will be shown as not testifying, but neutral on House Bill 980. Brandon Johnson.
Brandon Johnson, testifying on behalf of myself. I would just request that you change it from on the bill to for the bill.
Yeah, so we have your permission, Mr. Johnson, to show you, you are currently shown as neutral, but we have your permission to show it as for the bill?
Yes, sir.
For House Bill 980. Okay, we will show you that way. Thank you. You may proceed.
I don't have any testimony. Thank you.
Okay. All right. Thank you. Is there anyone else here who would like to testify for, on, or against House Bill 980? Not hearing any, the chair recognizes Representative Cook to close.
Thank you, Mr. Chairman. With regard to the question about a conflict of interest, I would like to point out that one of Mr. Morgan's sidekicks filed a TEC complaint last session, and it was ruled that there was no conflict of interest. And I guess it just depends upon whether they like the bill or not as to whether or not it's a conflict. But anyway, anyway,
you can't.
Other than that, Mr. Chairman, I believe the questions with regard to the bill have been laid out. Any questions, I'll be glad to answer. Otherwise, I close.
All right. Any further questions of Representative Cook members? Not hearing any. It's the chair's intent to leave House Bill 980 as a matter of pending business before the committee, Without objection, chair hears none. So ordered. Chair lays out House Bill 3072 by Cook and recognizes the author.
Thank you, Mr. Chairman. I appreciate the opportunity to lay out this bill. This bill in relation to a couple of important cases. The first case is Troxel v. Granville. This was a case that was heard in 2000 by the United States Supreme Court. And in that case, the U.S. Supreme Court ruled that the government may not infringe on the fundamental right of parents to make child-rearing decisions because a state judge believes a better decision can be made. Later, 20 years later, in 2020, the Supreme Court of Texas ruled in CJC that, quote, in a contested case, regardless of whether the case is an original case in which conservatorship or possession of a child is at issue or a motion to modify, as long as the court finds that the parent is a fit parent, then the court cannot grant a non-parent request for conservatorship or possession of a child. This bill addresses that issue specifically. In Section 1 of the bill, I know there's been different questions throughout today about best interest in an attempt to define what best interest is. Well, this isn't, in my opinion, this is a directive with regard to the best interest of a child. Currently in Section 153.002A of the Texas Family Code, the best interest of the child shall always be the primary consideration of the court in determining the issues of conservatorship and possession of access to the child. This bill adds paragraph B and states that in a suit between a parent and a non-parent, it is a rebuttable presumption that, number one, a parent acts in the best interest of the parent's child, and number two, it is in the best interest of a child to be in the care, custody, and control of a parent. In Section 2 of the bill, it talks about a modification suit, which is in Chapter 156 of the Texas Family Code. It says in a suit for modification between a parent and a non-parent, the presumption under Section 153.002B, which is what I just talked about, is rebutted with respect to the parent who is a party to the suit if the order subject to modification, number one, expressly states that the presumption was rebutted with respect to the parents, number two, appoints a non-parent as conservator of the child, number three, subject to subsection D, that grants a non-parent possession of or access to the child, or number four is the result of the parent's voluntary relinquishment of the actual care, control, or possession of the child to a non-parent. The presumption, as stated in paragraph D, the presumption under Section 153.002B that I just stated may be rebutted as provided by subsection C3 only in a suit for modification in which a non-parent seeks possession of or access to the child. The presumption may not be rebutted as provided by that subdivision in a suit for modification in which a non-parent seeks conservatorship of the child. So basically what this is saying is that the parents have a parental preference, is often referred to as a parental preference. A parent has a fundamental constitutional right to parent their child. We can all agree upon that. And only in very limited certain circumstances can that be where a non-parent can overcome the presumption that a parent has a fundamental constitutional right to parent their child. And Mr. Chairman, I don't believe we laid out the committee substitute, and if you could,
I don't have it.
You don't have it. It was sent in. I do have copies here, but I believe that there's a change that needs to be made anyway. So I'll be glad to provide copies to the committee if you'd like.
To the clerk, yeah.
But we do intend to make a small change.
If you'll just get it to the clerk, she'll get it to make sure.
Yeah, it's in the Dropbox. I think all the members have it, but I do
Okay.
have copies here as well.
All right, I just didn't have it. I don't have it. Okay. All right, okay, we'll get it done.
And so I believe that accurately summarizes what House Bill 3072 does. I'll be glad to answer any questions if any member has questions.
Okay, any questions of Representative Cook, members? I don't believe so.
Thank you, Mr. Chairman. I'd like an opportunity to close when appropriate.
We will give you the opportunity to close. Chair, we will start the public testimony, and the chair calls Steve Bresnan with the Texas Family Law Foundation for the bill.
Thank you, Mr. Chairman. My name is Steve Bresnan here on behalf of the Texas Family Law Foundation in support of the bill. Representative Cook did a great job of explaining what the bill's trying to accomplish here. I want to thank him in particular for the leadership role that he played on this. And also a person who's not here to hear it, Representative James Frank, also worked with us on this. And I think you're going to hear from my friend Andrew Brown from the Texas Public Policy Foundation, who was instrumental in reaching this agreement. Although this bill looks simple, it's taken some time to get the language right. And as Representative Cook said, there's a piece that still needs adjusting. It didn't come back from the Legislative Council exactly the way it was sent over there. The important part of that we've been working on here is to make it clear that in a modification, that parent carries forward the constitutional presumption, and if provided that it hasn't been rebutted in a previous proceeding. And so how to tell that in the modification proceeding, looking back, is the subject matter of that second part of the bill, and that's the part we're working to hone. Be happy to answer any questions.
Any questions of Mr. President? Members? Not hearing any, Steve. You answered all of them.
Thank you, Mr. Chairman.
Thank you. Chair calls Judge Hayes, who is for the bill.
Good evening, members of the committee. My name is Carl Hayes. I am here to testify in favor of HB 3072, and I am testifying in my individual capacity. As previously mentioned, I am the judge of the family court in Hays County, Texas, and I am in favor of HB 3072. It primarily sets forth the law, as Representative Cook correctly noted, the law from the United States Supreme Court and the Texas Supreme Court as far as the rights between a parent and a non-parent. One thing that's really important about what Representative Cook is trying to do is to clarify, and it's an issue that's not completely clear in most of the states in the United States, and it's not clear in Texas yet exactly when when a parent maintains their parental presumption, their right as a fit parent in a modification action. And so this latter part of the bill that Representative Cook laid out is going to clarify that so that it's then clear in a modification action exactly when a person still can assert their right as a fit parent or when they've lost that as a result of a prior proceeding. So I think that's really significant because it gives guidance to the trial courts about how to apply the fit parent presumption in a modification case, which right now is not really clear from the appellate court opinions. And I thank Representative Cook for his leadership on this issue, and I'll yield to any questions.
All right. Any questions for Judge Hayes, members? Not hearing any. Thank you, Judge Hayes, for being here. Chair calls Jeremy Newman.
Chairman, members, my name is Jeremy Newman. I'm the Vice President of Policy for the Family Freedom Project, and we do parental rights related work in the courts and in the legislature, and this is actually an issue that we've worked on for quite some time, especially in the last few years in the appellate courts. And I agree with a lot of things the prior witnesses said about the issue here that we have in the jurisprudence in Texas is that you have these constitutional rules. I don't know if I said originally that I'm neutral on the bill.
Neutral on the bill.
Yes.
Thank you.
So the issue we have in the jurisprudence currently is that we have constitutional rules that the courts have set forth for how the presumption is supposed to work for parents, but a lot of local judges and local attorneys who don't necessarily know what those are. And so unless a parent can afford to get to the appellate courts, they often can't vindicate their rights on these issues. So the first section of the bill lays out in fairly clear terms what that constitutional presumption is. The reason that we're neutral on the bill instead of supportive is because the second section of the bill, in our reading and so far in the reading of the judges and attorneys that I've talked to in the last few days, is that there are just some mechanical problems with how it would work that would actually undermine the first section of the bill. And the high-level view of that is that in Section C, it lays out the fact that this presumption applies in the modification suit. But then in the prongs beneath that, it describes circumstances in which that can be overcome, but it doesn't specify what parties or what types of remedies necessarily each of these parties is coming in under. And so you end up in a situation where once one party gets in the first suit for one type of remedy, then a lot of other parties can get in the modification suit for a lot of other types of remedies. And I don't think that's necessarily the intention, but the mechanics of it kind of make that the result. And so it actually leads to constitutional problems that I think undermine the first section of the bill. So the goal of the second section is to clarify the circumstances under which you don't have to overcome the presumption repeatedly if one party overcame it originally on the same type of issue. The mechanical problems that I mentioned before, I think, lead to a result where, for example, you can have a parent who's a sole managing conservator or joint managing conservator of their child, but they're deemed to have lost the constitutional presumption, and that's actually kind of directly contrary to what the court stated in CJC. So I think all of the original language of the bill actually almost completely addressed those issues, and so it's really the committee sub that we have mostly the concerns about.
All right. Any questions of Mr. Newman, members? Not hearing any. Thank you for being here.
Thank you.
Chair calls Andrew Brown. Testifying for the Texas Public Policy Foundation for the bill.
Good evening, Chair Dutton, members of the committee. My name is Andrew Brown. I oversee child and family policy with the Texas Public Policy Foundation. Thank you for the opportunity to testify in support of House Bill 3072. First of all, I want to thank Representative Cook for bringing this bill and bringing together parties who often have very different views on some of these topics. Especially want to thank the Family Law Foundation for their collaboration with us to make sure that we could put together a bill that, as best as possible, balances the interests and concerns of multiple parties that are very active in this space. As was mentioned, there were a few drafting errors with the committee sub that still need to be worked out, which we are working with Representative Cook and his team to fix, so y'all can vote on a clean bill that reflects the agreement of the parties. As was mentioned, Section 153.002 of the Texas Family Code states that the best interest of the child shall always be the primary consideration of the court in determining issues of conservatorship, possession of, and access to the child. And despite the obvious importance of the best interest standard, Texas Code does not provide a clear definition for the standard and little guidance on how to apply it. Although case law and certain sections of the code provide some guidance on the factors that may be considered, the lack of a baseline definition has contributed to inconsistency and unpredictability in its application. House Bill 3072 is intended to address this deficiency in state law. Both the United States and Texas constitutions recognize that the relationship between a parent and child is a fundamental right deserving of expansive constitutional protections. In a consistent line of cases dating back for 100 years, the U.S. Supreme Court has held that the state may not interfere with the parent-child relationship absent a compelling interest, and accordingly it is well settled that the Constitution requires courts to presume that parents are fit and that it is in the best interest of the child to be raised by their parents. The Texas Supreme Court made this abundantly clear in its recent landmark decision in In Re CJC, holding that when applying the best interest standard, quote, a court must apply the presumption that a fit parent, not the court, determines the best interest of the child. Section 1 of House Bill 3072 codifies this long history of jurisprudence by requiring courts to start any best interest analysis from the presumption that it is in the best interest of the child to be in the care, custody, and control of his or her parent. This may seem like a minor change to code, given that the case law is abundantly clear on this topic, but it will have a transformational impact on, again, bringing that consistency to the application of this standard in our courts. Section 2 of the bill, as you've heard, was really an attempt to balance that first section with those circumstances in which courts may find sufficient evidence to overcome the parental presumption and outline the limited circumstances, again, taken from case law, in which the presumption is deemed to have been overcome to provide that clarity to the courts. Thank you very much for the opportunity to testify in support of this bill, and again, thank you, Representative Cook, for working with us on this.
Thank you, Mr. Brown. Any questions of this witness, members? Not hearing any, thank you. Chair calls Cecilia Wood, testifying against House Bill 3072.
Good evening. My name is Cecilia Wood. I'm
still Cecilia Wood. And today, on this bill, I'm testifying only on behalf of myself. I'm a board-certified attorney, and I've been practicing for 37 years. I have tried to work with some of the people that have been working on language. When my opinion has been asked, I've given it to whoever wanted to hear it.
And you're against the bill?
I'm against the bill.
Thank you.
But I want to start off by saying I really like Section 1. I agree with everyone who said that Section 1 states the current state of the law, both federal law and state law, and I really like that bill. I also agree with the people that have said we don't know how to overcome this what standard overcomes this fit parent presumption. CJC said, if you're named as a managing conservator of your child, you retain your fit parent presumption going into a modification. But they also said, as Justice Lehrman said in her concurring opinion, but she said what we haven't answered is how, under what circumstances can we overcome the presumption? I don't think that this Section 2 meets the standard that it needs to be high enough to overcome that presumption. So for one thing, it says if somebody else was named as a conservator. That's not what CJC says. If you have a non-parent and a parent named as a conservator, joint managing conservators, the fit parent doesn't lose that fit parent presumption. But the other thing CJC said that was so important and really embodies this 100 years worth of jurisprudence that has served our nation so well is that any time there is a best interest inquiry, you always have to lay the fit parent presumption on top of that. And so a modification requires that. You have to prove best interest, then you prove one of the other prongs, kind of like backwards from a termination, but you got to prove both of them. And so where the statutes and the legislature in the past has had statutes where we're overcoming this fit parent presumption, they have used the significant impairment to the child's emotional or physical health or emotional development. And these standards focus not on the child, but the standards currently in this bill focus on the other people and what interests they might have. So I would like to keep working on this. I would really like to see, because I think it will help judges, practitioners, everyone across the state. I just don't think that this standard meets the constitutional scrutiny of a compelling state interest, and then it's narrowly tailored enough. So thank you for what we do have here, Representative Cook, and if you want to talk further, I'm more than welcome to do that.
All right, thank you. Thank
All
you,
right,
Ms.
thank
Wood.
you.
Let me see if there are any questions. Are there any questions of Ms. Wood? I think Representative Cook has a question.
Thank you, Mr. Chairman. So are you suggesting that the parental presumption applies time and time again in a modification? Is that what I heard you say?
I do, as long as you're named, as long as the parent continues to be named as a managing conservator. So if they were not named in the previous order, in the most recent order as a managing conservator, then they would have lost it in that. They could regain it, right? Because the judge could name him as a managing conservator, like in CDC.
Well, that's two different things. I mean, you could regain it, but you don't.
Right,
You wouldn't apply the parental presumption.
But if you were named as a PC and the possessory conservator in the last order, then yes, I think you've lost it. But let's use the grandparent access statute, for example. So in the grandparent access statute, they've had to prove a significant impairment. Now, if either party comes back in, that's a specific significant impairment if they can't have this one piece of relief that they've asked for. But that doesn't apply to the live-in boyfriend. That doesn't apply to, because remember, and I don't mean to be talking, I know you know this, but not everybody does what we do. Not to get back into court on a modification, whether it's the parent or the non-parent, they have to prove one of these three prongs again. So they have to prove the child's turned 12 and wants to, live with somebody else. But what really we're going to come in on possession and access, there's been a material and substantial change. If that's the case, then there's a new decision to be made, and the fit parent is entitled to have that presumption that his decision is the right best interest for the child. Now, again, it might be overcome, but if we're going to put in the standard, I think we need to put in significant impairment. And I know, because we've worked on this before, I know, and I don't have the wealthiest clients in the world. Nobody wants to be dragged into court over and over on the same issue. But modification statute itself has if you bring a frivolous modification, there's consequences for that. And that can be brought up in the very beginning, that this is frivolous. And so I don't think that we're going to see repeat litigation. We know those people, but in the general population, we're not going to see repeat litigation if we're going to adopt a standard, which I'm not opposed to. Let's adopt the one that's across the board that focuses on the child, significant impairment to the child. So, maybe this grandparents have visitation, say on certain holidays, right? And then they want to change it. And what the days they want to change it to interferes with something that the child has to do for school, or interferes with, what they've been doing with the parent, and so maybe grandparents, it's still important for the grandparents to have that court-ordered visitation, but not necessarily the days they want. And that's what we see in a lot of these cases anyway. It's not that people are that people are trying to hoard their children, or it's that they are not doing what the other person wants in the way they want it. So I'd love to just see significant impairment put in here. We can stop all the appeals that have been going up, and we would have, plus with significant impairment, like I said, focuses on the child, and we've got how much case law and what that means.
Do you agree that CJC makes a distinction between parental preference with regard to custody versus possession?
I don't, and this is why. Because that was what was before the court, okay, and that's why. So yes, and definitely on statutory, they said you don't have any rights on.
So how many times in your practice have you advised a client to? Probably unfair question, but I don't want to get specifically into the advice.
If I can't answer,
what I'm asking is haven't you had situations where you've had a situation where it was better to have your client agree to possession and not make sure there's no custodial rights so that the parental preference is not overcome? Do you agree with what I'm saying? So basically.
No, not necessarily, because I understand this parental presumption to attach to all decisions a parent makes, and I have. When you look at, some of the cases that are
CJC definitely makes a distinction. So I mean, you may disagree, but I think you or somebody else testified that what Justice Lerman thought or didn't think, and so let's just say that she makes a distinction between overcoming parental preference with regard to custody versus overcoming with possession. That's why we made the specific provision in paragraph D.
But first of all, the majority opinion doesn't. What it does is it makes a distinction between the relief you can get under the statute, as opposed to the relief you can get, the relief of parents or the protection of parents entitled to under the Constitution.
Yeah. We'll agree to disagree, because I think that I feel strongly that you can overcome one without overcoming the other.
So, well, okay.
Thank you.
Any further questions of Ms. Woods? Not hearing it. Thank you, Ms. Wood, for being here. Chair calls Brandon Johnson.
Brandon Johnson, represent myself. There's a lot of reference to the case. I believe CJC was the Chris Clay case.
Neutral
I'm going to remain neutral on it. There's some good things and bad things in here, or well, not necessarily bad, but just it could be better. With that case, I believe it was up in Denton. You had the mom die, and then the grandparents and the boyfriend, live-in boyfriend, kind of stepped in and tried to take the custody. And then he spent $200,000 fighting that case, if I'm not mistaken. But it, of course, we come back to, if we look at the verbiage here, it says a parent. And, I know there's some, little bit of gymnastics with the legalese and not talking about both parents. So, in a situation where two parents are getting a divorce, and I know that this is aimed at a modification, but as a previous speaker talked about, and I'm going to have to look into that. I don't know that much about it, but she was saying the fit presumption still applies to possessory conservator or whatnot. I don't know all the specifics on that, but you have it in here, a parent. Okay, we know that 92, 93% of the time in Texas, the father's mandated absent. And then that creates a second-class parent named visitor.
Would you rather?
Chair recognizes Representative Cook.
I'm sorry, Mr. Chairman.
Oh, is it? Go ahead.
He has a question.
Okay. Yes, sir.
Yeah, so are you saying that if the mother of your child had her parental preference overcome, you would like yours to be overcome as well?
Yes, I mean, for a fit, willing, and able, okay, a fit, willing, and able parent.
That's why I did say, it doesn't say either. Like, you don't want one parent's bad decisions to negatively impact the other parent, correct? That's why it says a parent. It doesn't say like if parent.
But we're not starting from that. Well, and correct me if I'm wrong. Look, maybe you're helping clarify the bill for me. If we're starting from a fit, willing, and able parent.
That's what it says.
Well, then I'm gonna. If that's what it is, a parent. And look, I'll switch my vote if that's what it is, a parent. And you're saying that that protection's in there.
The letter A means a singular.
But once again, that's where the ambiguity comes in, okay? Because unless you add in that there could be equal custody, then you're still creating two classes of parents.
This bill does not have any.
Well, no, I get it, but the point's being made here that
most cases have joint management conservators, and so if one parent's parental preference is overcome, that doesn't automatically overcome it for the other parent. That's why you would not want it to say both. You would not want the bad decisions of one parent to negatively impact the other parent.
And I agree with that. I mean, I agree with that if you have an outside person coming in, and that's why I specify. It's new.
Basically, think of it this way: parent versus non-parent.
And I understand that's what you're talking about, but that leads into the whole deal that you're any other time. Here's the thing. It would be very easy to amend this that both parents independently, because that's what I think you're saying, both parents independently have that fit, willing, and able presumption.
That's what it says.
Well, I'm going to have to think about it. I'm not going to change it. I'll follow up with you on that. No, it doesn't matter. It's not going to matter one way or another. So, yeah, I shouldn't give any credence to what I say when I know it may not be heated on your side. But I'm saying a compelling state interest narrowly tailored. That's where I'll wrap it up, is what's happening in another proceeding where it is just the two parents and you're having.
Everything to do with that situation.
Okay.
It only deals with. I'm just telling you. It only deals when you parent versus non-parent. That's what this.
I get it, but it could be very easily modified to say, look, both parents are, because y'all amend these bills all the time. It'd be very easy to say that both parents are presumed fit, willing, and able, and independently. Thank you.
All right. All right, thank you. Chair calls Anton Golakov, who's not here. He will be shown as neutral on House Bill 3072, but not testifying. Chair calls Julia Hatcher.
Hi, Chairman Dutton, committee members. My name's Julia Hatcher. I'm an attorney in Galveston. I'm also president of the Texas Association of Family Defense Attorneys, which is a statewide organization of attorneys representing parents and children in CPS cases. We had to register against this bill, and that is because it changed from the original version. We would have been in favor of the original bill, but once we got wind of the committee substitute, we had to register against it, and I'll tell you why. First off, I wanted to start with an answer to your question on conservatorship versus access, and this is a quote that I'll read from In Re CJC. Thus, we read any best interest. I'm sorry.
What page are you on?
It's pages 819 through 820. Thus, we read any best interest determination in which the court weighs a fit parent's rights against a claim to conservatorship or access by a non-parent to include a presumption that a fit parent acts in his or her child's best interest. And then they also say, also on page 819, when non-parents seek court-ordered custody of a child subject to an existing order under which one or both fit parents were appointed managing conservators, that parent or parents retain the presumption that protects their fundamental right to determine their child's best interests. And this bill, as it's written, would really negatively impact CPS cases because we have a lot of cases where grandparents will intervene or they may have placement of the children and not intervene, probably because they can't afford it in most cases. And CPS cases are unlike any other family law case. In a CPS case, CPS can determine to award or ask for custody to be given to a party that has not actually legally intervened in the case. You don't see that anywhere else, but it happens in CPS land. So we have a lot of non-parents that are in these cases, and if we get to the end of the road we're heading up to trial, and the parent wants to avoid a trial, wants to avoid a possible termination, maybe just wants to keep family peace, whatever, get rid of CPS because we go to mediation before we go to trial. We'll often, tell our clients to, agree to JMC with the grandparent, agree to JMC with your sister. Just do something to get rid of CPS and get out of this termination suit. So, then our parent's going to lose their fit parent presumption when they want to come back and modify that order to get full custody and get rid of, whoever they needed to get rid of CPS. That's not really fair to them. We don't want to have to, we're afraid that this is going to cause us to not recommend that. It's going to clog all the trial dockets in CPS courts because now we're all going to have to push them to trial. And then another thing is if a grandparent is a possessory conservator, because the way that I read this in 2 appoints a non-parent as a conservator, that includes a possessory conservator.
All right,
So you have
Ms. Wood, would you wrap it up for us, please?
Ms. Hatcher?
I mean, Ms. Hatcher.
Yes.
Ms. Wood.
So that's our main concern is we don't want our parents losing their fit parent presumption because we agree to get out of a CPS case.
All right, thank you. Representative Cook.
Yeah, so that's the question I was asking Ms. Wood earlier that she didn't want to answer for me, but that's the exact situation. That's where this committee substitute started, and the conversation was that if you did not name them a conservator, you only gave them possession, you would not be overcoming the parental preference with regard to custody. That's why you may do that, but I would never do that. I agreed in order to save the expense of going to trial, I have many times agreed to let my client agree to possession only, but no conservatorship rights.
But that gives them, anybody who has possession is a possessory conservator.
Absolutely not. If you name them,
well, I guess your courts where you practice are different than the courts where I practice.
Well, obviously, because you said you don't have to be an intervener or something in your court. So yeah, I don't practice like that. But I mean, in CPS cases, if I want to intervene into a case, I file an intervention into a CPS case. So yes, that's correct. But yeah, just because you have possession does not mean you're a possessory conservator. If you have possessory conservator rights, then yes, you are a conservator. But just because you have possession So you're saying if a grandparent is granted access in the family code that they're a possessory conservator?
That's what I've seen in my last 25 years of practice.
Well, that's definitely not the case. You can have grandparent access without being a conservator, 100%.
Well, then what is a possessory conservator?
It depends on what you put in the order. There's a laundry list of rights and duties that you can give to possessory conservators or joint managed conservators. But if you're not listed as a conservator, then you're not a conservator. That's what I mean. That's why there's a distinction in the family code with regard to grandparent access. That is only possession. That's not conservatorship.
Okay, but there's still a distinction between managing conservatorship and possessory conservatorship, right?
Of course. The only time possessory conservatorship comes in is if you have a sole managing conservator. If you have a sole managing conservator, then the other parent is going to be a possessory conservator. The presumption that was changed in 1995 that the gentleman talked about earlier made it where there was a presumption that both parents are to be named joint managing conservators. So most of the orders that we work on, they're JMCs. But so, yes, and I've talked about wanting to, and maybe that's something that the chairman could recommend during the interim, is we do need to clean up the family code, and that's something that I've suggested. And it's a situation where you shouldn't be calling possessory conservator in a standard possession order when you're in fact, you're a joint managing conservator, but it refers to the non-custodial parent as a possessory conservator, even though they're really a joint managing conservator. So that's a discussion for another day, but thank you for your testimony.
Okay, thank you.
All right. Any further question to Ms. Hatcher, members? I don't think so, Ms. Hatcher. Thank you for being here. Chair calls Carlos Damon.
He's not here.
He's not here. He will be shown as against House Bill 3072, but not testifying. Taryn Champagne is not here. He will be shown as for House Bill 3072, but not testifying. Chair calls Jeffrey Morgan, who is against House Bill 3072 and testifying for himself.
Yes, my name is Jeffrey Morgan. I am testifying for myself. I think I'm going to change my position to neutral. So you have my permission to change the position.
We do? Okay, we will show you as on rather than against.
Okay.
And you're neutral, okay?
Gotcha. The biggest issue that I have, and of course this is not addressed right here, I was listening to Representative Cook, and by the way, Representative Cook, I have no idea when you talked about my sidekick, I have no idea who that would be. I don't have sidekicks, and I don't think anybody considers me to be a sidekick either, for the record. But anyway, the thing that always concerns me, and it's not addressed right here, but everyone talks about the best interest of the child. CJC talked about the best interest of the child. Justice Lehrman talked about the best interest of the child. Nowhere is it defined. It's mentioned over 140 times, directly or indirectly, in the family code. It's not mentioned. And last session, when I said something, Representative Ramos said, well, the court's given us the definition. Well, I talked with the Supreme Court Justice, and they said, well, the legislature hasn't given us a definition, so they're kind of using the Hawley factors, and they're a non-exhaustive list. And, when you look at somebody who really understands what the needs of children are and what you would call the best interests are beyond being a paycheck, beyond giving them physical things. You have things like providing order for their lives, protection and guidance, autonomy, equality, freedom of opinion and expression, truth, honor and respect, respectful love, responsibility, security, and he names a whole bunch of stuff that we never talk about when we talk about the best interest of the child. Once again, to me, my definition of the best interest of the child differs from everybody else's. At least I have a definition. My definition would be that the best interest of the child is to be reared in an intact family with his or her natural mother and father, period. That would be the majority of it. And but right now, and I'm glad, Representative Cook, that you said that you're going to maybe look at cleaning up the family code, because I think that's where some of our problems come in. We see things that look like they're contradictory, not exactly sure what they're meaning. And I'm also glad, too, that you clarified that Article 3, Section 22 inquiry that somebody made, because from the way that I would read the Constitution, I would say, whoa, I can't do this. And I say that as a financial institution examiner. If I have an account at a financial institution, I cannot examine that account because I have to recuse myself. Even if I'm dealing with crypto, I cannot examine any banks with crypto. So that's my standard that I use. I'm glad that you clarified that for me. But anyway, like I said, I'm going to be on the bill right now. I'll be neutral. I do know the whole situation with CJC. I've interviewed them, been to their house, everything else. And by the way, they wanted to have grandparents in the household. It was more the backdoor approach through the mother's fiance that kind of messed things up. But anyway, I think grandparents are important and parents are important.
All right, any further questions of Mr. Morgan, members? Not hearing any, thank you, Mr. Morgan.
Scroll down. Scroll, yeah, keep going. Go all the way down. David,
Okay, Chair calls David Bello.
David Bello, I'm representing myself, and I am for the bill. I'm really glad to hear everyone talk about that the best interest of the child is, it's presumed to be in the best interest of the child to be under the care and control of their parents, that the parents are presumed to know what's best and to take care of their children better than, it's presumed that they know how to take care of their children best, and that the child should have a loving relationship with both of them as long as both parents are fit. And that the state should only be able to take away that right, take away that presumption after going through hurdles to prove that the parent is not fit. But the parent should start off as coming in as being presumed fit. And that's really important, not only for this bill, because you do have a lot of situations where maybe parents are fighting and they want to start a new life with someone else and don't want the mom or the dad involved, and so they go try to fight over in court to remove one of the parents out of the child's lives, so that the step parent could become the father or the mother, and so it's very important that as long as both parents are fit, willing, and able, they should have equal access, and presumed that they act in the best interest of the child, unless proven otherwise or shown otherwise. And look, there are some deadbeat moms, deadbeat dads. It happens. There's some bad parents, but I think that's the exception, not the rule. I think for the most part, most parents are fit and willing, and that should be presumed that they act in the best interest of the child. I'm actually adopting my stepson Monday, actually, and I'm all about equal parenting. I'm all about equal rights, but I'm in a situation where I have been the child's father for the last 7 years, and the child's father didn't want to be involved at all. So in that situation, even in that situation, I believe there should be hurdles before I could adopt my soon-to-be son, because parents should be presumed to act in the best interest, whether or not it's in a step parent situation like this, or when two parents in a non-step parent situation go to court, they should be presumed to be starting off as equal parenting. And so you can't say parents are presumed equal, that they should be start off as knowing what's best for their children in this situation, and then others say that they're not. So parents should start off as presumption of knowing what's best for their children and having the equal rights. Thank you very much.
All right, thank you. Let's see if there are any questions, Mr. Bello.
Yes, sir.
I don't believe so. Thank you for your testimony, and
Thanks.
thank you for being here. Chair calls Arnold Leanne.
Hi, my name is Arnold Ian. I represent myself, and for this bill, I'm neutral. There's several reasons I can explain that. And I thanks for Mr. Cook for submit this bill. It's very good. I have done a lot of reading on CJC case too, so I'm not coming here to talk about nonsense or doing any karaoke here. And this bill, the way I look at that, the CJC case is the Supreme Court has established a rule says, as long as there's fit parents, nobody else can override the fit parents to define what is the best child interest, what's the best interest of the child. unless you can prove that parent is unfit one. So basically, it gives back the right back to the fit parents, right? We all know unfit parents, they cannot make a decent decision, but for fit parents, this rule basically give everything back. No judge, no child custody evaluator, no anybody, no CPS can determine what is the best interest of a child unless you can prove the child is the parent is unfit, which is very good. And put that into bill, I like it. And there are also some situation I would like to. The reason I'm neutral is there are also some situation I know some case, and there's parents, father drugs, went to jail, mother has custody, then mother passed away due to the illness. Grandparents took over, and I don't know for this bill situation, what is the situation for the grandparents when they were actually doing the possession of the children and doing the custody for the children, and that they can make a better choice actually than the parents. That parents definitely is unfit in jail, but at this situation, how this bill gonna affect them in the future when they decide what's the best interest of the child in the future. So this is the reason I wasn't so sure about it, the whole outcome of that, but I just want to present this question to the committee, and then you guys can, much smarter than me, can think about that.
All right, thank you. That's a broad assumption. But
there always some situation, right, happens, but it happens. I saw that in the real life. But
let me see if there are any questions. No questions. Thank you, Mr. Yan, for being here. Is there anyone else here who would like to testify for, on, or against House Bill 3072? Chair hears none and recognizes its author to close. Representative Cook.
Mr. Chairman, thanks for the opportunity to lay out House Bill 3072 and the substitute as discussed. We will be providing you with another committee substitute prior to requesting a vote. I appreciate the opportunity to lay it out tonight. Thank you.
All right. It's the chair's intent to leave House Bill 3072 as a matter of pending business before the committee without objection. Chair hears none, so ordered. Yeah. Don't everybody leave. We got one more bill. No. I'm only kidding.
All right. All right, the chair lays out HB 3446. The chair recognizes Chairman Dutton to explain the bill.
Thank you, Mr. Chairman. I think I'll do it from right here. In 1973, this legislature created a situation where indefinite child support can be ordered for a child who has a mental or physical disability that requires substantial care and personal supervision. However, the statute did not contain any definitions on standard to make the determination of whether to award indefinite child support. There have been several cases to Court of Appeals cases that have issued opinions that interpret the statute differently depending on where now the law is based on where you live. In 2018, Texas Supreme Court Justice Eva Guzman wrote a published opinion in a case in which he posed several questions regarding the meaning and applicability of the statute. This House Bill 83446 provides uniform standards to define the term disability and require medical proof of a disability. That's essentially what the bill does, and so I'll be prepared to answer any questions.
All right, thank you, Chairman Dutton. Members, are there any questions? Okay, we'll go to public testimony. At this time, the chair calls Ramiro Canales. Sir, make sure to give us your name, who you're representing, on for or against the bill.
Mr. Chairman, thank you. It's been a long day, long night. My name is Ramiro Canales. I'm an attorney here in Austin, Texas. I'm representing myself, and I support this bill. I'm also a former Assistant Attorney General for Texas Attorney Generals John Cornyn and Greg Abbott. While working with them, I handled very difficult cases for the state of Texas. I I'm here to support Chairman Dutton's bill because the case that he cited, in which Justice Guzman issued a decision, involved my brother. I have litigated this statute for the last 7 years, representing him for free, asking a simple question: what does this law mean and require? I took this case twice to the Texas Supreme Court, and they could not interpret this law. The last time I took it to the U.S. Supreme Court, asking whether this statute is unconstitutional. The Supreme Court asked General Paxton to provide a response. General Paxton told the U.S. Supreme Court not to take the case in order to give you, the legislature, the opportunity to construe the statute. Chairman Dutton's bill provides standards and definitions that is going to provide clarity throughout the state of Texas. It is true, for the last several years, approximately, I think 7 or 9 courts of appeals have interpreted this statute differently. Parents are treated differently depending where they live in the state of Texas. There are no standards, there are no definitions. Currently, this law does not require any evidence, any medical evidence or any other type of evidence to make a determination of whether to award indefinite adult child support. And currently, as the statute currently stands, there is no way to end it. If an adult child gets educated, gets a job, is able to live on their own, you cannot end this. There are no standards, there are no definitions. This bill is intended to answer the questions that Justice Guzman posed back in 2018. And there were approximately 10 to 13 questions asking, what is this bill, what does this law do and require? So this bill does provide clarity, does provide standards, does provide definitions, and I applaud the chairman for taking the initiative and the leadership to address this issue that is affecting hundreds or even thousands of parents statewide, because no one really knows what this law requires and demands of parents. I'll be glad to answer any questions.
Thank you, Mr. Canales. Members, are there any questions for the witness? Representative Cook?
Mr. Gonzalez, was there, as far as the court's majority opinion, was there anything different with regard to that's noteworthy?
There was no majority opinion. This was an interesting case. It was denied with an opinion. Okay. And as you know, Representative Cook is an attorney. Most cases at the Texas Supreme Court, they are denied with no opinion. Right. Justice Guzman wrote an opinion asking these questions as to what this statute requires and demands. And as you know, Justice Guzman is a brilliant constitutionalist who knows family law very well. And when she wrote this opinion, I was actually very surprised because she asked these questions. And the first question that she asked is, what is the disability in the statute? It has no definition. And what I discovered through litigating this for my brother for free for 7 years, most families don't have the benefit of having a brother who's going to litigate a case for 7 years all the way to the U.S. Supreme Court. What I discovered is that different courts of appeals have different standards, and it's very arbitrary and subjective. But it's a very potent law. Once indefinite adult child support is ordered, there is no way to end it. Even though you get a job, you're able to sustain yourself, there are no standards to end it, the indefinite adult child support.
Thank you. Members, any other questions? Thank you, Mr. Canales.
Thank you.
Thank you.
Chair calls up Brandon Johnson. Full name, who you represent, on, for, against.
Yes, sir. Brandon Johnson, represent myself, and I'd like to change my stance from neutral to for the bill.
Okay, so we're going to change it. We have your approval for. Is that correct?
Yes, sir.
Okay. Go ahead.
I was here for the long haul, so I just want to say this is not something I even knew was going on. I didn't really even read the bill, but based on the prior testimony, and I'm sure Chairman Dutton has looked it over and wrote it properly, because this kind of goes back and ties in what I've said all day, is I'm sure it's ambiguous. And the state's making a lot of money off of it. And so you know what, and it's a difficult situation. If the kid is permanently disabled, that parent is gonna, if the parent's taking care of the kid after he's 18, well, they need the help. But if he's got a job and can get along in society, that's a lot of burden on a man to have. So I'm for the bill. Thank you.
All right. Thank you, Mr. Jones. Any questions? Nope. Chair calls Anton Golikov. I know he's not here. Carlos Damon. I know he's not here. Chair calls Jeffrey Morgan. Full name, who you represent, on for, against.
I'm glad I made it too. I only had 2 hours sleep last night trying to read all of these things and driving down. But thank you so much for letting me be here. Even when I've disagreed with people, I appreciate the fact that we've been able to have the conversation. My name's Jeffrey Morgan. I am representing myself. I'm also representing my wife and my stepson, and I'm testifying on the bill. As you can see by the couple of pictures that are down here, and I had a lot more, but I just kept it to one. My stepson is 32 years old in a couple of days, but today's my anniversary with my wife, and then in 3 days is his birthday. He's 32 years old. He was born dead, resuscitated, and he has massive medical needs. And as anybody who knows, who's had situations like this, it creates a lot of stress in a marriage. The father and the mother, they ended up in a divorce, various reasons. And earlier it was last year actually, I said, why don't you have your husband come over, because this is still his son and everything. And I mean, it took a couple of years to do that, and we were able to get that to work out and everything. But the way that things are right now, if you have some of these issues with his needs, you would have to be a multimillionaire several times over to take care of his medical needs. And the interesting thing is the reason he's able to stay with us right now is because there was a lawsuit against the state of Texas. Because there are different programs for people like this with the state of Texas, but the state of Texas decided they did not want to put him on it because they didn't check one box exactly right. And there were people that came out and evaluated him, and they didn't do a good job evaluating him. So anyway, there was a lawsuit, and now he is supported in part by the state of Texas. But I want to address it from that issue, because I think that if there are these programs out there that are available to the handicapped community and to the special needs community, and trust me, that community is a different community than what you're used to. It's not the normal same thing. It's a whole different community. And you see parents, like, what do we do? They're burdened. And sometimes it creates divorce, sometimes it brings families together. But the whole thing with the resources, how do we care for our kids? Can we get a break? Instead of 24 hours having to watch our child like this, can we get a break? The state of Texas has resources, but the interesting thing was that she was told basically to institutionalize Matt, put him in an institution. The doctor said, well, if he goes in an institution, he'll be dead within 2 months. And now, like I said, he's 32 years old. Quite amazing that he's lived this long. He doesn't communicate. He cannot eat except through a feeding tube. He can't speak. He does communicate non-verbally, and yet he's a blessing. And I think that we sometimes forget that people with special needs can be a blessing and can teach us to be blessings to other people too. But with regard to some of these services, I would say this, that maybe Chairman Dutton, you ought to look at a couple of things with regard to the state's responsibilities as well, or the programs that are available. People don't know how to apply for the programs. There's a 14-year waiting list. You have people with disability rights that are trying to do various things, and they run into roadblock after roadblock after roadblock. My wife right now is on long-term disability, in part because of all of the stuff that she's faced with the state. Misdiagnosing disabilities. It's just way too difficult. I think I'll close right here, but all I can say is that, the indefinite child support, I would much rather the father be involved with his son than to have this to be something. I provide primary insurance. He provides secondary insurance. There's 2 other insurances as well. There's a flop back and forth and everything. But how are we going to create families, strong families, and communities in the state of Texas?
Thank you, Mr. Morgan. Appreciate your testimony. Members, any questions? No? Thank you.
Thank you so much.
Chair calls Cody Taylor. I know he's not here. He registered him against. Chair calls David Bello.
David Bello, representing myself, and I am in favor of this bill. Thank you, Chairman Dutton, for filing it and recognizing that there are some issues in Texas law with whether it's adult child support or regular child support. There, y'all have heard a lot of testimony. A lot of it is coming from a place of hurt. So a lot of these people that are coming up here today, they're hurt by the system and they're lashing out. And and even though it's easy sometimes to say, well, I don't like the way that person testified. At the end of the day, we've got to rise above that and say, you know what is the underlying issues? You've got, in situations like this, you do have situations where you could have fraud. There's no definition of what a disability is. You could have people that are being told they've got to pay something unfair for something that's not even necessary because, look, we all watch TV. I've seen lots of shows where a child was actually, the mother or father actually said the child was disabled in order to get a bunch of state services or GoFundMe money from people. So, it's important whether it's this situation or in general child support situations, it's important for the law to say, look, we want to support children and we want to support people with disabilities, but we can't do it in a way that's unfair or unreasonable or unconstitutional. We've got to really look at, this really opens up the door to showing that there's a need to look at child support as a whole, not just here in this situation, but in general. And I know Representative or Speaker Phelan has called year after year for child support to be evaluated. Most other states do a shared income type model where they look at the needs of the child, they look at the incomes of the parents. That's fair, that's reasonable. In fact, Texas is one of the only 2 states that doesn't do that. So this is a great bill. It shows an issue that also is part of a wider problem in family law, which is better defining taking care of children, and yet we don't want someone who's taking care of the children to not have a house and not be able to feed their other 4 kids because there's some unreasonable ruling or ambiguity of how much is needed and what's needed. So thank you for this bill on reforming, better defining support for children. And thank you very much.
Thank you, Mr. Bello, for your testimony. Any questions? None?
Can we go home?
Do you have another one? Nope. All right. Is there anyone else who wishes to testify on or for or against HB 3446? Hearing none. Are we sure? Oh, no. I'll stop there. If not, the chair recognizes Chairman Dutton to close on HB 3446.
And I close, Mr. Chairman.
That's nice. If there's no objection, HB 3446 will be left pending.
All right.
All right.
Thank you, Mr. Chair. Members, we're going to have a formal meeting on the House floor at my desk tomorrow upon adjournment. So just be prepared for that. We'll try to do it as quickly as possible.
Voting out.
You did what?
My PIFs committee is also voting out.
On the
Okay.
House floor.
Upon adjournment.
On the floor,
Not on the floor, in the eggs.
Ag Museum? Okay, well, we'll try to be quick. So,
Or I'll just see if I can do it on the Ag Museum for her.
okay, all right. We may look and see if we can do it, go in the Ag Museum, so that way you'll be there for both. But
And you
just know
special-
that we'll have a formal meeting upon adjournment, okay? If there are no further business for the Committee on Juvenile Justice and Family Issues, we will stand adjourned.
Thank you, Mr. Chairman. I've got another 4 hours.
Yeah.